Madam Clerk, you are live.
Mayor, we are live.
Thank you. Let me call this meeting to order. This is a special meeting of the governing body. We're beginning at 5:36 for a meeting scheduled for 5:30. According to our agenda, we will begin with the Pledge of Allegiance led by, we'll start with the Pledge of Allegiance led by Councilor Lindell, salute to the New Mexico flag led by Councilor Michael Garcia, and then an invocation from Councilor Castro. Please rise as you are able.
Salute to the flag, the state of New Mexico, the Zia symbol, perfect friendship amongst united cultures.
I just want to take a few moments to thank everyone for being here and to remember all of the wonderful contributions that workers do in our city. I would like to thank everyone for being such a wonderful part of our city, and a great thank you to Cesar Chavez, who is a great leader for all workers. Muchas gracias.
I don't know if there are other remembrances tonight. This is a special meeting, but there may well be. Councilor Cassett.
Thank you so much, Mr. Mayor. I do want to take a moment to remember Roxanne Varela, maiden name Ortega, who passed a couple days ago. Roxanne and I grew up together, went to high school together, graduated Santa Fe High together. She has to be one of the kindest, sweetest, most frightening people I had ever met. I actually was able to reconnect with her when I was campaigning the first time and ran into her on the street, and it was just such an incredible treat. And we spent the last 4 years saying how we need to get together, and of course we never did. So don't put that off. Mrs. Varela was also a wife of one of our Santa Fe firefighters. And we really know how much the family sacrifices as well for our first responders. So we often think about our first responders and how much they give to our city, but their families do too. And so she really did serve our city. We know our fire department is an extremely close-knit family, and they're all hurting. So I just want to give my condolences to her family, to her husband and her son, to all of her friends, and to anybody who really just had the honor of even spending a moment in her presence.
Thank you. Councilor Lindell.
Thank you, Mayor. I want to acknowledge that Friday, it'll be 2 years that our dear friend and former Mayor Javier Gonzalez was called to his greater rewards. For some of us, it feels like it was yesterday. And I always remember the last communication that I had with Javier was so typical Javier. He said, "You know what? Life's funny, but it has a way of working out." It didn't really work out the way that I had wished, and it's been painful without him, but he sure did leave us a lot. And how he dealt with people. I mean, there's hundreds of people in this town that felt like Javier was their best friend. He had that terrific ability to make people be seen and to know that they were important. So 2 years, keep him in your memory, and all good thoughts to his daughters, Cameron and Cadence. Thank you, Mayor.
Let's take a minute and think of the individuals just named and others in our community who are dealing with illness, dealing with challenges and struggling. Let's keep them in our thoughts. Let's do what we can to help them, and hope that our community enjoys peace and tranquility in the days and months ahead. Let's take a minute. Thank you, everybody. Please be seated. Madam Clerk, could you please call the roll for tonight's meeting?
Certainly, Mr. Mayor. Counselor Cassett,
Here.
Counselor Castro, Counselor Lee Garcia,
Here.
Counselor Michael Garcia,
Present.
Counselor Lindell, Counselor Romero Worth.
Here.
Mayor Weber,
Present.
Mayor you have a quorum.
Please note that two of our members are excused. Counselor Faulkner recused herself, and I believe Counselor Chavez did not participate in the first part of this hearing and so has excused herself from the second continuation. Can I get a motion to approve the agenda, please?
So moved.
Second.
Motion, there's a second. Is there discussion? All in favor, say aye. Opposed? Motion carries. Madam Clerk, just for the record, would you please read the item in front of us tonight?
Certainly, Mayor. This is a public hearing. It's for case number 2023-7297 APPL Old Peckles Trail. Appellants Annie Campbell, Mark Baker, Robert Josephs, Christopher Warland, Stephen Clark, Lucia Diekman, and Tom Hall, by and through their agent Bruce Throne, appeal the Planning Commission's decision to approve a final subdivision plat for a 25-lot residential subdivision located at 2200 Old Peckles Trail.
Thank you. Thank you, everybody, for attending tonight. I know you're all aware that this is a continuation of the hearing that we began at our last governing body meeting. Just to remind everybody here and listening, it's a quasi-judicial proceeding, which means that the governing body is hearing evidence and making a decision by applying the city's laws and ordinance to the evidence presented. We had a presentation at the last governing body meeting of the staff report and opening statements and testimony provided from each of the parties. And so tonight, following our procedures that are established under city resolution, we will begin with cross-examination that the appellant is allowed, followed by the, we'll start with the applicant cross-examining appellants and their witnesses, followed by appellants or their agent cross-examining the applicant's witnesses. Following that, the appellant may address questions to city staff, and then same is accorded to the applicant. My understanding after consulting with our staff is that tonight, city staff members are available for questions either in person or by Zoom, including our land use director, Jason Kloop, our assistant land use director, Heather Lamboy, planning manager, Maggie Moore, senior planner, Dan Escabel, who was delayed due to a family emergency, but will be available as early as much as possible. We will also have available our city engineer for land use, Dee Bein-Gessner, Office of Affordable Housing Director, Alexandra Ladd, and Fire, Geronimo Griego, and Leroy Pacheco on issues involving traffic and traffic engineering. If there's somebody that we've missed, we can try to see if we can reach that person who you would name and try to make them available by Zoom. So after the questions to the staff, the governing body will then receive sworn public testimony from those here and on Zoom with up to 2 minutes per speaker. And when that has been completed, the governing body members then are offered the opportunity to ask questions of the appellant or the applicant or staff or members of the general public who have testified under oath. And as we established at our last meeting, we're going to have as many rounds of questions from the governing body as the members wish, but we'd like to use 10 minutes per member so that we continue to move forward with everyone on the governing body having an equal opportunity to participate. When questions from the governing body have been completed, then we will offer time for staff to respond to any matters raised by the appellant or the applicant, following which the appellant and applicant may provide up to 10 minutes of a closing statement. After those closing statements, then the public hearing is closed and the governing body deliberations begin. After that, no more questions of witnesses will be permitted unless the governing body votes to reopen the public hearing, which is permissible. At the time when the governing body is deliberating, we'll follow the same 10-minute approach where there's many rounds as desired, but each member may use up to 10 minutes to either identify their position or further discuss the merits of the case. Once the governing body is ready to vote, then any member may move to do any of the following: grant the appeal and reverse the Planning Commission's approval of the final plat, deny the appeal and affirm the Planning Commission's decision to approve the final plat, or modify the Planning Commission's recommendation, its approval, and that those three options are in front of the governing body. Purpose of tonight's hearing is to give everyone an opportunity to present their evidence and to present the perspective and data that they wish to give to the governing body so that an informed decision can be made and a clear record can be presented. With that in mind, I ask the following. Please follow some basic rules in this part of the procedure where there will be questioning or cross-examination. Please follow our parliamentary procedure, address questions through me as the chair. It may seem cumbersome, but I think it will make sure that we have clarity and there is respect and decorum maintained for everybody in this hearing. Please keep your questions on topic. It's important that everyone have a chance to speak and that the evidence is relevant to tonight's decision. If I find that we are wandering afield or it is unclear what the line of questioning is designed to produce, I may ask for an explanation or a rephrasing of the question or encourage that we move on or not repeat the same question again and again. Please, to make it easy on those who are being asked questions, ask one question at a time. Let's break these things down into easy to answer questions so that the witnesses can respond and we get to the next question. Please be clear what you are asking about and that there are clear references. If you talk about the hearing, make sure we know what hearing we're talking about. If you're asking a question about a document, please reference where the document is located in the record as much and as precisely as you can. And as I said, let's not repeat the same question over and over. If a topic has been covered, please do move on. And please avoid on all sides arguing with witnesses. We're looking for answers, not for arguments. And so if you feel that you're asking a question and you're not getting a satisfactory answer, you may ask me to address that concern, and I'd be happy to do that. And witnesses, if you are asked a question, I would request that you provide a full answer, but try as much as possible to be concise. Some of the answers will always require background information, context, but just as the question should be focused, I ask that you make the answers focused as well. So with all of that, I would then request that we start tonight's hearing. And following our procedures, I will ask that the applicant has an opportunity to cross-examine the appellant or the appellant's witnesses, and I please request that you use what we all would consider a reasonable amount of time without undue redundancy.
Mr. Mayor,
Yes, Counselor.
a point of parliamentary inquiry. When you spoke about the governing body deliberations, can we get clarification in regards to the motion? Is that to be made after each individual governing body member has an opportunity to speak during deliberation and then a motion can be made, or a motion is made and then we each deliberate?
Great question, Counselor. Our standard procedure is we have discussion and deliberations, following which we then move on to a motion.
Okay, so we each have an opportunity to speak and then somebody can make a motion.
Correct.
Perfect. Thank you for clarifying, Mr.
Thank
Mayor.
you. Yes, sir, you have the floor. I'm not sure your mic is on.
Is that on now?
Yes, sir.
Mayor, for the record, Carl Summer, Post Office Box 2476, Santa Fe, New Mexico, 87504. I'm here on behalf of the applicant, and thus far, the only witness that the appellant has put on is Mr. Throne. I have no questions for Mr. Throne, but if there are other witnesses, we'd like the opportunity, if there are questions to be asked, to ask those questions.
Very good. Thank you, sir. The appellant now has an opportunity to cross-examine the applicant's witnesses. And again, I make the same request about taking a reasonable amount of time, getting your points across, but also avoid redundancy if you can.
Good evening, Mr. Mayor, members of the governing body. My name is Bruce Throne. I am one of the appellants, even though that wasn't indicated in your notice, and this was addressed in the January 31st hearing, but I'm also their authorized agent, and I will be questioning, cross-examining for the appellants this evening. Even though under the governing body's appeal procedures that are Exhibit A to the resolution, the mayor that you mentioned, state that the parties need to identify witnesses 10 days prior to the hearing, and the applicant did not identify anybody that did so. Mr. Summer did, under oath, testify at the January 31st hearing, address facts, including referring to a drawing, the lot open space and buildable area drawing that had been submitted by the applicant in support of the application. He also referred to the site plan that's in the packet that you've been provided with and handed out the enlargements of. So I would like to question Mr. Summer at this time under oath, and would help me. And by the way, thank you for providing, it looks like, a separate podium for this, and wasn't quite sure where you wanted questioner to be and the witness to be, so maybe you can tell me about that.
I'm sorry, I missed the last part of your sentence.
I just want to know if when I question Mr. Summer, we asked for a second podium here so that not only for efficient use of time for health reasons, and I previously informed the city attorney and city clerk that, I'm recovering from a cold as well. I don't want to expose anybody. So did you want the questioner at that podium or this podium? How did you want
I
to?
think you, as the person asking the questions, are fine where you are. And then going forward, individuals who are being asked the questions can stand at this additional podium and use that microphone.
Fine. So that I would ask to begin my cross-examination of Mr. Summer at this time regarding his testimony at the January 31st hearing.
I don't think that's quite on yet. Did you check it?
Another quick question, parliamentary inquiry, Mr. Mayor. Do both the appellant and the person testifying have to be sworn in?
The current individual has already been sworn and remains under oath.
Mr.
I think I think both.
Is this on now?
Yes, sir.
Mr. Mayor, I would state, for the record, at the last hearing, you have the opportunity to make an opening statement, and then you have the opportunity to testify. Mr. Throne acted in both his capacity to make a presentation and then launched into testimony. There was a little overlap, but whatever, doesn't matter. I got up and I indicated quite clearly I'm here in a representative capacity. I was giving an opening statement. My reference to facts were facts that are in your record. And when somebody gives an opening statement, they refer to the facts that either are going to be adduced at the hearing or that are already in the record. I was not testifying substantively. I was commenting on facts. So the idea that you can cross-examine the other party's lawyer in a hearing, in a quasi-judicial hearing, I would say is way out of the ordinary.
Let me,
Mr.
I mean-
Mayor, just if I may, Mr. Summer just said that he made it clear that he was testifying, or that he was not testifying, but only acting as a legal representative or lawyer of the applicant. I don't believe the record reflects that. I don't think he made that distinction. And we do think we have both a due process right and a right under this governing body's procedural rules to cross-examine because he addressed facts, including the documents that I referred to.
let me turn to the city attorney for some guidance. I hadn't anticipated this particular development, to be honest.
Mayor, Weber, councilors, I think it came up just before the hearing. We saw an email on this point. So our rules say that attorneys representing the party shall not be sworn to the extent they are representing their clients and not testifying as to facts. Attorneys testifying as to facts shall be sworn. City staff shall be sworn when testifying as a witness as to facts. And that's in section 8D1 of your appeal procedures. So I think if I know Mr. Throne would like to ask about facts, and Mr. Summer is saying that he does not intend to rely on, is what I'm hearing on. You've got independent bases for any facts that you mentioned.
Correct, Ms. Sherry, I referred to things that are in the record.
So, Mr. Ware, I think the city would not rely on anything from Mr. Summers' opening statement in our proposed findings of fact. And with that understanding, I'm not sure there would be a reason to require Mr. Summer to be under cross-examination. We're not going to use anything from his opening statement. He is now telling us that those are not facts that we should rely upon.
Correct, I was making an opening statement, so that term is generally understood.
Mr. Mayor, we would object to that for the record. And as I understand this advice that you got from the city attorney, that means that, and this is a de novo, as you know, a de novo appeal hearing that's addressed in Ms. Herman's staff report on January 26th that she submitted to you. And so as I understand it, that in this de novo hearing, then the applicant has provided no testimony. And I would also point out to you, and this was raised weeks ago between me and Mr. Summer and Ms. Minuk Herman, that, there's as you mentioned in the order of proceedings this evening, there's a point at which the members of the governing body get to ask questions of people who have testified at the hearing. And I, kind of anticipating this might happen, I discussed with Mr. Summer and in an email with Ms. Minuk Herman, and this is in one of the documents that I submitted in the record on January 31st, to say, look, if you're not going to put any witnesses on, you can't then come in the back door and then have the governing body ask questions of people for the applicant who haven't testified at the hearing. And because Mr. Summers said, well, we're going to make some people available to answer questions. And I brought that out. It's in the email. And so we want to make it really clear that if we're not going to be allowed to cross-examine any, then, even though members of this body may not like that, then we believe under your rules that You're not allowed to ask them questions either. And the reason I bring this up is because we just feel like this is kind of a gaming of this appeal procedure. You know, you ought to be allowed to ask questions of the applicant's representatives who testified. Mr. Summer testified at the Planning Commission's hearing under oath. He was the only witness who testified at the Planning Commission's meeting, and to a large extent, you're being asked, even though the staff report by Ms. McHerman said you're not required to defer to the judgment of the Planning Commission. You know, they made findings of fact and conclusions of law based on those representations, and we've challenged those on substantial evidence grounds. So I just want to make the record clear on that. If that's how you're going to rule on this, that I don't get to question Mr. Summer.
Very good. I would like to take a 5-minute break while I talk to the city attorney. We'll just stand down and I want to discuss this with her. So please hit the pause button and we'll step out for a minute. Thank you, everybody, for your patience. We're just trying to go over some of the material that is in our process, the regulations that govern our processes. I would ask the city attorney to address this request by Mr. Throne to cross-examine Mr. Summer and see if we can then move on.
Mayor, but councilors, I think Mr. Summer has the right to determine whether he is going to be a witness or not as the agent, and whether he is testifying to facts. There's no rule that requires someone to fit into one category versus the other. And I would just clarify, the part about, who may be questioned by the governing body is on page 8 of your, procedural rules. This is an exhibit A. And it says the members of the land use board hearing the appeal or the governing body, as the case may be, may ask questions of the appellant and the appellant's witnesses, of the applicant and the applicant's witnesses, or staff, or of members of the public who testified at the public hearing as they choose. So all categories of those people are available to answer questions.
I would just point out that if they haven't testified, that was my point.
I
just wanted
think
to-
I heard, I
Okay.
appreciate that, and I appreciate your waiting while we did a little sidebar conversation. I just want you to know, we're taking, as you can tell, we're taking this seriously. We're working hard to get to a fair process that lets everybody be heard, but we're also eager to follow our own processes so that we don't deviate. So with that, I think the next step,
Point of inquiry.
Yeah.
So that means that if Mr. Summer chooses not to be questioned, that is on all parties. So he can't take questions from us or from anyone, correct? It's
Not-
sort of an all or
that-
nothing.
let's go over that again, city attorney, because I think that was the last point you tried to address.
Right, that's correct, Mayor Weber.
Clarify just in our documents where that is, just because you said it quickly and
Sure,
wanna see it.
absolutely.
Take your time. Take your time.
So this is in, and I think I sent this out in an email last week for folks to have for quick reference, and I can send it again this evening if you need it at your fingertips. This is Resolution 2011-24, which is administrative procedures related to appeals of land use decisions. And I am referring to the Exhibit A, which is page 8. And I read number 9, and that refers to the members of the land use board hearing the appeal or the governing body, because this is written for both appeals to the land use boards, including the planning commission, because they do hear appeals sometimes, such as if the department head, the land use director, has authority to make a decision and his decision is appealed. This procedure also applies to appeals of his decision to a land use board, as well as appeals of a land use board to the governing body. It says either of those bodies may ask questions of the appellant and the appellant's witnesses, of the applicant and the applicant's witnesses, or staff, or of members of the public who testified at the public hearing as they choose. Now, I will address this right now. It sounds like Mr. Throne is reading this rule differently than I am, to say that the modification of who testified at the public hearing modifies all of those prior groups. I am reading it to modify the members of the public who testified at the public hearing.
Mr. Mayor, just 2 points of order, and I'll be very brief. There is an ethical rule that applies to licensed lawyers, and that ethical rule states, and I'll paraphrase it, that an attorney shall not act as a witness and as counsel before a tribunal. I believe that applies to you all. However, your practice has been to swear in everybody who shows up and so I swear in when they say swear in, because I don't want to create a scene and say, oh, I'm not going to swear in. So I want to point that out. There's an ethical rule that applies to that. The second thing is that my understanding is that what is in front of this public body tonight, the governing body, is the record below, which includes all of the testimony of all of the witnesses that testified before the planning commission. And all of that information is in front of you for consideration. And I just want to confirm that is my understanding of how that is there. Is that a correct understanding, Mr. Chair?
Madam City Attorney?
Mayor, Weber, councilors, that is how the city's appeal works. Yes, it is an odd construct in general, but it is our construct that it is de novo and you have the record as available evidence to rely upon. Some de novo hearings don't use any record evidence. Ours does. Some record evidence doesn't include any new evidence. Ours says you can look at the record below and receive new evidence, and you get to make the decision based on all of those things.
Thank you, Mr. Mayor. I just wanted to clarify those two things.
Thank you.
Mr. Mayor, just briefly, I need to respond to Ms. McSherry's statement about that the phrase in item 9 in the procedures only applies to members of the public who testified at the public hearing. The reason why the appellants don't believe that that's a reasonable interpretation is because that would allow circumvention of the ability of the appellants to cross-examine witnesses at the hearing. Because under your order, basically, now is my opportunity to cross-examine. And if they're able to circumvent it by saying, well, we have no witnesses, but then it comes to your turn and you can call on people who not only haven't testified at the hearing, weren't listed as witnesses for the hearing, and that's just a way for them to escape proper cross-examination under your rules. We really don't think that that's a reasonable or fair interpretation and really kind of object to it.
Okay. I hear you. Thank you. I would like, if we can, to move beyond process and actually get into substance. And I would encourage you to begin, because our next opportunity is for the appellant to address questions to staff. And that's your opportunity right now.
But still, point of parliamentary inquiry, Mr. Mayor. Still don't know if we've come to a resolution in regards to when we get later on in the agenda where the governing body has the opportunity to ask questions in determining who we have the availability because my interpretation of what's stated here is that we have the ability to ask questions of the appellant, their witnesses, the applicant and the applicant witnesses or staff or members of the public who testified at the public hearing as they choose. So using the information the way I interpreted it, it really changes the way have the ability to take in any additional information during this proceeding if the witness, in this case, Mr. Summer, is not available for questioning by the governing body. Because if Mr. Throne is unable to ask Mr. Summer question as being a witness, then the governing body would not have the ability, given that it's outlined here. We may ask questions of the appellant witnesses, applicant witnesses, staff, or members of the public who testify. We then eliminate Mr. Summer in general. And I just want to be able to establish that from now because it will help me move forward in regards to how I examine this proceeding. I don't believe that these proceedings are based solely off the fact that's included in the packet and the information included in the packet. There's also information that arises during the proceedings. And I want to be able to understand how I move forward. So if we can establish that here, it would be very helpful.
Yeah. City Attorney, I think you gave us some advice on that. Maybe you can reiterate what you said before about in what regard Mr. Summer would be available for questions and not available for questions, because there's a difference.
Mayor, councilors, thank you. So I understand Mr. Summer is the agent for the appellant, and the way that we have applied these rules traditionally for the agents is they can respond as the appellant
I was going to say
or the applicant in this case, the applicant.
I represent the applicant. I'm here in my representative capacity of the applicant. You have the right to ask the applicant questions. So I'm here in that capacity.
And Mayor or Counselor, my understanding is those types of questions would be answered by references to the record itself and by legal argument.
Okay, so then I guess what prohibits Mr. Throne from asking Mr. Summer questions as the applicant versus as a witness?
Mayor or Counselors, it would be because of he's not doing sworn factual testimony. So he can reference the record.
So who's
Which exists.
representing the applicant? I mean, I'm very confused here because it seems like a big part of this process. We're not affording the opportunity and due process opportunity of one part of the proceeding. And it causes me great concern. And I understand the, the ethical quandary that Mr. Summer is in, but does that apply here, I guess?
Mayor or Counselors, I think that was a definite concern of the request to cross-examine the city attorney's office too. It was absolutely an ethical problem. So Mr. Summers acting as an advocate for a client in a legal proceeding. So he can answer legal questions and legal argument question and interpretation of existing record questions, which is the same type of thing my office can answer questions about. We cannot testify to you about the plat personally, because we are not witnesses about the plat. I suggest you ask someone who does have direct personal knowledge about the plat, those types of questions. You are answering a question of whether the final plat conforms to the preliminary plat.
Right, and so I
And so
guess,
if there's plenty of city staff who can participate in that conversation. And then if you don't have enough information, identify that information, we'll find out where we can get it.
right, and I guess my question is, why, if I want to go to the applicant and there's no witnesses on behalf of the applicant, there's nobody, that's a great concern to me.
So Mayor Weber, Counselor, what I would advise is you ask the applicant where you can look in the record, if anywhere, to find the answer to your question, or if there's a city staff member who can answer your question.
And what if I have a follow-up question for the applicant based off the information provided in the record? And I don't want a response from city staff or the appellant. I would like a response from the applicant. Puts me in a position where I'm not able to get the full piece of information.
Mayor Weber, Counselor Garcia, I think we will have to find a specific instance of where this might come up because it's very hard to answer in the abstract. And I think what it will come down to is, does the governing body have enough evidence in front of it to make a decision of whether the final plat substantially conforms with the preliminary plat? And I think you won't know that answer until the end of your hearing.
Okay, I just trying to be proactive and that we don't get into that position. But thank you, Mr. Mayor. I appreciate it.
Thank you.
Mr. Mayor,
Mr. Throne,
I just have to, a couple of things. One, you heard from both Mr. Summer and the city attorney that the record in this case is the whole record, goes all the way back to the beginning of the preliminary plat approval stage, and we don't disagree with that. We've asked for that entire record to be included in the record in our appeal petition. There was a misstatement by Ms. McSherry that Mr. Summer is the authorized agent of the applicant. He is not. The record reflects that Monica Montoya is the authorized agent. Monica Montoya testified, as did other representatives, at the preliminary plat approval proceeding before the Planning Commission. The only witness the applicant put on before the Planning Commission at the final plat approval stage was Mr. Summer. So, and the other thing is, you've got a rule, and there's another part of your rules that required us at least 10 days prior to the hearing, which we complied with, not only identify each of our witnesses, but to describe the subject matter of their testimony and the basis for it. The obvious purpose of that from a due process point of view is to give the other side an opportunity to know how to prepare for the hearing. They didn't list any witnesses. And so now to come in and try to come in through the back door through questions from the members of the governing body after all the cross-examination opportunity is over, it's just not only unreasonable, it really is outrageous. And so I ask you to consider your rules and fairness here, because you've talked about this, over and over again, and enough said.
yeah, I think your preparing us for something and putting us on notice that this would be objectionable, but it hasn't happened yet. So let's be aware of it and let's move forward with the part that is agreed upon by everybody. And that is that you now have the floor and you have the opportunity to ask questions to staff, and we'll go forward with that. And I will be your intermediary to keep the conversation going.
Okay, and as I begin that, I'm also going to, in accordance with your appellate procedures, we're allowed to hand out a document as long as it's handed out to everybody. And I'm going to do that at this time. I have enough copies. I'll give one to Mr. Summer. This was previously provided to Mr. Summer and to the Assistant City Attorney prior to the hearing, so there's no surprise here. And then here's the clerk for passing out to the members.
Thank you. I'm sorry. Not at the moment.
For short.
Okay, let's not have sidebar conversations while we're waiting for the paper to be passed around. It may be in the future, we can ask specifically to see things that that are either in a digital format, but you have the floor, sir.
Yes, and just for the record, what this is an email to me from Assistant City Attorney Minuk Herman. I think it on the, I believe it's attached, I believe it's 2 days ago. Yes, February 5th, attaching series of questions provided by the applicant to staff for questions for Dan Escabel. It says on the top, notes on a plat. So this was provided 2 days ahead of time to Mr. Escabel, so apparently so he could prepare for this hearing, which to me was unusual, but I wanted it in the record. Thank you.
Very good, sir.
The first staff witness, and we did provide, and it's also in a document, we previously notified the city attorney and the applicant's counsel that we wanted to cross-examine Ms. Minuk Herman because she authored staff's report. That's the January 26th report that is required by the city's appellate procedures. We were surprised that came from the city attorney's office. We thought it would come from staff because all the prior reports were authored by staff. But it addresses facts. It's not just law. And we asked for an opportunity to cross-examine her about the basis for some of the statements in that report. And so that at this time, we would ask that I'd be allowed to question her about the applicant's report and also the PowerPoint presentation that she made, which differed somewhat from that report. She made that at the January 31st hearing.
I believe that the city attorney has addressed that already, but I'm happy to have her once again cover that ground as to why the city attorney's office doesn't feel that's appropriate.
Mayor, councilors, the staff report for appeals is generally written by staff. I'm not aware, or sorry, by the city attorney's office. For non-appeals, it's written by land use department. I did cover the rule a moment ago. For sworn testimony by attorneys, our rules do contemplate the opportunity to ask them questions as witnesses for non-sworn legal argument and citations to the record. They do not. The governing body is welcome to ask Ms. Minuk Herman any questions it wishes to in her role as advising to the governing body and to help navigate amongst the record, which is what her staff memo is intended to do. If anything does not cite to the record, please do ask her about that, and we will find where in the record it is that she is relying on. But she personally is not testifying as to facts in this case, but is here to help navigate the process, as am I. She has the more intimate and direct knowledge of the case, having been involved with the planning department all the way through. But I reviewed the memo with her as well and asked many questions as well. So anything I can do to help, I'm happy to help. But anything I say is not factual testimony that I recommend the governing body rely upon. It is more assistance as to how to navigate the rules in a consistent manner.
Mr. Mayor, remember.
Point of parliamentary inquiry, Mr. Mayor. In our rules, it clearly states on item 6, the appellant shall address questions questions to staff. Is, Madam City Attorney, is Ms. Minuk Herman staff? Yes,
Mayor Weber, councilors, so
she is city staff, so I don't see a challenge with.
Hang on a second, Council.
Mayor Weber, City Councilor Garcia. The earlier part of the rule distinguishes between attorneys that are providing sworn testimony and those who are not.
I still, who else went, because the way I read this is in Exhibit A, number 6, the appellant shall address questions to staff. I believe any employee of the city would fall under that name, staff. So if the city attorney's staff is not eligible to be questioned, who else is not eligible to be questioned? Just so Mr. Throne can understand, because I mean, we're now eliminating the questioning body, so to speak. We can't ask questions to the applicant and folks who have testified in the past. We can't ask questions to the city attorney staff. I mean, the more and more we go through this
Mayor
proceeding,
Councilor Garcia, you can
Mr. Mayor,
ask questions to the city, the city staff, and you can ask questions to the applicant. Mr. Throne cannot cross-examine the city attorney's office. We are your attorney. We are not witnesses in this matter.
can you? Sorry about that. My phone, my computer's talking to me. And in this resolution, can you point to me where it speaks to that about the city attorney staff?
Mayor Weber, Councilor Garcia. Under Part 8D1, city staff shall be sworn when testifying as a witness to facts. Ms. Minuk is not sworn. She has no facts. And she will not be testifying today, and she has not testified in this proceeding.
So the memo, what the information pertained in the memo written by Ms. Minuk is not fact.
Mayor Weber, councilors, Ms. Minuk is citing to your record. She is not providing facts that she knows personally. It is all hearsay. It is all based on other people's statements that are in your record. She is therefore not a witness in this proceeding, not providing facts. She is summarizing for your help. You do not need to use her report if you do not wish to use it. We will not cite to her report in any findings of fact. We will only cite to the record and to witnesses' sworn testimony.
Okay, so I believe the memo is part of the record as well as the presentation was part of the record.
Mayor, councilors, it is part of the record in the sense that it is something you can use. It is not something that will be used for a finding of fact in your ultimate conclusions.
So asking a question of whether it be Mr. Throne or the governing body, we could not ask a question of Ms. Minuk in regards to the memo she wrote.
Mayor
or-
Weber, councilors, you can ask questions of Ms. Minuk. Bruce Throne cannot ask questions of Ms. Minuk.
I find that very contradictory to what's laid out here in the resolution. And as I cited earlier, number 6, the appellant shall address questions to staff, which Minuk is. No other questions, Mr. Mayor.
Okay. I think if there's another witness you'd like to call from land use or other departments.
There are, Mayor,
Okay.
and I just want to point out, I mean, you heard the city attorney say that Ms. Minuk, I guess I can refer to her as Ms. Minuk, isn't addressing facts. I mean, you look at the staff's report, they don't even name me as an appellant. They don't properly name the two HOAs that are appellants, they name individuals. And there's a statement in there on page 1 that says, bottom of page 1, it says, and I'm quoting, opinions, actions, and decisions by city employees who provided advice and recommendations to the planning commission are not under review by the governing body. And I would say to you that that is directly contradicted by the city code. And this is, we're spending a lot of time on procedure here, but I think the reason is because the procedure in this whole proceeding going way back to the beginning has been problematic from a code point of view. But section 14-3.7 A1D7 says that final actions that may be appealed by a land use board do not include, and I'm quoting here, any action regarding procedural matters or requirements, provisions of notice, the admissibility, relevance, or weight of evidence, or the conduct of a public hearing. However, these actions may be raised by parties as part of an otherwise valid appeal. This is an otherwise valid appeal. And the way you know that is because as part of your appellate procedures, after our appeal petition was filed on August 31st, the next step is for the land use director, Mr. Cluck, to determine whether or not there's been any nonconformity with the requirements, procedural requirements in the appeal. He didn't find any, because if he had found any, he would have to report them to the city attorney, at which point the city attorney has to, if she agrees, is then presented to you with a recommendation. That's happened to you in the January 31st hearing with a prior case where you dismissed the appeal because they hadn't served the opposing party in 3 days. So, you know, there are all sorts of problems. And then we have the slideshow that had listing the basis. The staff report is required to summarize the basis for the appeal. There are things on that slideshow that were presented that aren't even in our appeal. So, I mean, to say, I mean, are we going to strike the whole staff report, or is that something you're going to be relying on? Because honestly, we understand that what happens under your procedures after you close the record is you go into the room down the hall with the city attorney and you deliberate in private before you come back and you announce your decision. And,
That's actually not factually correct, sir.
that's what,
It's an option to go into executive session. In 6 years of land use cases that I've been on this governing body, we've done it no times.
I see. I was just reading the rule and it said that you made.
That's okay. I just want to make sure we don't confuse the public as to what our process is. We have the option to go into an executive session, but for the most part, well, not for the most part, in every instance since I've been sitting in this chair, all of those have been done in this room and with the public fully present.
So with our objection having been made on the record, I'll move on. And now
Thank you.
we'd ask to ask questions of Daniel Escobar for the staff, please.
Thank you. Mr. Escobar, I think I saw you come in. Appreciate your taking time from your family emergency. If you would please come forward to this podium that we've set up to the side. Mr. Throne will stay where he is in order to ask his questions, and then Mr. Escobar, you, sir, will be at this podium and you will be sworn to answer questions. And that microphone, I have to warn you, I've seen with Mr. Summer, it is not picking people up unless they're really very much in front of it. And so you may have to either raise it or adjust it to your height.
Can I ask just one quick question, just so I know what where I set up?
Yes, sir.
And I just want to make clear that we are talking only about an appeal of the final plat and its relation and compliance to the preliminary plat. The rezoning, the preliminary plat in and of itself, the contents or merits of those cases are not on trial today.
I would, did you pick that up? Madam City Attorney, did you pick that up?
Mayor Weber, counselors, are you asking if I can hear him?
No, I was asking if you concurred with it was a statement, but it was also a question as to what
I just
is-
want to make sure
is in
I
front of
know what
him.
the fundamentals of this meeting are, just for my own, so I can set up correctly for questions. This is not an appeal of the rezoning or the preliminary plat or the merits of the rezoning or the merits of the preliminary plat, but an appeal of the final plat and its compliance with the preliminary plat.
Mayor Weber, counselors, what you have in front of you today is an appeal of the preliminary plat.
Final plat or?
Final.
Sorry, of the final plat. Yes, not the rezoning. Correct.
Okay, I think we need to swear this witness.
I, Daniel A. Esquibel, residing on Howard Frio Street, solemnly declare and affirm that the testimony I have in reference to this item shall be the truth and nothing but the truth, and do so under the penalties of perjury.
Thank you. Okay, again, that microphone is a little, not giving us full volume. So if you can really be clear in getting it in front of you, it would be really great, because so everybody can hear and so the record that is produced can be accurate. Yes, sir, Mr. Throne.
Good evening, Mr. Escabel, and also for, in terms of your preparation, could you, or if you don't have it in front of you, I know you've got a laptop, could you have staff give you a copy of the document that was presented at the January 31st hearing, which was the design ingenuity drawing that was submitted by the applicant on April 10th, enlargement, so that you can read that. Do you have that in front of you?
Yes, would it be okay if I pull up the digital copy? That way I can zoom in and out. It's a lot clearer than a paper.
Absolutely. Yep. I think our city council members prefer digital anyway.
And I will say, Mayor, that the reason why, I mean, I asked for these enlargements because we felt the PDF reduced versions, we couldn't read all the data on it easily. And I wanted to make sure for the appeal that you all could read it.
Thank you. Are you set up or not quite yet? All right, take your time. Make sure you can look at the material and then the questions that come your way.
So I'll be able to see this, but I won't be able to see you.
All right, well, that material is more important than seeing us, trust me. So, Mr. Throne, I think Mr. Escabel has the digital and paper version of the document you were referencing, if you'd like to proceed with a question.
Thank you.
And I'm happy to have it channeled through me.
Okay. Is it correct that you testified in support of the applicant's application for preliminary plat approval at the Planning Commission's July 21, 22 public hearing and August 18, 22 public hearing in case number 2022-5064?
Mr. Escabel?
Mayor, members of the council, yes, the Planning Commission did approve the preliminary plat. And I did present and make a presentation and recommendations for that.
Is it correct that you were not sworn in by the city clerk or anyone else for the city prior to presenting your testimony in those preliminary plat application cases?
That is correct.
Did you review the appellant's verified appeal petition prior to this appeal hearing?
I'm sorry, say that again.
Did you review the appellant's verified appeal petition prior to this appeal hearing?
I did read it, yes.
Is it correct that on or about February 5th, after the governing body recessed its January 31st hearing in this appeal, you received an email from one of the applicant's representatives attaching questions that the applicant wished to ask you at today's hearing about notes on a plat?
Mayor, members of the council, I'm not quite sure what he's referencing.
We have a document that is a series of questions called Questions for Dan that was forwarded by the applicant. I don't know if it got to you or not, but Mr. Throne has distributed a hard copy of those questions.
I believe that email was forwarded to me by my supervisor. However, I was deep into looking at all of the videos in order to prepare for this meeting. I did not get a chance to look at this, so I don't know.
Thank you. Go ahead, Mr. Throne.
Are you aware of any provision in the city code that authorizes the planning commission to approve a staff recommendation that notes on a final plat addressing requirements in chapter 14 of the city code applicable to a subdivision and commission conditions for a final plat approval need only be placed on the plat after the commission approves a final plat?
Mayor, council, yes, I do.
And what provision is that?
That would be under the subdivision criteria. Would you like me to read it to you?
You could give us the section number, please.
There are several that allow us to provide conditions of approval. See, so we're going to start with 1437, keep that in mind. Go down to B as in Bravo. And you're going to go down to 3C. The land use director's review.
My question was, does that code provision authorize the commission? Not whether it authorizes you to recommend that notes on the plat will be done or put on the plat after the commission gives final plat approval. But is there anything that authorizes the commission to approve that?
Mayor, council, may I read this?
Yes, please. And Mr. Throne, I'm not sure when you referred to approve that, to what is the that in that sentence? You lost me right at the end.
What I'm addressing here is the position taken by staff at the Planning Commission's July 6, 2023 hearing that any notes required to be on the final plat did not have to be on that plat at the time the Planning Commission made its decision and then made its findings of fact and conclusions of law, but rather any necessary notes can be put on the plat afterwards, as I believe Mr. Escobar testified, at some point in time after the record's closed. That's what I'm asking about.
Mr. Escobar?
So Mayor, members of the council, there are actually two sections that answer those questions, if I may read them.
Please.
So the first one, going back to the sections that I just referenced, the land use director shall review the preliminary plat and supplementary materials submitted for conformity to this article. The land use director shall provide the planning commission with a written report of findings together with a recommendation that the preliminary plat be approved with conditions or disapproved. The recommendation to conditionally approve shall contain the conditions, and a recommendation for denial shall contain the reasons for that recommendation. Let's see, B, the planning commission review and decision. The planning commission shall review the preliminary plat and other materials submitted for conformity to this article, consider the land use director's report and recommendations, and require any chart changes deemed advisable and the kind and extent of improvements to be made by the subdivider. Following this, the planning commission shall act on the application within 35 days unless the extension of time is applied for in writing by the subdivider and granted by the planning commission. The planning commission shall approve or deny the application. And then with regard to time limits, all conditions and final plat approval shall be completed within 3 years of recording the plat unless a different schedule has been approved by the planning commission or an extension is applied for in writing and approved by the planning.
Mr. Throne, did that answer your question?
Well, let me ask you about that. And you just read the language that said that conditions need to be completed within 3 years after recording. So that happens after recording.
That's correct.
So are you saying that conditions that are established or adopted by the planning commission at the preliminary plat approval stage, including required notes on a plat, don't have to be complied with until after a plat is recorded with the county?
Mayor, council. So when a preliminary plat is approved, it usually comes with all the necessary components in order for it to be moved forward to a final plat. Some of those conditions have timestamps, be completed by, and the commission approves those timestamps when they approve those conditions along with approving that particular project. So those timestamps could be either prior to recording the plat so that they get on the plat prior to its recordation, or there'll be conditions that affect the construction and therefore have to be complied with after the recording of the plat. So it depends on the condition of approval and the time frame that it was approved by for it to be complied with. Most of the conditions that Mr. Bruce is concerned with, such as the open space, those were conditioned prior to recording the plat because I wrote that.
Mr. Escobar, how can notes be added to a plat after the plat is recorded?
Well, Mr. Mayor, Council, as I said, that condition was timestamped so that it would be placed on the plat prior to recordation.
I got a response. I'll move on to the next question. I don't believe that the provision that was cited authorizes the commission to do that, but I'll move on. Is it correct that you testified, Mr. Esquivel, at the commission's July 6, 2023 hearing addressing the applicant's application for final plat approval, that the notes on a final plat are the principal mechanism the land use department staff relies on to ensure that all development on each lot of the subdivision complies with all applicable requirements in Chapter 14 of the code?
Mayor, members of the council, that is correct. We do use notes on the plat in order for our staff to be able to address those conditions and enforce those conditions when an application comes in for construction.
And now referring to the final plat that is now before this body, which is the same plat that was submitted by the applicant on April 10th, 2023 to you and to the Planning Commission, and I believe is in front of the members of the governing body. Is it correct that that final plat, as it exists in the record before the governing body in this appeal, does not contain any notes addressing the open space requirements applicable to each lot of this proposed subdivision, or referring to the open space standards in Chapter 14?
Mayor, members of the council, when Mr. Throne filed the appeal, I stopped working on it. So I put it aside and started looking at other applications that need my attention. So not all notes have been able to be placed on the plat because we set it aside until pending this approval. So whether there is a note that addresses it that I agree with, or there's not a note that doesn't address it, I'm afraid I don't have that in front of me because I put it away.
Well, if I could get my question answered. So you don't know, as you stand here today, you don't know whether or not there any, I mean, the governing body has the plat. I mean, it's, for your reference, Mayor and members of the governing body, it's sheets 2 and 3 in those in that plan set. Mine. Yeah, just for frame of reference here so what you have here, and just, I'll point this out to you and to the witness to make sure we're all clear. I know he says he can draw it up on his laptop. So, I'm looking at the set of plans, and it says in the lower right-hand corner, it says April 10, 2023. That's when it was submitted, by the applicant to Mr. Esquivel and to the commission. And you'll see there's a cover sheet. And then the second page is it identifies a site plan, distinct document from the final plat. That's not recorded. There's no recordation information on that. And then the final plat is 2 sheets, and that would be the 3rd and 4th pages of this document. And if you look at the lower right-hand corner, it says in the first page, sheet 1 of 2, and then you flip it over on the other side, and there's sheets 2 of 2. And I'll give Mr. Escabel a chance to make sure he has access to that.
So, Mr. Throne, did I hear your question correctly? It was, were all the notes entered on the plat by Mr. Escabel? Was that your original question?
No.
Okay, could you repeat it, please?
I asked, is it correct that the final plat that's presented to the Planning Commission and it's before the governing body here today in this appeal, is it correct that does not contain any notes that address the open space requirements in chapter 14? And by that, I'm referring to two things. The first being the 50% per lot open space requirement that applies to all property that is located in the South Central Highway Corridor Protection Overlay District. And then there's a separate section of the code that addresses open space standards. I believe that's 14-7.
So the question is, are there no notes regarding those requirements?
Mayor, members of the council. So if you were provided with sheet 2, which is identified within their package of information, a lot of their notes are present on that. If you look at the upper right-hand corner under project data, there are 1, 2, 3, 4 items. And it says lot open space. It says 50% of each lot within the subdivision shall be open space per SFCC section 14.5 4A 4B5. The South Central Highway Corridor section, chapter 14.
So could you, Mr. Escabel, we are inundated with paper. Could you guide us a little bit as to which sheet we should be looking at? And also, I apologize, that microphone is not doing you any favors.
I'm sorry, Mayor, I'm not familiar with what they gave you. If I can approach your desk, I can point it out.
I think Counselor Garcia will bring some paper to you and maybe you can find it. We'll share, right? We have a document dated April 10, 2023.
Okay, Mayor, members of the council, you have a cover page, Old Pecos Trail. If you turn it around, you're going to see a second page with many of the notes and conditions. Right underneath the vicinity map, you're going to see a section called Project Data. You go to the fourth line or the last line under Project Data. It reads 50% of each lot within the subdivision shall be open space per SFCC section 14.5 4A 4B5. That references the South Central Highway Corridor requirement for the 50% open space requirement.
Got it. Does everybody find that on your documents, governing body members? Okay. Mr. Throne, back to you, sir.
Mr. Escabel, it's correct, is it not, that the document you just referred to is the site plan?
Mayor, members of the council, as I indicated before, I stopped working on this, so it's not recordable, but it is not uncommon that because of the number of conditions that are required for a specific development, that we require a conditions page to be recorded alongside of the plat so that they all apply and function together.
Is it correct, Mr. Escabel, that site plans are not recorded with the county?
Mayor, members of the council, as I indicated already before, we would, if there's too many notes to place on the plat itself, this site plan will be included as part of that subdivision recordation.
Mr. Escabel, is it true that there is no, I mean, the county has recording requirements for filing, isn't that correct, that you're familiar with?
Mayor, council, I am not familiar with what the county is allowed to or not allowed to record. I can only tell you what we would require to record, and the county does not tell us what we are going to record as part of our documentation.
I would just, for my next question, just point out that we have submitted a document in the record that talks about the attestation that's required by the county for recording documents, whether it's a final plat or, but along these lines, let me refer you, Mr. Escabel, to the third page of this plan set. That's the sheet 1 of 2. And that's the first page of the final plat that was approved by the Planning Commission. Is that correct?
I gave my version back. I'm not sure. I guess I'll have to use your copies. You're taking 1 of 2. That is part of the survey. That is true.
Well, that's the first page of the final plat for recording, correct?
It may or may not be, Mayor. As I said before, we decide what's going to be recorded. It isn't the applicant, it isn't the county clerk.
Well, is this the final plat or not?
The entire package of material represents the final plat, which includes all of the construction drawings as well as the survey that outlines each and every lot. They are, what we record is the survey so that they know exactly where their boundary lines are. But the plat itself is filed in the map room where the applicant utilizes that information for the construction materials part of their building permit.
Mr. Escobar, looking at that same first page, the sheet 1 of 2, on the left-hand side, under which there is the words dedication and affiant. You see that?
Yes.
And there's language, and then it goes down, and there's a space for the owner of the lot. Here, there's a signature line for Mr. Pierre Amistoy as the owner, and where in front of a notary public, he has to attest to that dedication. Is it not correct that that's what's required by the county for recording any document, whether it's a final plat or any other document with the county?
Mayor, members of the council, dedication statement is required by the land use department, not by the clerk.
That wasn't my question. What I'm trying to bring out here is that, what was approved as the final plat is not the same thing as the site plan. And I'm just trying to establish if it's correct that, and going back to my original question, that you referred to the 50% open space requirement on the site plan, but that's not on the plat. I'm just trying to establish that as a factual matter. Is that correct?
Mayor, members of the council, again, it will be part of the plat and part of that filing when we record the plat. So it's not uncommon to have a single document, to have multiple pages for filing. You have a deed, and the information on that deed cannot fit on the front page, you're going to have a second page. The same thing occurs with our subdivision. There's more information that can fit on the survey itself. We will add sheets in order to file with that survey to become part of that plat as an extension of notes to the survey.
And so am I correct then this document, the sheet 1 and 2, I'm sorry, the 2 sheets that are the third, fourth pages of this plan set, that is not the final plat that's going to be recorded.
Mayor, members of the council, that is correct. What is being represented here to you tonight is a draft that I did not finish in order to get it ready for filing. Therefore, you are looking at an incomplete document. So there are notes and other conditions within the approvals of the Planning Commission that are not on here because I have not collected them all. I have not sent it to the DRT for them to look at it, make sure their conditions are on the plat in order to get it ready so that all of the sheets can be recorded and filed in the county clerk's office and filed in our map room so that the applicant can start construction.
Now,
Mayor, can somebody tell me what DRT is?
Yes.
I'm sorry, Mayor, members of the council. The DRT is our acronym for the Development Review Team. The Development Review Team are all of the city divisions that are required by the land use director to look at the project before you, because it may have several cases, or the development before you or subdivision, so that we can get feedback for other sections of Chapter 14 or city code that are required to be looked at so that this development will meet the city standards.
It's a cross-department working group that comes together to review proposals developments and make sure that all voices in all departments that need to be engaged have a chance to review the proposal and make their comments. Mr. Thrum?
Thank you. Mr. Esquivel, can you tell the governing body today, as part of the record in this appeal, exactly what the text will say on the final plat regarding the open space requirements applicable to this subdivision?
Mr. Mayor, members of the council, as I've referenced in previous planning commission meetings, there are 4 types of open space. One of those types of open space is the requirement of the overlay. That is just a requirement. So we are going to require that they show that open space on each lot to identify its compliance with the open space. And we'll probably keep the note that is currently on the site plan as part of that compliance record so that we can physically see it and we can identify it on the plat. We'll probably put the date of the meeting so that whoever is looking at a building permit can reference that meeting date, look at the minutes, look at the conditions of approval, and verify and validate for themselves so that they can apply it correctly as building permits across the board.
Now, with respect to your response there, I'm looking again at that language on the site plan. That reference to section 14-5, 0.4A4 B5, excuse me. That refers only to the open space requirement in the section of the code that addresses the South Central Highway Corridor Protection Overlay District. Is that correct?
Mr. Mayor, members of the council, that is correct.
And that doesn't refer to the open space standards in section 14-7.5 of chapter 14 of the code. Is that correct?
Grants by memorandum. Contrary to popular belief, I do not have the code memorized.
Oh, I've had to.
Sorry.
Hmm.
Fourteen seven five open space standards. Mayor, members of the council, there will not be a condition relevant to that particular section on the plat.
Now, that section of the code defines and addresses open space standards for residential private open space and residential common open space. Is that correct?
Mayor, council, that is correct.
And I believe you testified at the Planning Commission's July 6th hearing on final plat approval that you had discovered after the Planning Commission's made its decision on preliminary plat approval that there were actually, I thought you said 3 different types of open space, but I believe you just said there are 4 different types of open space.
Mayor, council, that would be non-residential. Non-residential has its own form of open space.
Well, this is residential property, correct?
Yes, Mayor, this is residential property. The reason we do not put notes on the plat for private open space is because it's triggered by lot coverage. Lot coverage is a measurement of all roof area on on the lot itself, on the piece of property. So when development occurs on a lot that hits 40% or greater, but up to 50% in this particular R district, then the applicant is required to add open space to their site plan as a requirement of 14, this particular section. So if they don't hit 40% or greater, if they're under 40%, then that will not trigger that section of the code and it won't be applied. So during our training of our employees who are looking at building permits, we train them to look and understand how to calculate lot coverage in order to apply the open space. They fail to meet that open space standards, they either have to reduce the size of their buildings or they have to seek a variance. So, but we don't put a note on that plat because it may not apply each and every single time.
Mr. Escabel, well, is it correct that the code provides that under the dimensions provisions, that for lots that are zoned R3, which is what the city has rezoned it to in its prior decision, maximum lot coverage is 40%, but can be increased to 50% if it is private open space.
Mayor, Council, that is correct.
And I think I referred to this in my testimony, January 31st, but if you look on the second page of this final plat document, which is sheet 2 of 2, up in the upper left-hand corner where it says project data, it says the lot coverage is 40% maximum. Is that correct?
Mayor, Council, that is accurate.
And now going back to the preliminary plat approval proceeding, your staff report that you presented to the commission, in that report, you indicated that the applicant had not shown that his proposed subdivision could comply with the 50% on each lot open space requirement because of the buildable areas shown. And you said that in the report, that's your report, correct?
Mayor, Council, I'd have to refresh my memory as to why and if I said it. I don't remember. I don't recall that. If I did, it was probably because the plat in and of itself was designed in such a way they couldn't adapt to the regulations that are required. That is why we pushed the finding of the applicant to demonstrate how he could meet that open space criteria. That was that colored piece right here that allowed me and the commission to actually identify how they were going to achieve that requirement.
So, and I think you sort of just answered my next question, but just to be clear for the record. So, what you testified at that preliminary plat review stage in front of the planning commission was, well, let me back up. Do you recall that at that time, Janet Cloud, the chair of the commission, asked you, do we need to address the open space compliance requirement at that hearing? And you indicated, well, that's a good question. It's up to you. But if you want to defer it to the final plat approval stage, you can do that. Is that accurate?
Mayor, Council, Chair Clow was referencing at the before she made the question, it was a reference into relevant to condition 1 within the staff memo. And condition 1 within the staff memo identified that they had to comply with the open space requirements. She was asking whether or not they had to deal with it now or they can push it off to final. However, they did actually deal with it during that hearing as all of the planning commission adopted all of the conditions of approval and approved the plat.
Well, just to be clear, and I think the record will speak for itself on this, is it not your understanding that Chair Clow, without actually discussing this with the planning commission, decided we'll defer this? And not only that, but you actually testified to the governing body in the rezoning case that this is a matter that's going to be addressed on the final plat at the final plat approval stage.
Mayor, Council, I don't actually recall that conversation. I did look at the video and I do recall an exchange with Chair Clow regarding the open space relevant to condition 1. And we moved on to the hearing, and condition 1 was not deliberated by anybody during that process. When they were making a motion, they did vote to accept all of staff's conditions, so I assume they were comfortable with whatever exchange occurred between Chair Clow and myself, trying to answer the questions relevant to question number, or condition number 1.
So now turning to this, the document that is entitled Lot Open Space and Buildable Area with the green areas shown. But it's correct, is it not, that that was not presented to you or the Planning Commission until April 10th, 2023 in support of the applicant's application for final plat approval?
Mayor, council, to put myself in a position of liability, but you know, unlike the neighbors who tend to attack me for being on the developer side, I also fight with the developers, and I was threatening the applicant that if they did not provide me with information to show how they were going to comply with that section of the code, I was not going to present their application to the Planning Commission. This is a direct result of their trying to achieve my requirement in order to address the open space needs, because I too wanted to see how they were going to comply with that 50% rule in the event they were going to exceed the 40% lot coverage. This is what they came up with, and I accepted this and took them forward.
And don't misunderstand my question. I'm trying to get at the timing here. There's been a suggestion by the applicant's attorney that somehow there was a waiver by the appellants to not address the preliminary plat approval, that therefore that issue was by not appealing that to the governing body. And I'm just trying to establish, I mean, the appellants couldn't address this document until the Planning Commission came in for its hearing on final plat approval, correct?
Mayor, council, I don't understand his question.
Maybe you could rephrase it. I also missed the gist of that one.
I'm trying to establish that the first opportunity the appellants had to address the applicant's compliance with the open space requirements in Chapter 14 of the City Code was at the Planning Commission's hearing, because this document was not included in the packet for the Planning Commission until June 30th, which is about 4 days before the Planning Commission's July 6th hearing, correct?
Mayor, council, if I'm understanding his question correctly, the applicant and staff tend to argue a lot over what we require and what our interpretations are of Chapter 14. The applicant believed that they should be able to address open space at the time of building permit, because all of their houses are going to be custom houses on each lot. My interpretation, which is an extension of the land use director's interpretation, is that the open space for the Old Pecos Trail is not the same as the open space for lot coverage, and therefore you have to show it on the plat because it's a requirement regardless of lot coverage. This exchange went back and forth through the preliminary plat process and up until we were going to final plat. And the only reason we got this is because I did tell them, you're not going until I get it. And therefore they brought this up a few days before that in order to achieve our requirements to be able to be taken forward to the Planning Commission.
Is it correct, Mr. Escabel, that your interpretation that the private residential open space standards doesn't apply to this subdivision is not a interpretation that's ever been issued in writing by the planning land use department director, Mr. Clark, or his predecessor?
Mayor, council, this, I believe, in my 17 years is my first review of a subdivision inside the South Central Highway corridor. Plenty of lot splits, but first subdivision. So originally, we discussed with legal how we were going to apply the open space because it did not assess any direction within chapter 14 to either private or common open space listed in another section. So it was determined that it was just open space and it has to be placed on the plat, but it was not the same design standard as the private open space, which limits your parking, your driveway, your grading and drainage. It has to be a slope of 1 in 10. It also has to have an access directly onto the house. So they were clearly different types of open space. So that is how we came up with our interpretation of open space and how to apply this open space for the overlay. Is there a policy in writing to date? There is not.
Is it correct that you came up with this interpretation? And I think you testified, and you said you read our appeal petition. I believe this is the YouTube recording of your testimony is cited in there. But isn't it correct that at the Planning Commission's July 6, 2023 hearing on final plat approval, you said that you came up with this after the Planning Commission had made its determination to approve the preliminary plat?
Mayor, Council, we did talk about it again after the preliminary plat. But if you look at the preliminary plat, the same information that was presented at final is the same information that I presented initially going over my initial presentation of how we apply the open space standards at the preliminary plat. So if you go through the video, there's a section of the video that talks about how open space is applied, and that is on the first meeting for the preliminary plat for the Planning Commission.
With regard to that,
It is the same interpretation, the same explanation today as it was then.
I believe you said you did review the appellant's appeal petition, and there's a section in there that addresses why we believe your interpretation is incorrect. Did you review that prior to the hearing today?
Mayor, Council, I kind of stopped when I read the word bias in the appellant's appeal petition and sort of put it aside and started prepping for this meeting so that I can answer as many questions as I possibly can. There are probably many statements that have been made, not only in the appeal, as well as at the podium initially for this meeting, that I believe to be incorrect.
Is it correct that there are provisions, and they're cited in that appeal petition, that these are provisions in the city's land use code that state that where there are requirements in an overlay district, such in the South Central Highway Corridor Protection District being an overlay district, those requirements are in addition to other standards in Chapter 14 of the code?
Mayor, Council, that's partially correct and partially not. The overlay district is designed to take control over many design criteria that may trump the underlying district standards in favor of its new matrix. In some cases, you may have to meet both sets of standards, but in other cases, the overlay district will trump those standards. Good case is the historic district. Many of our rules and regulations allow much higher height for buildings than what the overlay district for the historic district allows. In that sense, it does trump. Same thing with the South Central Highway Corridor. The South Central Highway Corridor limits height to 25 feet, not including a parapet, so it's to the roof deck. However, in an R1, 2, and 3 district, up to R6, height limit is 24 feet for residential districts. So therefore, the more restrictive requirement in that sense would take precedent, and the 24-foot height limit would then be its maximum limit instead of 25. I believe that the applicant has restricted theirs as a covenant to 18 feet, and I believe that we were asked to place that on the plat. They did place that on the site plan somewhere, so that will be their limit, is 18 feet.
Gosh, Mr. Mayor, I was hoping we could avoid the word Trump tonight, but I guess we couldn't.
Let's stick to the land use code.
Yes, I agree. I agree. So let's go, looking at this document again, that's entitled Lot Open Space and Buildable Areas. I understand your testimony. This is the document that you relied on to represent to the Planning Commission and again, to this body in this de novo appeal that the applicant subdivision complies with all applicable open space requirements in Chapter 14. Is that correct?
Mayor, Council, this is one item within the entire package of documents that was submitted that provide me that ability to recommend approval to the Planning Commission. It isn't this document in and of itself that makes that a complete application. It helps in the global sense that it is part of the review, part of the application, and through all of those documents, through the development review team's comments and conditions and the applicant's compliance with those conditions, we can recommend approval of the preliminary and final plat.
But is it correct that you actually insisted, or I don't want to put words in your mouth, but you said to the applicant's team, I need more documentation of this, and that's why they submitted this to you?
Mayor, Council, that is correct.
Let's look at that document, and let's first, on the right-hand side of the document, there's a lot of data there, but just to sum up, what that shows is the lot area of each lot in square footage, and then the open space identified, which is mathematically 50% of that amount, and then it says allowable buildable area, and that is the same 50% of the total lot acreage, correct?
Mayor, Council, the table on the right-hand side is what also provides some of that information. Again, we will be narrowing down a lot of the compliance requirements as we move forward to recordation. But in the time frame that I had to look at this, I believe that this met the intent of what we were looking for, and that I was able to move forward with them being able to comply with the 50% rule, and therefore I recommend it.
And so do I understand correctly that when you did your analysis of this document, you assumed that no private open space requirements applied to this document?
Mayor, Council, since I don't know how big those houses are going to be, that is not a review that I would put forward. That is a review that occurs at the building permit phase.
Say that again. Yeah, that is a review that occurs.
The 50% for lot coverage is something that can only be addressed at the building permit, since I don't have access to their roofed area to calculate lot coverage. Our code requirement says that a minimum buildable area shall be at least 2,000 square feet. So I look at that minimum area, and then I move towards, can you meet that 50% rule requirement by the overlay district? And this is what they presented to me, and I agreed with the engineer's evaluation of how they could meet this requirement. We will iron out any differences that we have prior to filing the plat.
My question actually was a little bit more narrow, Mr. Escabel.
Sorry.
When you look at this green area and you did your analysis, did you assume that none of the private residential open space requirements in the code that I referred to earlier did not apply to this open space demonstration, this drawing?
Mayor, Council, I did not assume anything about that section of the code. I just did not apply it in my review for this document. I was looking specifically for the overlay required 50% rule.
And in fact, if you look at the legend in the upper right-hand corner where they showed the green block, titled Lot Open Space, that refers to that same section of the code that's limited to the South Central Highway Corridor Protection Overlay District, correct?
Mayor, Council, I believe so.
Let me ask you about the private residential open space requirements. And and I think there was a little confusion I had in your last answer. You were talking about the 50% lot coverage. I don't want to confuse things here. We've talked about that the applicant's final plat says the lot coverage will be limited to 40% of the lot, correct?
Mayor, council, that is what they placed on the site plan, yes.
And lot coverage means basically the square footage of any structures on the property as a percentage of the total square footage of the lot.
Mayor, council, that's correct.
Now, this document doesn't show, what this shows is 50%, a 50% situation where there's 50% open space and, is that correct?
50% of the lot, Mayor, council.
Is it correct that, well, the things that can't be included in private residential open space include driveways, walkways, most structures, roof structures, except for portals or balconies. I think there's an exception for that. Storage units, couldn't have an accessory dwelling unit. Or, I mean, you know, in other words, that would count as a structure. And then one other thing that you can't have is a stormwater drainage pond on the lot can't be in open space, correct?
Mayor, council, that is correct.
And it's correct that the final plat here, pursuant to conditions that actually staff recommended because of the terrain of this property, requires that each individual lot has to have a stormwater ponding area that will, it'll be based on how much of the impervial, I'm sorry, on how much of the structure is put on that's impervious to water. And that's going to be determined at some future point in time, but each lot has to have one of those, correct?
Mayor, council, I'd have to look at the conditions of our train management team in order for that to happen, or I believe she is online. She can be able to answer those questions as to what her recommendation to the planning commission was.
Well, isn't that condition right on the final plat?
She has stormwater drainage information on the survey. Yes, that's correct.
I'll just refer you just to confirm this so we don't get too abstract or vague. So we're talking about sheet 1 of 2, conditions of approval, item number 10 on the right-hand side of that page. See where it says all lots are required to have on-lot ponding or any new impervious surfaces for structures, driveways, walkways, etc.
Mayor, council, that's correct.
And that can't be in open space, correct?
Mayor, council, that cannot be in private open space.
Okay, so again, the point you're making is that you don't believe the private open space, residential open space requirements apply here.
The private open space limitations apply to the private open space as identified within 14.7.5, I believe. But it does not apply to the open space as outlined in the overlay district. The overlay district does not have any limitations built into its text. It just says it's required to have 50% open space, and then it refers you to the definition.
And it's correct that this proposal and nothing in the applicant's final plat is proposing common open space as defined in the code.
Mayor, council, that's correct.
Now getting back to and each of these lots, is it correct that just from a purely private ownership point of view, once the lots are sold, no one can walk on any of these lots unless they have approval of landowner, right? It's not, it's private property, correct?
Mayor, council, it will be fee simple land owned by the purchaser of that lot.
And now I think you acknowledged that one of the things, and I understand you you think the private open space requirements don't apply, and we've challenged that, but just for the purposes of this question, assuming that the private open space standards did apply, would you agree that it would be important to have that noted on the plat so that subsequent owners, not only subsequent owners would know about that, but also that would be enforced by the land use department at the enforcement?
Mr. Throne, I think you're asking him a hypothetical that's hard to answer since he already referenced your previous question about how he made the determination regarding the overlay versus the other standard. I'm not sure he can answer your question about hypothetically what would happen to you.
Okay, well, I want to just explore with you just what this shows, this document in a couple of instances. By the way, I don't know if you were here or maybe you listened in from your office, but did you hear Mr. Summer? I believe he testified, but he says he wasn't testifying, indicate at the January 31 hearing that in fact, the applicant had informed the city where the 5 lots that are going to be covered by the Chapter 26 governing the Santa Fe Homes program, that is the affordable housing program, are located. Were you there when he said that? Were you aware that he indicated that they were shown on the site plan?
Mayor, council, I did listen and I did hear that.
Okay, and as I recall, he said there's an A, a letter A. Now let's look at this plat before I get to your question about open space. And here, this only shows 4 lots with a letter A, right?
I'm sorry, Mayor, I'm not sure what document,
think
Mr.
we're
Crone
looking
is
at
looking
this.
at.
Looking at the same,
You're looking at this one, yeah?
yes, yes,
Okay, just want to make sure I'm,
yes,
This was what you asked about previously.
exactly, yes, yes, Mayor. So there's only 4 lots with a letter A here, and that would be lots 10A, 11A, and 4A and 7A. Is that correct?
Mayor, council, I count 5 lots.
Where's the 5th?
You have lot 24.
I'm sorry, your document has a A after 24?
Yes,
No, I don't think so, sir.
this is the same document.
Oh, we're looking at the enlarged piece, but maybe there's a different one that you've been referred to. Under this document that I think Mr. Throne was guiding us toward, 24 does not have an A on it. There may be a different document that does, but this one does not.
Mayor Weber, councilors, for the record, it would be really helpful if we don't say this document. Can we give whatever you're talking about?
Document
An
that is
agreed upon
called Old
name?
Pecos Estates Design Ingenuity Lot Open Space and Buildable Area with green indicating lot open space is the document I'm referring to.
Mayor, council, if I can, again, the lot open space buildable area document, colored document, green. This is a document that was prepared by their engineer to satisfy my requirement to get to the planning commission. The actual document that we're going to be looking at and filing is going to be here. There are 5 lots required. If there was a typo in their haste to meet my requirements, it is not really a factor in my review since we'll be completely looking at the entire project.
So you're referring to the document that is dated April 10, 2023, Old Pecos Estates subdivision plat, page
2.
2, the turnover from the cover page where there is another representation of the different tracts and different, the letter A, as Mr. Throne referred to in his question, does in this one show up as 24A. So
The correction, Mr. Mayor, that's not the final plat. That's the site plan. If you look,
I'm just reading what's in front of me.
it says site plan. That's not.
Along the side of it, it says Old Pecos Estates subdivision plat. That's all I was trying to use to identify the document.
Mayor, Council, this document was an attempt to satisfy the open space overlay, not to reproduce the plat itself. So there are five affordable lots. Mr. Summer chose to disclose the A on that subdivision. They've been there since the preliminary plat.
Mayor Weber, councilors, Mr. Escabel, when you said this, you're talking about the colored document.
I'll refer this to the open space plan. And I will refer to the subdivision as the subdivision maps. Then I'll give the sheet number. Sorry.
Is it your testimony, Mr. Escabel, that these A after certain lots was there? Did you just say that it was there on the preliminary plat?
Mayor, Council, the applicant has been in compliance with the affordable housing project since the beginning.
That wasn't my question. My question is, I thought you just testified that this designation of where these affordable housing lots were going to be has been there since the preliminary plat. Did you just testify that?
Mayor, Council, they have been on there since the preliminary plat.
I believe he provided the preliminary, that's the second plat set. For the record, we're talking about the first page of which says lower right-hand corner, March 18th, 2022 revisions. So this is the second set.
Oh, Mayor, I'm sorry, that is my mistake.
Pardon?
That is my mistake. They must have been placed on there for the final. But when I saw them, I did ask what that A meant, since it's a change. And that was when they advised me with the affordable housing. I tried to have them remove that, since we were advised that the affordable housing lots are not to be shown.
So to correct the record, when you look at the document, preliminary subdivision plat on the second page, when you turn the front page over, there is no letter A on those lots. Just to be accurate.
Be accurate, Mayor. That's the site plan. That's not the preliminary plat. Preliminary plat is sheets 2 and it says, look at the first page.
I'm only trying to identify the document, sir. I'm not trying to identify.
This is a distinction that's important because the site plan is not a recorded document. It's not the same as the final plat that was approved by the Planning Commission. And it's not the one, so I just want to make the record clear on this.
Mayor, Council, all of this represents the preliminary plat. We don't isolate the survey from the terrain management, from the landscaping. This is the entire preliminary plat package, as well as a draft of the final plat with many of the conditions, many changes that were adopted by the preliminary plat. So this is an attempt to move forward to complete those conditions or to get it ready for recordation as they start making the edits that we require in order to mold the preliminary plat, not just the survey that gets recorded, but all of the sheets from water, sewer, lighting, grading and drainage. All of this represents the preliminary plat. We don't isolate just the survey and call that the preliminary plat. That would be an incorrect assessment in referencing how we address this package.
And just in that regard, but it's correct that what is recorded, which you record, you don't record this entire plan set with the county, do you?
That is correct, Mayor.
I'm still referring to the same document that's entitled Lot Open Space and Buildable Area. I just want to look at it, just a couple of examples here. Now, these aren't these buildable areas where it says building pads in each lot. These aren't what's sometimes referred to as building envelopes that are enforceable, right? This is just illustrative. Is that correct?
Mayor, Council, given the requirement of the open space requirement for the South Central Highway Corridor, the applicant will be required to place on this plat a buildable area. If that buildable area needs to be moved, there is a process in Chapter 14 that allows that to occur, provided they still meet the approval criteria for what was approved for the plan.
Stress, well, when will the buildable areas be put on the final plat?
Mayor, council, prior to recordation,
So as the governing body sits here today, they don't have that information, do they?
Mayor, council, you do not have the final version of the final plat because we stopped working on it. And typically you don't see subdivisions. So this is a common practice that we have with the planning commission where conditions of approval will provide us the opportunity and time to get the plat molded to its final version for recordation and use for construction.
Is it correct, Mr. Escabel, that nothing in the code defines final version of a final plat versus a final plat?
Mayor, council, the two conditions that I read to you earlier that give the authority of the land use director to write a review, and recommend with conditions, and the planning commission, their authority to review the same and approve with conditions. That gives us the authority to ensure that the final plat has to meet those conditions of approval, whether those are notes on the plat that have to be put, or whether those are conditions that have to be met after the recordation and part of the construction phase, with notes on the plat possibly. But that is the authority that we have, and that's been in practice since I've been working for the city.
Look, again, I'm looking at the same document, same drawing. Let's look at the at what's identified as lot 5. And I counted that's actually a 14-sided building pad description. Does that sound reasonably accurate to you? There are 14 sides to that.
Mayor, council, that building pad is not the final version that we're going to be looking at. We're going to be looking at a more generic use of the land so that the applicant and the staff don't have to work twice as hard to achieve the same goal and meet all of the conditions of approval. Again, this was just a quick attempt by the applicant to meet my requirements and demands in order to move forward to the planning commission.
And I'm still looking at that same lot, Mr. Escabel. Now, and I understand your position that you don't think that the private residential open space standards in the code apply, but I think we've talked about the fact that one of those standards is driveways can't be included in private residential open space, correct?
We make that interpretation, but I don't know if that the actual private open space section has a few limitations. I don't know if it actually says drive.
Okay, well, I'll let the code speak for itself on that, but just assume that the code says driveways, walkways can't be included. You want to check it? You want to check, you've got it there. I believe it does say that. (14-7.5A), I believe, before you even get down to C.
Mayor, council, would you like me to read? It's a very short section. That way everybody understands.
Go ahead. We'll all have the same information in front of us.
Which section are you reading, sir?
So this would be 14.7.5D, resident.
Could you start with A, please? Could you start with reading A? That's what I was referring to.
A, open space shall be provided that meets the minimum standards of this section 14.7.5, section 14.8.4H, open space planting requirements, and other applicable requirements of chapter 14, all required open space shall meet the following standards. 1, open space consists of area that are landscaped or that preserve natural vegetation, may include outdoor facilities, passive or active recreation. 2, open space does not include streets, driveways, parking, or loading areas, fire apparatuses, access roads, or turnaround storage areas or buildings.
That's what I was referring to, the driveways part.
And you are correct.
Thank you. So looking at lot 5, this illustration that was submitted to you to show that the applicant could satisfy the open space requirements. I'm looking at that, and that's why I asked this to be enlarged. Would you agree with me that that building pad is completely surrounded by open space?
Mayor Council, that is correct, according to
So-
their drawing.
So there's no, that lot doesn't show there's any way for someone to get from the roadway that's coming off of West Zia Road onto that lot, because there's driveways can't be in open space, correct?
Mayor Council, as I indicated before, this is just a quick rendering by the applicant. All the Ts will be crossed, all the Is will be dotted. This is a good catch by Mr. Throne. However, it would have been caught anyway, and we would have required them to address that issue prior to it being filed.
Mr. Escobar, I do understand, as is indicated in the legend up in the upper right-hand corner, that down the line, and it says right there, it says that buildable area may be relocated at time of building permit as long as 50% requirement is met. You see that?
Mayor Council, yes.
So I'm just trying to understand how it was that this document satisfied the applicant's burden of proof to show it could meet the 50% open space requirement. That's why I'm asking these questions.
Mayor Council, again, this is a rendering that shows me that they can meet that 50% open space required by the overlay. It doesn't mean that the buildable areas are set in stone. Doesn't mean that these buildable areas will not move in order to address these issues. It just means that they are able to meet the 50%, and each lot has the correct acreage to at least satisfy that minimum 2,000 square foot of buildable area. Each buildable area will then be looked at in order to make sure that the open space remains as open space, and that the private open space or the buildable area can accommodate at least a moderate size home.
Again, looking at the lot acreage data on the right-hand side of this same, I'm on the same drawing. That if you look at that square footage, it indicates that 5 of the lots that are proposed here are less than 15% of an acre. Isn't that correct?
Mayor, Council, the smallest lot in the subdivision is Lot 5, which is not an affordable housing lot. Smallest lot in Lot 5 is greater than 4,000 square feet, which is the minimum lot size for Chapter 14 for the creation of a lot without common open space.
And by the way, I neglected to just make sure I understand this. So based on the data here that you say is, and they've added another affordable housing lot that's shown on the site plan, this shows that 4 of those lots are directly adjacent to the arroyo, which is the Foothills Arroyo, that has been designated as a FEMA flood zone. Is that correct?
Mayor, Council, I believe it is. I would prefer that any flood zone comments be directed to our subdivision engineer or our floodplain manager.
I'm just asking you about the location. You're confirming that that's what's depicted.
Mayor, Council, that is true. The flood zone has been removed from the buildable area of the subdivision, so none of the lots are compromised by the flood zone itself. And there's also a setback requirement from the flood zone buildable setback.
Is it correct No, well, going back to the submission by the applicant in support of his application for final plat approval on April, was sent to you on April 10th, 2023. Included in the agent's, Monica Montoya's letter to you and the commission, one of the things that was included in there was a proposed or draft Santa Fe Homes Program Agreement, correct?
Mayor Council, I did get that.
And but that wasn't included in the packet that was published by the city on June 30th prior to the Planning Commission's July 6th hearing, correct?
Mayor Council, I'd have to look at the packet. I don't remember. I don't recall.
Well, were you aware that the appellant's appeal petition pointed that out?
Mayor Council, I stopped reading it after a certain point, and moved on to preparation.
One of the exhibits, Exhibit G to the appellant's appeal petition, was actually a final agreement executed by, it says Pierre Amistoy as a limited liability company with the city that was actually made effective in May 24th, 2023, prior to the Planning Commission's July 6th hearing. Were you provided with that prior to that hearing?
Mayor Council, again, I am uncomfortable talking about affordable housing documentation or contracts. Those have to go through our affordable housing. I would prefer that all of affordable housing questions be directed to that DRT member, as I am not qualified to answer those questions.
I looked at all the DRT reports, Mr. Escabel, and isn't it correct that really none of the DRT reports addressed affordable housing requirements?
Again, Mayor, in our policy, we don't disclose, or we were told not to disclose where the affordable housing lots are on a subdivision to prevent discriminatory practices from surrounding areas that may have a different point of view of what affordable housing is. There have been many angered people when they realize there's an affordable housing lot right next to their lot. And so it has been a long-standing practice that we don't disclose those lots or provide them. And that's why we have the Alex come to those meetings, so that in the event there's a question regarding affordable housing, she can answer those directly.
You're referring to Alexandra Ladd, the director of the City Affordable Housing Office?
Mayor Council, that's correct.
And I do, Mayor, I do have questions for her as well about this subject. But were you shown that final agreement before the Planning Commission meeting?
Mayor Council, I did see an agreement. I did not read it. I rely on that DRT member to identify whether or not they're in compliance with the affordable housing program.
Is it correct, Mr. Escabel, that one of the approval criteria in the city code for approval of final subdivisions is a demonstration that the subdivision will not create a nonconformity with provisions not only in Chapter 14, but in other chapters of the code that are applicable?
Mayor Council, there is a section within Chapter 14 that prohibits us from signing a plat that creates a nonconformity. I would have to read it exactly to see. As I said before, I don't have the code book memorized.
I believe it's been quoted in staff's report, so I'll move on. But before I leave this document, let me have you look at another one of these lots. Let's see, 24, lot 24 there. And I believe you said that actually the site plan actually identifies that as one of the affordable housing lots. Is that correct? Isn't that what you already testified?
Mayor Council, lot 24 is being represented as affordable housing.
And is it correct that looking at that, that lot, that's another lot that's completely surrounded by open space? That doesn't show any driveway access to the road coming off of Old Pecos Trail that would allow access to that lot.
I'm sorry, say that again?
I'm just looking at that, the depiction, and it appears to me that that lot, the illustrative 3,000 square foot building pad there in white with hash marks is completely surrounded by green indicating open space, therefore not showing any access to the lot from the road if the private open space requirements applied.
Mayor, council, as I indicated before, this was
I think we've covered this point, Mr. Throne. It's just another example, but Mr. Escabel has testified that this is, as you said, illustrative, and before anything would actually be recorded, the calculation would have to be done as you've already cited, unless there's an additional point to be made about this specific lot.
I'm just trying to point out two examples on the record, but let me ask you, I have one more, I think, question about this. Going back to that lot 5. Well, actually I have more than one question. Look at lot 5 and look at the, I'm sorry, I think a better example. Let's look at lot 1. You look at lot 1, which abuts West Zia Road. You see under lot 1, there's a indication with 2 arrows showing a width there in green. It says 7.5 foot public utility easement. See that?
Mayor, council, yes.
Did you understand that to be the width of that green section there where the arrows are pointing?
Mayor, council, yes.
Is it correct that the code, specifically section 14-7.5C4, states that the minimum dimension for private open space is 12 feet?
Mayor, council, private open space does have minimum dimensions. However, the open space for the overlay does not.
So you don't believe that the 12-foot open space minimum dimension applies here?
Mayor, council, it does not apply here.
You've read the section of the code that addresses the open space requirement in the South Central Highway Corridor Protection District and its purpose and intent, correct?
Mayor, council, yes.
And would you agree with me that the general intent here is to provide visual openness from the Old Pecos Trail for the community?
Mayor, council, yes.
I think that's all I have on that document. Correct, is it not, Mr. Escabel, that another of the documents that were submitted by the applicant to you and the Planning Commission on April 10th, 2023 in support of the applicant's application for final plat approval was his draft covenants, conditions, and restrictions known as CC&Rs?
Mayor, council, yes, that document is reviewed by our technical review division in order to ensure that they have adequate maintenance agreements associated with certain items that have to be maintained by any kind of association that are there. I did not go through the actual covenants and conditions, or since we don't enforce covenants and restrictive covenants.
And in fact, one of your DRT members, I don't know if I'm pronouncing her name right, is Dee Beingessner. Is that right?
Councilor Mayor, that is Dee Beingessner,
Beingessner.
as well as Jason Kluk, not Buck.
Oh, my apologies. Ms. Beingessner, in fact, in her DRT report that was attached as part of staff's July 2022 report to the Planning Commission, asked for the HOA documents to be provided, correct?
I'm sorry, say that again?
Well, I'm just confirming that one of the reasons why the CCNRs were provided as part of final plat approval was because Ms. Beingessner in her DRT report said the HOA documents were necessary specifically to make sure that there was a note on the plat regarding stormwater ponding and the maintenance obligations of each owner of the lot of each of the lots of the proposed subdivision.
Mayor, Council, that is what I said before. The maintenance agreements must be in place in the event there are maintenance of certain drainage requirements associated with the subdivision. And the association will have to take care of them. So those will have to be in the covenants or maintenance agreement.
And those draft covenants, CCNRs that were submitted, those were also excluded from the packet that the city published on June 30th for public review prior to the Planning Commission's July 6, 2023 hearing, correct?
Mayor, Council, I may have or may have not put them in there. I'm looking at it now. It doesn't look like I did.
And do you recall, oh, I guess you've already answered that you didn't read through the whole appeal petition, so I won't ask you if you recall. Well, let me ask you, did you get as far to read the part where we talked about the fact there's no mention of the open space requirements in the proposed CCNRs?
Mayor, Council, that would not be a requirement for anything that current planning division would require. Since again, we don't enforce the CCNRs. If there's a requirement that we're going to enforce, we will place them on the plat or somewhere in other documents that have to be complied with for the construction, development, or any kind of restriction that has to be met.
But aren't those CCNRs the document that typically buyers of lots refer to find out what kind of restrictions are maybe on the lot before they purchase a lot?
Mayor, Council, that's a private document between the seller and the buyer. We're not involved in the creation of those documents, other than to look at the maintenance agreement and the structure of the maintenance agreement and how anything that has to be made by the association has to be maintained.
Mayor, can we have clarification on what a CCNR is, please?
As I said, it stands for covenants, conditions, and restrictions. These are documents that if any of you bought a home, you get and you ask for a title binder so you can get title insurance. They list the documents of record for your lot. And since the developer has to record those documents, that's something that the buyers, hopefully they'll know, or they hire an attorney, look at to find out before they purchase the lot, what are the restrictions on this lot? And so I'm just trying to establish that what was presented to staff. I mean, I do understand that the city doesn't enforce CCNRs, they enforce notes, but this has to do with, notice to the public about what are going to be the restrictions on this lot, because this has to do with also this variance issue.
You answered her question.
Yes.
Please move along, Mr. Throne. I don't think we need to go into depth on what goes into the purchase of a home.
Sorry, just a point of clarification. So the city does not enforce CCNRs. Is that correct?
Well, I believe Mr. Escobar did testify to that.
That's
And
not, yeah, that's addressed to you, Mr. Escobar.
Mayor, Council, Councilor Castro, we do not enforce private covenants.
By the way, I'm not sure I covered this before, but you not only testified at the two hearings in front of the Planning Commission on preliminary plat approval, but you also testified at the July 6, 2023 hearing on final plat approval, correct?
Mayor, Council, I am the case planner.
And you were not placed under oath prior to your testimony or at any time during that hearing, correct?
Mayor, council, there was, I think, one or two times where the attorney had me go under oath during the rezoning portion, which was part of the preliminary plat project. But I was not sworn in for any of the planning commission review for this project.
For the planning commission, did you provide the members of the planning commission with, on this whole plan set and including the buildable, the open space area document that we talked about? Did you provide the members of the planning commission with, just the PDF versions, or did they get enlarged versions of those documents?
Mayor, council, we use the PDF version for all of our planning commission documentation.
Would you agree to me with me that and you have it on your screen, that the PDF versions are extremely difficult to read all the text on those because of the size?
Mayor, council, I have no problem reading the PDF version of anything that I produce. In fact, I OCR'd them because we had.
Mr. Throne, I'm not entirely sure how germane that is to this consideration. If you could stick to the code and the application of the difference between the preliminary and final plat. Readability is something that I'm not sure is germane.
Well, Mayor and members of the governing body, I believe the record reflects that actually Commissioner Smith at the July 6, 2023 Planning Commission hearing indicated that he was having difficulty reading plat and trying to understand what was on it. And
Be that as it may, I'm not sure that Mr. Escabel's testimony about the readability of the PDF is going to help the governing body achieve a decision in this case.
Is it correct, Mr. Escabel, that both in staff's July 2022 report to the Planning Commission and in staff's testimony to the Planning Commission regarding the preliminary subdivision plat, there was no mention at all by staff of any public lighting requirement for this subdivision?
Mayor, council, I don't believe that the lighting requirement requires planning commission approval. We did place it on the final plat as a courtesy to the neighborhood to allow them to understand that for safety reasons, our traffic engineer is requiring lighting. But if lighting questions are going to occur, I would rather have those questions directed to our subdivision engineer, who is imposing those conditions on the subdivision, rather than myself.
But it's correct that I think it's condition number 15, staff added as a new condition at the final plat approval stage, a public street lighting requirement for the first time.
Mayor, councilor, we did add the lighting component during the final plat.
And that was addressed at that hearing by Ms. Jane Gessner.
Mayor, council, that is correct, but as noted, I don't believe that the code requires that particular section to be approved by the planning commission. Again, those are questions that probably should be better directed to our subdivision engineer.
Trying to understand, Mr. Escabel, is if that condition was not required to be approved by the commission, why did staff add that as a new condition to be approved by a condition at the final plat approval stage?
Mayor, council, one of the hardest things to deal with as staff is after the final approval, after the plat's been recorded and the developer is coming in for a building permit. A lot of the times, code is going to require something, whether it was approved as part of the planning commission's deliberation or not, because it's a code requirement. We are obligated to fulfill the code. The mayor has his charter requirements. He hires people under them. They hire people under them. We interpret, educate, apply, and enforce. So unless the applicant has a variance before the planning commission that eliminates that section of the code, whether it was approved or placed on the report as a condition of approval, it's still applicable. And the reason why we reiterate some portions of the code, because we don't really have to make a code provision a condition of approval. It's already an ordinance required element that we have to enforce. We put them on in the report so that we don't have problems with the developer later to identify that it is a required element for construction. So it does have a benefit to the neighborhood because they get to see what that is. But whether or not it's placed on the plat, placed in the report, it's written into the ordinance, and we still have to enforce it, regardless of whether it's shown at the planning commission or not.
Now, regarding the benefit to the neighborhood, are you talking about the adjacent neighborhood, Solly Lomas?
Mayor, council, there are many aspects to benefit. One of them is health and safety. And if our engineer identifies that a light is required for health and safety, then that is a requirement that has to be met.
Is it correct, Mr. Escabel, that when you introduced Ms. Dane Gessner, and again, I apologize if I'm pronouncing her name wrong, you introduced her on Zoom to testify at the July 6th hearing. She didn't identify any requirement in the city code for public street lighting in subdivisions.
Mayor, council, I don't know what questions were asked of her directly. If the planning commission didn't ask her where in the code it was located, it may not have come up. I'm afraid I can't really answer that question.
And let the record speak for itself. But you were, there were 3 early neighborhood notification meetings at the very beginning of this process and you attended, I believe the second and third ones, in January of 2021. Is that correct?
I'm not familiar with the dates.
But you attended the 2 of those second one and the third ENN meetings.
Mayor, council, that is correct.
And do you recall in those meetings that one of the concerns that was raised by people who participated in that meeting was over public street lighting?
Mayor, council, I do remember there was some discussion about lighting. The applicant did not want to place the lighting as a direct result of the concern of the neighborhood. That is true.
And it as a matter of fact, I think staff has acknowledged, and Ms. Bing Gessner has acknowledged, that there's no public street lighting in the Solly Nolamis neighborhood that's adjacent to the subject property here.
Mayor, council, that would have to be directed to our subdivision engineer. I know I've traveled past that area several times, but to be honest, I just can't recall right now.
Condition number 11 for final plat approval, and this I believe was also on the condition for preliminary plat approval, required, and I'm quoting here, verification that the proposed public sewer line crossing the arroyo that bisects the subject property is allowed in an open space wildlife corridor. Is that correct?
Mayor, council, that condition was placed on there by by Stan Holland, who is the engineer for our sewer department.
Okay, and who is supposed to provide that verification?
Mayor, council, after speaking with Stan, he was not familiar with Chapter 14. There is no requirement or limitations for placing a sewer line over the open space. We have sewer lines in open space all over the city of Santa Fe, including some of the arroyos. The wildlife corridor was placed on there by the applicant. It's not technically a designated wildlife corridor by any government agency that I'm aware of, certainly not by us. It was placed on there in my conversation with Monica Montoya because it was based on a conversation they had with the neighbors. But in my investigation to figure out where that came from, it did come from the applicant. It is not a designated wildlife corridor by any means that we can find. And the open space will allow for the sewer line to cross. So in my view, as the case manager for this case, that condition has been satisfied to my needs.
Is there anything in writing that where you provided that verification that's in the record prior to to tonight?
Mayor, council, there's nothing in writing at this point in time.
Okay, and so I think if I understand your previous answer, the applicant had recognized or acknowledged that the Foothills Arroyo that bisects the property is currently functioning as a wildlife corridor. Is that correct?
Mayor, council, you'll have to ask the applicant that particular thing. My conversation with the applicant, when I asked, where did that come from? They said they placed it there.
And I know a lot of the comments, public comments that came in to the staff, I believe some to you, I don't know what you read or didn't, but comments from the public did provide information about how that arroyo operates as an active wildlife corridor. You recall that?
Mayor, council, no, I don't recall.
Mr. Throne, I'm trying to give you lots of time and lots of latitude, but I'm a little bit lost on the relevance at the moment and also how much longer you're going to be with this witness because we've already been at it for almost 2 full hours. So if you could narrow your questions for Mr. Escobar, I'm sure you have other witnesses you'd like to call as well.
Yes, and I thought I was showing the relevance by pointing out the condition number 11 that's in your packets. Was adopted by the Planning Commission.
Mayor, council, if I'm also not mistaken, that condition is to be done prior to recording, so it doesn't have to be done at this juncture.
Let's see if we can move along, sir.
Do you recall getting a letter, Mr. Escobar, from Monica Montoya, the agent for the applicant, on August 2nd, 2023, after the first Planning Commission meeting addressing preliminary plat approval, clarifying that the 18-foot height restriction that there was some controversy over would include parapets specifically.
Mayor, I'm sorry, I don't recall that letter at this point.
And so as you stand here today, you don't know whether or not there's actually an exhibit to the applicant's petition that contains that August 2nd letter.
Mayor, council, I would have to dig into my files to find it. At this point in time, there's so much documentation with this particular project to remember, and recall each and every one of them is a little tough at this point.
Well, I'll just let that document speak for itself. It's an exhibit to the appeal petition, but what I'm getting at here is, in terms of the height restriction, I want you to assume for the purpose of this question that Ms. Montoya, on behalf of the applicant, said, we'll make sure there's a note on the plat clarifying that the 18-foot high height restriction for structures includes parapets, and that's going to be put a note will be put on the plat saying that. And I just want to confirm that there's no note that appears on that final plat that's before the governing body today.
Mayor, council, with regard to the height requirements, I believe during the Planning Commission meetings, they did attest that they were going to limit the heights to 18 feet. That was also a concern of the Planning Commission. They did identify that they would place those notes on the plat. If they are not on the plat, they will be prior to recordation.
Well, there is a note on the plat now that says that there'll be 1-story structures are limited to 1 story and 18 feet, correct?
I'd have to, I was trying to glance very fast. I don't
Let me point it out to you. If you look at let me refer you to the sheet 2 of 2, which is the the fourth page of the April 2023 plan set. If you look at the under height restrictions on the upper left-hand corner, you see where it says single story only permitted, maximum height 18 feet.
Mayor Council, yes.
I'm just trying to establish that that didn't include the clarification that Ms. Montoya sent to you and to the planning commission, that it would include parapets. It doesn't say that, does it?
Mayor Council, that particular note is just limited to 18 feet.
And condition number 2 for both preliminary and plat approval and final plat approval, there was going to be inclusion of a note on the plat prohibiting walls and fences within 75 feet of the Old Pecos Trail setback, correct?
Mayor Council, that is correct. That was a condition required by our Assistant Land Use Director, Heather Lamboy.
And I believe that your staff's July 6, 2023 report to the commission said that indicated that the purpose of that condition was, and I'm quoting here, to address the intent of the general plan for the Old Pecos Trail Scenic Corridor. Is that accurate?
Mayor Council, while there is no ordinance in place for us to actually require that condition, we did fight for it with the applicant. So that was a negotiated condition, not a condition that we could point to by ordinance. And the applicant did agree to that condition. That's why we placed it.
I have no further questions.
Thank you, sir. Thank you, Mr. Escabel and Mr. Summer. I think our governing body members would like to take closer to 15 minutes and stretch and refresh and hit reset. And then when we come back, we'll resume. Thank you. We will stand until we resume in 15 minutes. Please come back then.
Test.
Zoom test.
Okay, let's see if we can come to order and resume, please. The governing body could come back to chairs and we will resume. Actually, Mr. Throne, you still have the floor. We don't switch who's doing the questioning. You get to complete your questions before we move to the other party. I'm looking at the clock. It's 8:45. We're going to try to get to a vote tonight if possible. I would encourage both parties to make sure that their questions are not redundant and that we are staying clear in the relevance of the questions to the matter that is directly framed before us about the final plat and the extent to which it does or does not conform to the preliminary plat. That is the matter before us. So there's lots of subsidiary issues. If we can really hone in on the core matter in front of us, I think the entire governing body is focused on that and will be paying attention to how the questions pertain to that central issue. So, Mr. Throne, you have another witness you'd like to ask to
Yes,
come?
Mr. Klug.
I believe he is available on Zoom. Madam Clerk, can he join us from Zoom? I also want to point out, we still have folks who want to speak in the audience and on Zoom. So the questions of staff is only one part of this process, nor has the governing body had an opportunity to ask any questions so far. So let's attempt to be really focused as we go forward. Is he on? Is there a way to see him on?
Hello, can you hear me? Yeah, I don't have video.
You don't have
capability.
video. Okay, I apologize. I thought you would.
Well,
Yes,
I personally do, but I'm not allowed to have video for some reason on this Zoom profile.
okay. As long as you're present and your voice is loud enough for us to be able to hear you. And I believe, Madam City Attorney, we're swearing in.
Mayor, councilors, to the extent that witnesses are testifying to facts, they should be sworn in. So
I don't think you have that card in front of you, Mr. Klug. Maybe we could provide that for you, although the clerk has had to step away from it to try to work on the technology.
Mr. Klug, can you hear me?
Yes, barely.
I'm going to read this if you can state, state it after I state what I'm saying. So it would be I, and state your name.
I apologize. I just rejoined as a panelist. I was allowed to do that, so now I can hear you.
Geraldine is back. She's going to do it.
All right, Director Klug, if you could please raise your right hand and state your name.
Jason Klug.
Do you solemnly declare and affirm that the testimony you have in reference to this item shall be the truth and nothing but the truth, and do this under the penalties of perjury?
Yes.
Thank you.
Mr. Throne.
Thank you. Good evening, Mr. Klug. Sorry
Yeah,
if
good
I've
evening.
mispronounced your name in the past.
Apologize. I can't be there in person. I've got a cold and I threw out my back, so.
It happens to me as well.
Sorry.
Is it correct that you testified at the Planning Commission's July 6th, 2023 public hearing on the applicant's application for final plat approval?
I apologize. I don't recall that. I may have made some comments during the course of the hearing, but I don't recall testifying to anything specific.
Well, you weren't sworn in at that hearing, correct?
No, not that I recall.
And so you, I believe after Mr. Escabel testified, you did make comments. And I think that's what I'm referring to, the statements that you made at that hearing, okay? Is it correct that one of the things that you stated at that hearing was to confirm Mr. Escobel's statements at that hearing that it is standard practice for the land use department to not add any required notes on a final subdivision plat until after the planning commission has issued its decision on whether or not to approve that plat?
Let me understand your question. To not add any required notes. Could you elaborate on what you mean by required notes?
Well, did you, is it correct that you stated at the planning commission's July 6, 2023 meeting that, as Mr. Escobel had testified, that the notes on a final plat that is recorded with the county are the primary mechanism that the land use department staff relies on to enforce the applicable requirements in Chapter 14 of the code and any conditions required by the planning commission?
I don't remember saying that, but I think the latter is true and the former is not necessarily true.
Explain what you mean by the former is not necessarily true.
So the applicant, if they wish to construct a building or a subdivision, they shall comply with Chapter 14. You know, we have enforcement measures from the day they come in, you know, review and approval measures and enforcement measures from the day they come in with an application in perpetuity forever. And, you know, different sections of the code address those, you know, regulatory authority.
But it's true, is it not, that when an applicant comes in for preliminary and final plat approval under the code, the applicant has the burden to show that that his proposed or its proposed subdivision complies with all applicable Chapter 14 requirements?
Staff has the burden to present a case for approval that we've seen. Pardon me. Yes, that we verified that the plat meets all codes, or, you know, we condition it thusly. And again, we have various points along the way where we can re-verify that, including, you know, up to and including enforcement of a violation to that.
My question is, though, whether it's correct that under the code, the applicant has the burden of showing the planning commission, which has been delegated authority to grant preliminary and final plat approval by the governing body, that the proposed subdivision satisfies all applicable provisions in Chapter 14.
Right, they have the burden of proving to the planning commission that they've met the criteria for the applicable land use activity.
And you, it's correct that you've testified before that the principal mechanism that the land use department staff relies on to make sure that all Chapter 14 land use code provisions and requirements that are applicable are satisfied. You rely on principally on the notes for that, correct?
We rely on what they've presented and on the conditions of approval and technical corrections. I'm not sure I'm answering your question. I'm not sure I understand it actually, but, you know, we are charged with making sure that a final subdivision plat that's offered for approval does comply with code. And that includes the conditions. And again, it includes our enforcement authority in perpetuity.
Have you reviewed the final plat submitted by the applicant that is presented to the planning commission for its July 6th hearing and is currently before the governing body?
Yes.
And do you agree with Mr. Escobel's statement that any notes that are required to be on the plat that aren't on the plat that is now before the governing body will be added after the governing body decides this appeal?
That's true. And they'll also be added prior to recordation and as applicable, you know, at time of building permitting, they'll be reviewed.
So, and you're familiar, have you been listening into the hearing thus far?
Yes.
Okay. So let's talk about these open space requirements. Well, first of all, I believe I heard Mr. Escobel acknowledge that neither you nor any of your predecessors have ever issued a written opinion stating that regarding property located within the South Central Highway Corridor Protection District, that the open space standards don't apply to property in that district because it's a separate section of the code. You've never put that in writing, have you?
No.
And you're not aware of any written opinion to that effect, are you?
No.
Okay. So let's assume that the governing body denies this appeal, and now you're in this area of time where you say that additional notes are going to be put on the plat. Regarding the open space requirement, can you tell the governing body today exactly what the note addressing the open space requirement will state?
I'm not sure I could do that on the spot, and I'm not sure it actually requires one, except for the fact that it does because of because it's the, you know, the highway corridor overlay. So that, you know, that I'm trying to avoid using the word that, you know, that trumps the other open space requirements, so to speak.
Mr. Mayor.
Supersedes is the word you're looking
Supersedes,
for.
yeah, thank you. Yeah.
hang on one
supersedes the other
sec,
requirements. So
Counselor.
yes, that'll be the only thing that's noted on the plat, and it will note that it has to comply with that section of the code.
Could you hold on one second? I think Counselor Cassidy either has a point of order or a question.
We have a lot of questions that are assuming scenarios. And I don't really want to assume scenarios at this point. You know, there's an assumption that Monica had said something, there was an assumption of this. I think that if we're going to be sticking with information, we need to be sticking with information and not assumptions. If we could please stick to really looking at these facts as opposed to assuming things. If there's information that we need to be directed to, please do. But just wanted to make that comment. Thank you.
Mr. Mayor, members of the governing body, any assumptions that I'm asking the witnesses that I question are a matter of record. You've been already told that you rely on the whole record. I'm not asking them to assume anything else. And certainly for the purpose of this question, let's go back to it. My question was, can you tell the governing body today exactly what additional notes will be put on the plat after the governing body concludes this appeal hearing?
How could I possibly do that right now? They haven't approved anything yet.
That's my point. I'm asking, so there's no record right now, either before the Planning Commission or this body in this appeal about what the notes have to state in the record, correct?
That's correct, and that's normal. That's how it's been done for at least 25 years that I know of.
Have you been with the city for 45 years?
I said 25.
I'm sorry, I misheard you. 25.
I've been working in this industry for around 25 years, probably closer to 30.
Is it your testimony that because this is the way the land use department has done it for X amount of time, that makes it in accordance with applicable provisions in the city's land use code?
I think that's a fair statement.
Mr. Throne, I think we can avoid argumentation and get to facts, please.
Is it correct that at the time you addressed the planning commission at its July 6th, 2023 hearing on the final plat approval application, that you knew at that time that the final plat presented to the commission did not include all of the notes that would need to be included on the plat?
I understand that conceptually. I work at a pretty high level, as you could probably imagine. I'm focused on the big picture, so I really don't get into that minutia unless I need to, unless it's drawn to my attention. But yes, I understand that conceptually that's true.
You understand at the time you addressed the planning commission that the final plat included project data indicating that the maximum lot coverage on each lot would be 40%.
Yes, I believe we discussed that.
So you understood that at that time?
I believe so.
Is it your understanding that under the city code, that 40% lot coverage could be increased to 50% if it includes private open space?
Right, but that's not on the table.
I'm just asking if the code provides that.
I'd have to look, but maybe Dan could answer that more quickly than I could, but I think that's correct.
I believe Dan already did answer that question, Mr. Throne.
Is it your understanding that in fact the applicant's March 2022 application report to the Planning Commission indicated that section of the code?
I don't recall that. Again, I'd have to look.
Let the record speak for itself on that one.
Point of information.
Counsel?
Can I just get some clarity on how this relates to the plat that we saw originally in the final plat?
She's asking your last question.
The line of questioning, yeah.
I was asking Mr. Klug if he knew at the time that he addressed the Planning Commission for final plat approval that it did not include notes on the plat that were supposed to be on the plat.
My understanding is we're looking at the final plat in relation to the plat that was initially provided.
Let me see if I understand your question, because this is another area with which the appellants disagree with the January 26 staff report by the city attorney. There was also, this part of it was repeated in Ms. Nook's PowerPoint presentation. It says there's only one issue for you to decide in this appeal: whether the final plat substantially conforms to the preliminary plat. Well, what the record shows and what I'm trying to bring out here is, and it's been acknowledged, that the applicant submitted a preliminary plat. There were all sorts of things addressed in that needed to be addressed for the final plat approval, and they didn't change anything. So if the city's position is that nothing has to happen between the preliminary plat stage and the final plat approval stage, and it's just the same plat comes through, what is the purpose and function of the Planning Commission in final plat approval? There has to be a change. That provision, substantial compliance, is a separate section of the code from the approval criteria section. And the purpose of that, I mean, should be obvious to this body, is you can't come in with a preliminary plat and say, I'm going to do 25 lots, as in the case here, and it's going to be laid out like this, and come in the final plat approval stage and show a subdivision that has a different number of lots or substantially different than what you proposed. But the notes of the plat, the idea that the notes on the plat don't change and that none of that happens until after the record closes, that is not a reasonable interpretation, and that's the point we're making.
And another point of clarification, just you have pointed out that there are significant changes from the initial plat to the second plat, including the A. So there are some changes, correct?
No, Mayor,
I really don't think we want to get into a back and forth here, but I think
I agree.
I think,
no, that's not, I need to clarify that because that's not what I said. We don't think there are any changes. In fact,
let's not, we really, this is inappropriate for right now. I think the original question that the counselor was raising was one that others on this governing body are struggling with, which is, as we follow your line of questioning from time to time, we are wondering whether the central question that we are seeking to address, which is to what extent does the final plat divert from the preliminary plat, doesn't always appear in the relevance of the questions you're asking, Mr. Klug, or others about their understanding of code. We really want to hone in on that particular issue.
right, and I understand, Mayor and members of the governing body, we disagree with how the city attorney has framed this issue. You have one issue. If that's the only issue, nothing changes from the preliminary to the final, which is not what the code says in terms of approval criteria. If that's the only issue, then I can imagine why you wonder why all these questions are coming in. We disagree. We don't think that's what the code says.
And I've heard that now, both in your opening statement and earlier this evening. I'm not sure you need to continue to make the point through the questions of our witnesses because you've made the point through your own testimony.
Well, Mayor, with all due respect, I think I'm allowed to add, I mean, if we're right and the city's wrong, these questions are very relevant. And I think that I need to make a record on.
I think you've made the record with Mr. Escabel, among others. I'm simply pointing out that I asked you earlier, asked the other representative that if we could avoid redundancy this evening, we'll all be very grateful. And some of this feels redundant. We get the points you're making, sir.
As a procedural matter, Mr. Klug, were you aware of the fact that when the city, excuse me, published on June 30th, 2023, its case packet for the Planning Commission, it did not include the applicant's proposed affordable housing agreement, that is the Santa Fe Homes Agreement, or his proposed covenants, conditions, and restrictions that were submitted by the applicant on April 10th, 2023.
I don't recall, but I would say that those probably were not in the packet, but I honestly, I can't recall.
Were you involved in any way, assuming it wasn't in the packet, and I think the record is the record, were you involved in any way in the decision to exclude those items from the packet?
No.
Okay. And whose decision would that have been?
I think it would have been the decision of the, number one, I'm not, I would need Alexander to speak to that, Alexander Ladd. I'm not sure that it's our prerogative to ask for it.
Was it your understanding that those documents were submitted by the applicant to support the applicant's application for final plat approval?
No, I wouldn't have looked at that.
So are you familiar, have you ever reviewed the April 10th letter by the applicant requesting final plat approval where the applicant says we're providing those documents to the commission at this time?
No.
Is it correct that the city's land use department did not provide any of the materials submitted by the applicant on April 10th, 2023 for public review until June 30th of 2023?
I need you to elaborate. I'm not sure.
What I'm talking about is the fact that, well, let's take it step by step. It's correct, is it not, that the applicant submitted all the materials that the applicant submitted in support of final plat approval on April 10th, 2023 to the commission through Mr. Escabel?
If I'm not sure on that date, but yes, that's how it would have happened.
And then do you recall that that I sent emails to you and to others in the land use department in May and June, asking for copies of that so we would have an adequate opportunity to review that material before the planning commission's hearing?
I get about 200 emails a day. So no, I don't. I know you've sent us quite a few emails, Mr. Throne, but I don't recall those.
Have you,
No,
have you,
I want to add, if you don't mind. Yeah, I definitely rely on my qualified staff to do their job. Even though the code cites the land use director, about 500 times in the code, my authority, I'm allowed to delegate that. And obviously I must delegate it in many instances.
so if the record reflects that none of those materials were published by the city for public review until June 30th, 2023, which was about 5 days before the planning commission's hearing on final plat approval, that wasn't your decision. That was made by somebody else. Is that correct?
I'm not sure it was a decision. It was probably just a process, just
Mr. Throne, I'm going to have to ask
natural-
again
the
what the
natural
relevance
process
of
of-
this. Hang on, Mr. Klug. You've asked the question, it's been answered. I'm still a little lost as to how it's relevant. If we can address some other issues at this point with the director, it'd be great.
Yes, I'll address the relevance. Relevance is we've pointed out in our appeal petition some procedural problems. And in this case, it has to do with, the opportunity to, provide a meaningful time and a meaningful way for people to respond. And that's what this is. That's
I take the point in general, but I'm with regard to this particular hearing, you've asked and it's been answered about when the material was in the packet.
Yeah, I don't think that we've been out of compliance with the OMA. I'll say that.
Did you review the appellant's appeal petition after it was filed on August 31st, 2023?
Yes.
And in fact, excuse me, you had to do that in order to determine whether or not the appeal petition complied with all the city's appeal requirements, correct?
That's correct.
And is it correct that you didn't determine there was any inconsistency or deficiency in the appeal petition in terms of complying with the city's appeal requirements, correct?
I don't know. I didn't, as you know, the valid basis is very broad.
Well, but under the city's appeal procedures, if you find any reason why you believe any of the appellants don't have standing, or there's not a valid basis for appeal, you're supposed to report that to the city attorney for further consideration, correct?
Yes, that's.
And you did not do that in this case, did you? I mean, you didn't say there are problems with this and we want the city attorney, we want you to address this.
So again, the valid basis is very broad. So yes, the appeal met, the basic valid basis. That doesn't mean that all the points were, things that we agree, should be appealable.
Understood. Now, my reading of the city's appeal procedures indicates that one of your duties as the director of the land use department, after you've determined that a appeal petition satisfies the requirements for appeal in the code, is that you are supposed to schedule with the governing body an appeal hearing date. Is that correct?
That's what the code says, yes.
And why did it take 4.5 months for you to schedule this appeal before the governing body?
There are lots of reasons for that. Number one, it was a very complicated appeal. You know, I think it was almost 2 inches thick when we received it. So that's a lot of information to go through. Also, we have dozens and dozens, if not hundreds of other land use activities happening at the same time. So I know there is a requirement to schedule the appeal as soon as practicable, which I feel like that's what we did, given the totality of our other concerns and duties.
And was it your understanding at the time, after you determined that it was a valid, or it was the appeal petition satisfied the requirements for appeal, that this was going to be what's known as a de novo appeal under the city's appeal procedures?
Did I know that?
Yeah.
Yes.
And did the fact that the appellant's appeal petition was 45 pages long with exhibits, and the fact that it would be a de novo appeal proceeding suggest to you that this was a hearing that would probably take more than a couple of hours?
I can't comment on that.
I have no further questions for this.
Thank you. We're a little bit, I think appreciate your stopping there. Are there others on your list, sir?
Yes. Ms. Bing Gessner.
Okay. Madam Clerk.
Can you hear me?
Ms. Bing Gessner, can you hear us or can you speak so we can hear you?
Yes, I can hear you.
You're very soft. You're going to have to be a lot louder to make it into our council meeting room.
Okay, I can hear you. Can you hear me now?
Not loud enough.
Oh. Let me try that. Is that better?
Much better.
Much better.
Okay.
But it has an echo. We're gonna have the city clerk swear you in now.
Okay.
If you'll please raise your right hand and state your name.
Dee Beingessner?
Do you solemnly declare and affirm that the testimony you have in reference to this item shall be the truth and nothing but the truth, and do this
Yes.
under the penalties of perjury?
Yes, I do.
Thank you.
Good evening, Ms. Bing Gessner. And again, I apologize for however I've mispronounced your name in the past. Now, it's correct that you didn't testify at the Planning Commission's hearing on the preliminary plat approval, did you?
I don't believe so.
But you did submit a report that was included in staff's report to the commission as a member of the city's, the staff's development review team, DRT, correct?
Yes.
And in that, in your report, you did not address any public lighting, public street lighting requirement, correct?
Correct.
And then you did testify by Zoom at the Planning Commission's July 6th, 2023 hearing on final plat approval, correct?
I believe so.
And as I recall, and I think the record reflects, the first thing you asked was, do I need to be sworn in? And Ms. Margaret Moore for the staff said no. Is that your recollection?
I honestly don't remember.
But do you remember whether or not you were sworn in?
I don't remember.
Okay. And then when you did make statements to the planning commission at that hearing, I believe you acknowledged that the Solly Lomas neighborhood, which is directly adjacent to the subject property, has no public street lighting. Is that correct?
I believe that's correct.
Just backing up one step, to your knowledge, did any other development review team member address public street lighting before the planning commission in connection with its hearing on preliminary plat approval?
I did not read Public Works DRT comments, but I don't believe that anybody else did. They are the ones that normally would.
Have you ever reviewed the planning commission's findings of fact or conclusions of law supporting approval of the applicant's preliminary plat?
I'm sorry, can you repeat that?
Yeah, I'm just asking if you ever reviewed the planning commission's findings of fact and conclusions of law addressing its approval of the applicant's preliminary subdivision plat.
I might have looked at it. I don't remember.
Well, do you recall whether or not there was any reference in that to any public street lighting requirement?
I don't believe there would have been.
I'm sorry, could you repeat that? I didn't hear.
Said she didn't believe there would have been.
Oh, there would have been. Thank you. And then it's correct, is it not, that staff's July 6, 2023 report to the Planning Commission addressing final plat approval presented for the first time a new condition number 15 requiring public street lights for this subdivision?
Yes.
Is it true that other than stating that new condition, the text of that July 2023 staff report did not address its justification or cite any code provision or other authority requiring public street lighting for this subdivision?
I don't believe it did, but I don't believe anybody asked, and I don't believe that is required to be put in.
And I believe you, when you did testify, you did not cite any city code requirement of public street lighting for this subdivision, correct?
I don't recall if I cited it or not. There is a city code requirement, but I might not have cited it then.
And I believe you testified at that hearing that the reason why you were proposing this condition, or staff was proposing this condition, was that your predecessor had received complaints from the community after subdivisions were approved because there wasn't public street lighting. Is that correct?
I don't recall if I said my predecessor or not, but I definitely have received complaints.
Okay, I believe we cited that in our appeal petition, but I'll move on. And then I know there's some reference in the staff report about, I believe, referring to the requirement of 2 public streetlights for the subdivision. In fact, didn't you testify at the Planning Commission's July 6, 2023 hearing that you believe that the city could get away, or staff could get away with 3 to 5 public streetlights in that subdivision?
Yeah, yes, it's most likely. We haven't done an actual evaluation of the engineering, and that would be required to determine how many streetlights would be necessary.
And was the reason why the staff proposed that condition to the Planning Commission was because it wanted the Planning Commission to approve that condition?
I don't think the Planning Commission has to, and it wasn't that I wanted the Planning Commission to approve it. It was that I wanted people to be aware that it was going to happen and is required.
And so it's correct that the first opportunity members of the community would have had to review and react to that new condition was after the city published its case packet for the planning commission on June 30th, 2023. Is that correct?
Yes.
That was the beginning of the 3-day 4th of July weekend, correct?
I don't recall.
Okay. That's all I have for Ms.
Very good. Thank you, sir. Do you have another witness?
Yes, Alexandra Ladd, please.
I believe she is present in the room. And if Ms. Ladd, Director Ladd, if you can come to the podium here and be sworn. Madam Clerk?
That if you'll please raise your right hand and state your name.
That
Do you
mic
s-
needs some help there.
Alexander Ladd.
Thank
Do
you.
you solemnly declare and affirm that the testimony you have in reference to this item shall be the truth and nothing but the truth, and do this under the penalties of perjury?
I do.
Thank you.
Good evening, Ms. Ladd.
Good evening.
You provided some statements to the planning commission at its July 6, 2023 hearing addressing final plat approval, correct?
I don't believe I would have addressed the final plat approval. My statements would have been concerning the Santa Fe Homes Program requirement and how it applies to this project.
And at the time you responded to some questions, I think one of them was from Commissioner Lucero, was asking about whether you knew where the homes, or the lots rather, in this subdivision that would be subject to the dispersal and other requirements in the Santa Fe Homes Program in Chapter 26. You testified that you thought they were indicated on the final plat. Is that correct?
That is not exactly correct. For the Santa Fe Homes Program, which at this stage is not an agreement yet, it's still in a proposal format, which is not legally binding. The point of the proposal is to articulate how the requirements for the Santa Fe Homes Program will apply to the project. I sign it, the developer signs it saying they accept those requirements. The proposal stays in the planning commission packet until final entitlements. So after the planning commission has determined its final conditions of approval. And that's at the point at which we execute the Santa Fe Homes Program agreement. So at the planning commission meeting, in terms of how the Santa Fe Homes Program approval of the agreement works, I would not have known which lots were indicated to be affordable. I know the applicant was there and the lots had been identified on the plat. That's not always the case. It's not always preferable to do it that way. So it wasn't my expectation that it would be done that way. So I did not know that until I was at the meeting. But that is completely normal. At the planning commission stage, we would not have those lots necessarily identified because we don't have a legally binding agreement.
Do you recall, after that record was closed in that planning commission out in the hallway out here, I actually introduced myself to you for the first time and asked you if you could provide a copy of the draft of Santa Fe Homes Agreement, and you said you would check into that.
I remember meeting you. I remember talking about the agreement. I'm sorry, I don't remember promises I made. And if I didn't follow up, as Mr. Klug said, we've all got a lot of stuff going on beyond this project. I know it's pretty front and center for the people in this room, but we've got other work to do.
Understood. You did follow up and I appreciate that. And thank you. And I was going to ask you next, if you recall that even though you said that the agreement had not been finalized, the Santa Fe Homes Agreement for the subdivision hadn't been finalized, In fact, do you recall that you actually sent me an email a few days later attaching a fully executed Santa Fe Homes agreement entered into on the 24th day of May, 2023 between Pierre Amistoy, a New Mexico limited liability company, and the City of Santa Fe Municipal Corporation.
I believe that is the name on the agreement.
And by the way, that's Exhibit G to the appeal petition. Now, that's the final executed agreement that actually it says it was recorded by the city, correct?
I don't believe it would have been recorded until the final development documents are recorded.
Well, I'm asking because, and you've never seen a copy of this?
Well, I've seen a copy of the agreement, but I don't, if it's recorded, it's because it was recorded along with the final development documents.
Well, that's what I'm asking about because, and I'd be happy to, if I can show the witness. I don't want to take advantage of the situation here, but I'm looking at the last page. It says SFC clerk recorded 6/23/2023. Now, assuming that's correct, and I'm not misrepresenting that to this body, does that indicate that it was recorded by the city?
So if that is a stamp from the county clerk, then it was recorded.
Right. And typically, that agreement is, you review it beforehand, is that correct? Before it's signed by the city?
Yes.
And then it's signed, I'm looking at agreements signed and sealed by the former city clerk, Christine Mihelczyk, sorry, signed by John Blair, manager. And that's also signed by, can't read who it is, it's illegible. It says senior assistant city attorney. But assuming that's what this document is that's in the record, okay? Well, let me ask you this. There's an exhibit attached to that. And the exhibit has a drawing of this subdivision. Did you ever see the exhibit attached to the agreement before it was signed by the city and recorded?
Of course I did, because I put it in there, but it's not, the purpose of that is illustrative to just give context for which project we're talking about. This is not, it's clipped from the very first concept. It's more of it can be a location map. It's just to provide context for the agreement so that we don't get two projects on the same street mixed up. It gives us a chance to be like, oh yeah, that's the one that's further down the road.
But it's correct, is it not, that nothing in the text of the agreement or on the exhibit A that is attached to that agreement indicates where the lots will be that will be subject to the chapter 26.
Mr. Throne, you're looking at it. I don't remember what it looks like. I can't answer that question, but if it says it, it says it. If it doesn't, it doesn't. Can you get to the point of this question? Because I'm not really sure what you need to hear from me.
Well, I'm happy to
I think the last part of her question is the one we're all waiting for, which is there a relevant question behind this line of questioning so she can help answer the fact question you're raising?
Sure. The relevance is that the approval criteria in the city code says that you can't have a subdivision, okay, that may create a nonconformance with requirements in chapter 14 or other chapters of the city code. Chapter 26 is one of those other chapters. What I'm trying to establish is, because I believe the record clearly reflects that Ms. Ladd testified that the agreement hadn't been finalized. She then sent me the agreement, and I'm trying to find out, how is there an enforceable agreement here that shows not only the commission, but this body, that there's going to be compliance with the dispersal and other requirements in the city code? That's the relevance.
Mr. Throne, I don't believe I testified to the status of that. If the agreement was finalized and recorded, that puts a restriction on that property. So any transfer of title on that property, that agreement is is invoked. It can't, the whole point of recording it is to put a land use restriction on the property.
But it doesn't tell you which lots are going to be subject to the requirements, does it?
It doesn't matter at this stage. It matters when we issue the fee waivers for the individual lots and when the individual home buyers are income certified to purchase those lots. Purchase the homes that are built on those lots.
Isn't this agreement the only enforceable agreement the city has to enforce the applicable requirements for, under Chapter 26, Santa Fe Homes Program?
It's a restriction on the title. So the developer, if they do not comply, we can hold building permits up. There's a whole section in the code that talks about how we can ensure that the requirements are met.
Did you understand at the time that you reviewed this, that 4 of the lots, as has been testified earlier in this appeal hearing, that apparently were designated in the site plan as the affordable housing lots, were going to be adjacent to a FEMA designated flood zone?
Mr. Throne, that is not part of the affordable housing agreement necessarily, so it's not something that I would review.
But isn't there,
What-
sorry, did you?
Yeah, if you look at Exhibit B, you'll see the pricing schedule. That's the part that I care about.
Well, what I'm concerned about or asking you about is the provision in the agreement, section 2.4 of the agreement, where it says agreement to sell at the SFHP home price. This is standard language you put in these agreements, correct?
That's correct.
Yeah. And I think we had a discussion, you may not recall it, in the hallway about if the builder puts any additional cost requirements on the buyer, who's going to be the qualifying Santa Fe Homes Program applicant, that you felt that the agreement make sure that they're protected, so those costs are not borne by the Santa Fe Homes qualifying applicant. Correct? Isn't there a provision in there that addresses that?
Well, that would be the purpose of the agreement.
Right. But isn't it true that that provision only applies to additional costs that are imposed by the homeowners association?
I guess I don't understand what you mean by additional costs.
Well, I'm looking at the provision in section 2.4A of the agreement that's in the record. It says the affordable, I'm quoting, the affordable home price and shall be reduced in order to limit the impact on SFHP homebuyers of fees assessed by condominium, common area, or homeowners associations, period. The affordable home price shall be reduced so that the buyer's mortgage or manufactured home loan principal amount, and accordingly the buyer's monthly mortgage payments, are reduced by an amount equal to the assessed fees in excess of $75, period. Additionally, the SFHP developer / successor in interest agrees that the association's bylaws will identify limits to annual fee increases for the owners of affordable units so that increases do not exceed 5% annually or 10% over any 3-year time frame, period. End of that section. Now that's the boilerplate that's in all your agreements, correct?
That's correct.
That provision would not protect those buyers, for instance, if their lender requires them to get flood insurance because they have lots adjacent to a floodplain.
The piece of financing, I mean, that process is completely separate from this process.
Counselor Lindell.
I don't see why we're talking about where affordable houses are placed or a flood zone, how that applies to this appeal. I think we're way out in the weeds on this. And it's not relevant.
Mayor, I believe they are, but I'm not going to argue. I'm just going to move on.
That would be true.
We disagree with how narrowly the city
I
attorney.
think we've heard that.
signed this.
That's
Yes,
in the record, sir, and
I'm responding to the,
I understand, and the part of your sentence I really appreciated was you were going to move along.
let me ask you one more thing about this. At the time you reviewed this agreement and where it says that the agreement is between the city and Pierre Amistoy, a New Mexico limited liability company. You saw that when you reviewed it?
If that's the name that the developer gave me, that's the name that goes into to the agreement.
And I will represent to you that this is signed by Pierre Amistoy, but not on behalf of any limited liability company. But my question to you is, at the time you looked at that, did you check with the Secretary of State's record to see whether or not at that time there was actually in existence a company registered as Pierre Amistoy Limited Liability Company?
Generally, we check to make sure that the entity we are going under contract with is in good standing and exists. I can't speak exactly to remembering that I did that or didn't do that.
So at least as of today, you don't know whether or not there such an entity existed at that time.
I can't answer that.
Good. That's all I have from Ms. Ladd.
Thank you, sir. Thank you, Director Ladd. Mr. Throne, you have another witness?
Don't, let me just double check. I don't think so, if you're not going to let me question Ms. Nook.
Very good.
I think that's all we have.
That completes it. Thank you, sir. Appreciate it. And I appreciate your willingness to move on and not argue the points. We understood what you were saying, and we appreciate what you're trying to, the argument you're making. I believe it's the opportunity now for the applicant to question staff as you wish. Same request.
And same time limit? Just kidding.
Well, we've tried to be reasonable and and capacious, so if
I
you
will-
have things you want to cover, please do.
I'm going to move as quickly as I possibly can. Why don't I just start with Ms. Ladd? I have two questions for her since she's here. And
Director Ladd, you're still under oath.
Ms. Ladd, just two questions. If an affordable housing agreement is signed and recorded, could you describe for the council what process you've got, your office and your staff has gone through to get it to that point? Attaching the exhibits, making sure about the property, just briefly describe that for them.
Sure, I think the initial work really is pulling together the information for the proposal, which is looking at the number of units and where the property is located and getting the names of the people signing it. And then when it comes to the agreement stage, we've waited to make sure that nothing's changed in the entitlement process, that lot's been removed or condensed or something. And then we update any information that may have changed from the proposal stage because our pricing schedules change every year. They get updated when the area median income data changes. So we do all those updates, put the exhibits together, and then send it through the city approval process.
It's that system. It goes to whose office from your office after you've done all that work?
It goes to the city attorney.
That agreement is signed by the city clerk, the city attorney, by your office.
My office does not sign the agreement. The city manager signs the agreement.
Okay. And then after it's been through that, That process has culminated in a proposal, a draft agreement, circulating that agreement, signature by everybody, and then recording, correct?
That's correct.
And in this case, was that process followed?
The agreement has the recording stamp on it, so that process was followed.
And is this property encumbered by the Santa Fe Homes program to require 5 affordable houses on this lot?
Yes, it is.
Thank you, Director Ladd.
I just have some questions for Dan Esquivel.
Mr. Escabel, are you still with us, sir?
I'm going to give him some documents so he could look at them and we'll talk about them.
Okay. Mr. Escabel, you're still under oath, sir.
Dan, you testified that you had testified at the preliminary plat and rezoning hearings, correct?
Mayor, council, that's correct.
You also testified and produced staff reports at those hearings, correct?
Mayor, council, that's correct.
And you did the same thing at the final plat approval, correct?
Mayor, council, that's correct.
Is the information that you provided to the planning commission at those hearings and to the city council, because it was appealed, was information true and accurate to the best of your knowledge and information?
Can you repeat that again, please?
Was the information you gave true and accurate to the best of your knowledge and information?
Mayor, council, the information that I provided was true and accurate to the best of my abilities, yes.
Is that the same with respect to the final plat approval that you gave? I mean, not final plat approval, final plat memo and testimony that you gave to the planning commission?
Mayor, council, to the best of my ability, that is correct.
Dan, in front of you, I gave you 3 documents. One of them is is your memo from July 7th, 2023. The other 2, one of them is the findings of fact and conclusions of law from the planning commission, in this case, the final plat approval. And the other is the final findings of fact and conclusions of law from the planning commission for the preliminary plat. Do you see all of those?
Mayor, council, yes.
Would it be fair, we're here on an issue, what do you understand the single issue or the issues that we're here to determine that the planning, the city council has to determine?
Mayor, council, that was my first question initially, is that the final plat substantially complies with the preliminary plan.
I'd like you to look at the preliminary findings of fact and conclusions of law for the preliminary plat. Now, that wasn't appealed by Mr. Throne and the current appellants, correct?
Mayor, council, as far as I know, it was not appealed.
So if you would look at page 2 of that and look at paragraphs 11 and 12, 13, 14, 15, and 16. Do you see all of those?
Mayor, council, yes.
Those are the criteria for the approval of a preliminary plat by the planning commission, aren't they?
Mayor, council, that's correct.
And the planning commission in these findings of fact concluded that they had been met, correct?
Mayor, council, that's correct.
And one of them is, number 11 is that, number 12, that under section 14-3.7C1, that the commission finds that due regard has been shown for all natural features and vegetation. Do you see that?
Mayor, council, yes.
So all of these findings and the criteria were not appealed, correct?
Mayor, council, not to my knowledge.
And so at the planning commission preliminary hearing, you advised the planning commission that the open space had been addressed to your satisfaction, not by virtue of code, but to demonstrate to you, Dan Esquivel, whose job it is to make recommendations, that they had provided you sufficient information to allow you to conclude that the open space requirements under the highway corridor and those on the lot for open space could be met under this proposal, correct?
Mayor, council, based on the conditions, what they provide me, that is correct.
And that document they provide you, you got asked for about an hour and a half about this green, the green stuff here, right?
Mayor, council, that's correct.
And Mr. Throne pointed out to you, well, there's some lots that don't have any driveways to them. There's these two lots, right?
Mayor, council, that's correct.
And so the little pieces of the driveway could easily be made up by moving these buildable areas up to create more open space and making those connections, correct?
Mayor, council, that is correct.
If you had seen that none of the driveways were included, or that there was some other discrepancy that couldn't be made up, would you have brought that to their attention?
Mayor, council, that I would have.
You concluded that based on the code requirements for open space in the corridor and on lot, insofar as the final plat was required, they could meet this requirement, correct?
Mayor, council, that is correct.
And the planning commission said they agreed with you, correct?
Mayor, council, that is correct.
And then in final, so they said, we believe that it could be met. Is there any code provision that says you or the planning commission must place a note on the plat that says anything about open space? Is there any code requirement that requires that?
Mayor, council, not to my knowledge right now.
You do it as a matter of practice because you want the public to know, hey, when you buy one of these lots, there are open space requirements and they're not your run-of-the-mill open space requirements, correct?
Mayor, council, that is not accurate.
Okay, why do you have a note on there?
We place notes on the plat so that when the construction comes in, we are able to enforce a condition of approval that was adopted as part of the final plat approval.
So it's a mechanism to help staff look at it and say, did you meet this? Did you meet this? Did you meet this, right?
That is correct.
If the note is not there, staff still has the requirement to say, did you meet this? Did you meet this? Including open space, correct?
Mayor, council, yes, but when you realize how many building permits come across the line, it is a lot easier to manipulate those site plans or surveys that come in to show legal lot of record, what those conditions are, rather than having to pull the files, pull the minutes, pull the findings, pull the memo, and try and look for conditions. So we make it easier on the staff so that all of the conditions are at their fingertips so that they can be complied with.
Kind of like a checklist for staff, right? If I get a building permit on lot 5, the subdivision plat comes in and I look at these conditions and I say, boom, 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 right? Are they there and then been met? Correct?
Mayor, council, yes, but it also does act as a notice to the applicant that they do have to design their drawings in accordance with that condition.
And open space requirements for a particular lot. All of the open space requirements are determined when you get a building permit, correct? When you apply for one, correct?
Mayor, council, that is correct for private open space, not for the open space required by this overlay.
Right. So you would have required, if a permit came in, if private open space was triggered, that they had to comply with it at that time, correct?
I'm sorry, say that again.
So if somebody came in and the private open space requirements of the code were triggered on, you would make sure that they complied at the time of building permit, correct?
Mayor, council, that is correct.
And the lots would already have been determined to comply, correct? By the notes and the technical modifications you would have made on the plat, correct?
Mayor, council, that is correct. Like I said, we don't have to condition the code. The code is an ordinance and enforceable on its own.
And in fact, the first condition of approval on the final plat that was submitted to you in June says, property development is required to comply with applicable provisions of Chapter 14 Land Development Code and subsequent amendments. It says that right on the plat, right?
Mayor, councilor, that is correct.
So if there is a provision of the code, like lighting, or excuse me, like the drainage calculations that don't show up on this plat, the drainage retention calculations, that note says, hey, you have to comply with this, correct?
Mayor, council, that's correct.
It would be impossible to put all the requirements of chapter 14 on a plat to notify people, correct?
Mayor, council, that is correct.
I don't know if you were at the January 31st hearing, but I in my opening described a process that might be easy to determine whether or not the requirement of substantial conformance has been met. And what I said was, we could take the three documents in front of you and say, we have a preliminary plat approval, findings of fact, and it has what the conditions are. We have a final plat approval that says what the conditions are, and we have your memo for the final plat as to what the conditions are, correct?
Mayor, council, that's correct.
And this council could look at those three documents, particularly the conditions of approval on the final plat, to determine, did Dan make sure that the conditions of approval in the preliminary plat followed through to the final plat? And were they placed in a place in terms of time, the conditions, the meeting of those conditions, in a way that we are in compliance? Isn't that one could do that? Let me rephrase that, was a bad question. So if I were to look at the findings of fact and conclusions of law for the preliminary, I would determine that there were conditions of approval, right?
Mayor, council, that's correct.
And if you look at those conditions of approval, one of the things that it says, and it says specifically, considering the foregoing findings and conclusions, the commission approves a preliminary subdivision plat subject to conditions, right? And those are conditions that are found in your memo, correct?
Mayor, council, that is correct.
And those might be conditions that were imposed by the planning commission, correct?
Mayor, council, that is correct.
And in this case, the planning commission did not impose any additional conditions beyond the memo, the suggested conditions that your memo talked about, correct?
Mayor, council, that is correct.
So they didn't say, Dan, as a condition of our approval, we want to make sure that when you come in here for final plat, or they come in here for final plat, these notes will be on the plat, walls and fences, correct? That's not what they said, correct?
Mayor, council, walls and there was a condition about fences that was placed in my report.
Yep, but the timing of that was before plat was recorded, correct?
Mayor, council, I believe that's correct.
So the planning commission's preliminary approval said, you must place this note and you must do it before the plat is recorded, correct?
Mayor, council, that's correct.
And then in the final approval, they had the same note and the same timing, correct?
Mayor, council, that's correct.
And the same thing was true with respect to open space, correct?
I'd have to refresh my memory, but I believe so.
Look at your memo. And if you look at the first page, the first condition on that memo deals with the open space condition that was in both the preliminary and the final.
Mayor, council, that's correct.
And the timing of that compliance for the applicant is at the time the plat is recorded, correct?
Mayor, council, prior to recording the plat is what it says.
And when the planning commission said that it approved it, it also approved it not just subject to the conditions, it approved it to technical corrections set forth in the staff report, right?
Mayor, council, that's correct.
What is a technical correction?
Those are corrections that require the applicant to modify conditions on the subdivision plans.
One of those would have been this open space showing a driveway, correct? Showing a driveway, showing a driveway to each buildable area, correct?
I don't recall that condition. I'd have to.
No, I'm asking whether that is the nature of the nature of a technical correction that you would have said, you got to show this here.
Mayor, council, that's correct.
A technical correction would also be that if it is fairly standard practice that on the final subdivision plat, the survey itself, it is required by your division to make sure that plat shows what is an affordable house, right? What is an affordable lot, correct?
Mayor,
Sorry,
council,
can
we do
Can
not.
you rephrase that question?
Sorry.
It went by,
I'm sorry. So one of the one of the things that your division requires is on the final plat on the survey that the lots identify which one of them are subject to affordable housing requirements.
Mayor, council, if that was a requirement by our Affordable Housing Division, I would require that on the plat. Otherwise, we would not require that on the plat since that goes through a separate process.
And are you familiar with this site plan that was submitted as part of the final plat set?
Mayor, council, I am.
And it shows 5 affordable houses, doesn't it? Well, 5 affordable lots, correct?
Mayor, council, that's correct.
And they all are the lots that have an A by them on that site plan, correct?
Mayor, council, that's correct.
We're asked a lot of questions about, well, hey, the recording of this final plat at the county clerk's office requires that they be an attestation and an acknowledgement in order to be recorded. Do you remember those questions?
Mayor, council, vaguely.
And you said, look, we determine what gets recorded. And what gets recorded is what we say recorded. And if I say a site plan is going to be attached to this set, a site plan is going to be attached to this set, correct?
Mayor, council, that is correct.
So if you needed to show open space requirement being met, as you've talked about, or you needed to show anything that is part of this set, you could require, and sometimes do require, that site plans, development plans, all get recorded with this plat, correct?
Mayor, council, that is correct.
I'll note for you on the plat that is submitted as a final plat, I see a lot of staff signatures. Do you see that? It's the first page of the plat, sheet 1 of 1.
Mayor, council, yes.
So you see all those signatures? None of them have acknowledgements, do they?
Mayor, council, that is correct.
And those are the technical review people who have looked at the plat to make sure all of their conditions have been imposed on this plat or whatever sheet is going to be imposed, correct?
Just to make sure you're talking about the actual cover page of the sub.
Right.
Mayor, council, that is not necessarily accurate.
What's
The
inaccurate?
signature page or the signature block for the subdivision is to identify that the city has approved the subdivision plat. It has it's required to have we require it to have information about the case. But the city planner and the city engineer will give their final signature identifying that all conditions, all relevant requirements have been made, placed on the plat. The applicant has filed their financial guarantee. Everything is ready to be recorded. And the signature of the city planner, which is Maggie Moore, and Dee Beingastner for the subdivision engineer, would then be placed on the subdivision so that we can take it to the county clerks and then get it recorded.
Those signatures are not acknowledged. They're not acknowledged by anybody, correct?
They're not.
And the plat gets recorded, doesn't it?
Mayor, council, yes.
Sheet 2 of this survey doesn't have any signatures on it, does it?
Mayor, council, that's correct.
And it gets recorded, doesn't it?
Mayor, council, that's correct.
And if you say, I want a site plan recorded showing the open space and the development and the the building envelopes, that gets recorded just like the second page, correct?
Mayor, council, that is correct. Just so that you know, the post-development review requires all the planners to make sure that the subdivision plat is recordable ready so that the county clerk will accept the final document for what they need. So we make sure that we manipulate each sheet that has signatures or required signatures, conditions of approval, even notes that will reference additional documents of the subdivision in the city map room, so that it can get recorded and everything is able to be found.
Now, the requirement, the document you have in front of you, which is the findings of fact and conclusions of law for the final plat, that shows what the conditions of approval were from the planning commission for the final plat, correct?
Mayor, council, it incorporates the conditions.
And those conditions are found in your report, correct?
Mayor Council, that's correct.
including the timing of when they're to be complied with, correct?
Mayor Council, that's correct.
So when the planning commission approves, when it grants final plat approval, it has all of the conditions of approval, including what notes need to go on the plat, the time that they need to go on the plat, and any other condition that needs to be complied with whenever it needs to be complied with, correct? So you talked about construction, correct? That might be a condition of approval, but it wouldn't show up then, correct? I have way too many questions. Let me start that over. The planning commission, when it approves a plat, when this packet goes in front of them, this is the final plat as far as you're concerned, correct? It includes and incorporates all of the engineering.
Mayor Weber, can we just make sure the witness is responding to each question? I didn't hear an answer.
We got for the record, a head shake won't show up in the record.
Sorry, Mayor. Yes.
This whole document includes what you call the final plat, correct?
That is, Mayor Council, that is correct.
And if Ms. Beingesser determines that she wants a particular engineering detail shown in the plan set to be recorded, she can require it and you can require it, correct?
Mayor Council, that's correct.
And that would be found in what was approved as part of this plan set, right?
Mayor Council, that is correct, but that is not the whole truth.
Okay.
Because the planning commission doesn't always require notes on the plat as part of their approval. It is the staff that will determine what kind of note goes on the plat for our purposes in order for implementation of conditions and enforcement. So for instance, many of the fire marshal comments are technical corrections. Those are going to be placed somewhere within the plan so that they can be implemented instead of just out in the ether as a condition of approval. There has to be some mechanism to be able to go back, find, locate, implement, and enforce.
Let's go to the lighting requirement, all right? That showed up in your planning report. It was a requirement, a request to be required to be shown on the plat by Ms. Beingesser for the reasons she talked about, correct?
Mayor Council, that's correct.
And if Ms. Beingesser had reviewed the final set of plans and said, I want the location of the lights, the street lights shown, could she have required that as a technical correction?
Mayor Council, yes.
And in this case, she might well do that, wouldn't she?
Mayor Council, I can't speak for,
I guess what I'm asking is, she could require it as a technical correction and it would show up on the plat, correct?
Mayor Council, that seems reasonable.
And you wouldn't take that back to the planning commission and say, hey, you gave us an approval and we didn't show the lights on it. And now we're going to show the lights on it. Will you please approve that? You would never do that, right?
Repeat that again.
You would not take that technical correction back to the planning commission and say, you know, on this survey and these plans, we're going to now show some lights. We want you to approve that. You wouldn't do that, would you?
Mayor Council, no. Mayor Council, just to be within the land use administrator's authority, he does have the ability to modify master plan subdivisions, development plans, special use permits.
And the reason that the example I gave would work, I mean, would be authorized by the planning commission without additional approval is because their approval for final plat says, subject to the staff report, conditions and technical corrections imposed preliminary stage. Technical corrections, you have the ability to do it under the approval, correct?
Mayor Council, yes.
Mr. Summer, I'm going to ask the same thing I asked of Mr. Throne.
I'm gonna
You can,
narrow it down and we'll finish here in about 2 minutes.
I'm not urging you to finish in 2 minutes, but I do think
Yeah,
that we all need to know where you're going and
I'm gonna finalize this with, now, Dan, you've been doing this for 17 years here at the city?
For the city, yes.
And before that, where were you doing it?
Before it was on my own, and before that, I resigned from the county of Santa Fe as associate planner.
How long were you there?
10 years.
For 10 years at the county, 17 years here doing this kind of review?
Yes.
And the term substantial, whether a plat substantially conforms have you had to apply that term in the course of those 27 years?
Mayor Council, yes.
In this particular instance, the number of lots in this subdivision on the final plat conform to the preliminary, correct?
Mayor Council, yes.
The layout conforms, correct?
Mayor Council, subject to conditions, yes.
I mean, what I'm saying, the layout, the street layout has been modified to conform to the planning, the approval, correct?
Mayor Council, yes.
When it was stated earlier that there hadn't been changes, the streets have been changed to conform to the preliminary, correct?
Mayor Council, yes.
The amount of open space that was proposed and is required under the preliminary and final, they're the same, are they not?
Mayor Council, yes.
And the entrances and exits to this subdivision are exactly the same in terms of their location, correct?
Mayor Council, yes.
Is there anything that you can think of from the preliminary approval of the plat, as shown by the findings of fact and conclusions of law, that does not conform in any of the slightest degree?
Mayor Council, that's a hard question to answer because as I am human, there's always the possibility that somewhere down the line, I'm going to find out years from now that I missed something. So I don't know how to answer that one.
And my last question was, you said you stopped working on this because an appeal was filed, right?
Mayor Council, that's correct.
Tell the council that had this appeal not been filed, what you would have done to make sure that all the conditions would have been met. What is it that you would have taken under,
Mayor Council, once the preliminary plat is approved or the final plat is approved by the Planning Commission, we move into a post-review process. That post-review process requires me to set up a signature sheet for all of the development review team to sign once they finalize their conditions with the subdivision plans, making sure that all of their conditions, all of their design criteria required by technical corrections, all of the infrastructure is meeting all of the required code sections. Once they are happy with those signatures, then they sign that sheet. It is sent back to me. My final review is to look at all of those conditions to make sure that they're not overlapping and causing conflicts, manipulating the plat so that it can be recorded with the county clerk's office and has a reference to all of the rest of the maps in our map room so that the construction drawings can be used for construction purposes. Once they file an engineer's cost estimate and our subdivision engineer approves that engineer's cost estimate, they are required to file a financial guarantee. Once the subdivision engineer approves and accepts that financial guarantee, we give it one more look over, present it to the planning manager and the subdivision engineer for signatures. It then goes to our map room, they schedule a recording, and it gets filed in the county clerk's office and filed in our map room.
in the process that you just described, what level of communication and interaction would you have had in this case with Orlin Guerrero Ortiz and Monica to comply, to make sure that this complied?
Mayor, council, we would have been in constant communication to make sure that the plans were brought up to speed and up to date, meeting all relevant conditions of approval.
I have no further questions for him.
Thank you. Thank you, sir. Do you have others? Mr. Summer, you had both Director
No, I have
Lat.
no further questions for any of your staff.
Thank you. Thank you, sir. At this time, I know there have been people who have been waiting quite a while for the opportunity to speak to this issue. We'll now take sworn public comment. If you want to be sworn and make a comment, please come forward to that podium there. And we'll accord anyone who wishes to speak the opportunity, and we'll accord the same to anyone who's on the Zoom call as well. And we'll ask the city clerk to keep time and treat everyone equally in terms of the amount of time that's provided for folks to address the governing body. And Madam Clerk, I'll wait for you to tell me you're ready, and then we'll swear. I wonder, can we do a group swearing? Do we have to do them individually?
Sorry, Mayor, I have this at the podium that they can read.
Okay, we'll do it individually.
I, Peter Ives, residing at 140 West Zia Road, Santa Fe, New Mexico, 87505, solemnly declare and affirm that the testimony I have in reference to this item shall be the truth and nothing but the truth, and do this under penalties of perjury. I begin by saying it's a pleasure to appear before you, Mr. Mayor and councilors, on this matter. I do have some printed testimony, which I thought our deadline was 1 p.m. to submit this, but with your permission, I will provide a copy to the clerk for the record, and I can certainly give Carl one as well. So Bruce has covered most of the points that I cared to make, but there were some other items within the code that I just wanted to make sure you were considering as you were deliberating here tonight. In the code 14-3.7B4, subsection E, it addresses the Planning Commission review and decision process for final plats. So subsection 1 states that the Planning Commission shall approve or disapprove the final plat within 30 days of the date it first considers the complete submittal. So we have this question of what is a complete submittal of a final plat? And a good deal of the testimony here tonight has described an approval of a final plat, which goes before the commission and also comes before this body, which is subject to being modified in numerous ways after it is approved. And it's hard to conceive that you are called upon to act upon a final plat when in fact you are approving a plat which might be subject to significant revisions by various parties within the city. And so pointing that out. Second, if the final plat, this is subsection 2, it says if the final plat is approved by the Planning Commission, the approval shall be recorded on the face of the original drawing of the final plat. The approval shall be dated and verified on the original drawing by the signature of the chair and secretary of the Planning Commission in spaces provided. So that original drawing is what is required to be filed of record. So you aren't getting the final drawing at this hearing. You're getting something that is subject to subsequent modification. So I would merely end by saying the code at its in that section on appeals, when it stops, I appreciate the additional time, says interpretation of this section shall be made in favor of a party's opportunity to be heard at a meaningful time and in a meaningful manner. Procedures shall adhere to procedural due process. You expect appellants to be able to comment on actions on final plats that are still subject to significant change. That makes it very difficult to prepare a case to, if you will, meet the requirements of substantive and procedural due process, as well as to create a record on appeal. So I think the only way to cure this is by sending this back for a final plat with all those things.
Thank you.
Will then be subject to final action.
Thank you,
Thank
sir.
you, Mr. Mayor.
Thank you very much. And if there is a written document you wish to distribute through the clerk, we'd be happy to have that.
I, Orlin Gadet Ortiz, residing at 700 Juniper Drive in Santa Fe, solemnly declare and affirm that the testimony I have in reference to this item shall be the truth and nothing but the truth, and do this under the penalty of perjury. My main purpose of coming up here is to be officially sworn and so that you can ask me questions, because I guess that might come up. I am the project engineer. I own Design Ingenuity. So I'm the civil engineer of the project. So the main purpose for me standing here is so that if you do have questions for me, you can actually ask them. I did want to state just a couple of things. It was stated by Mr. Throne that there were no changes made between preliminary and final plat. That's just incorrect. There were a lot of changes made. They may seem minor for you guys to find, but they're buried in there. There were a lot of technical corrections that had to occur, and they did. And, you know, if I had to get the DRT signatures today, I would bet dollars to donuts, that I'd get 80% of them based on this set of plans right here. There are, additional notes that have to happen. There are some additional things that need to happen, but they're not substantial. They're very minor details that need to be taken care of before we can record. And so I just wanted to make that point, and thank you.
Thank you. Yes, you have the floor. You need to swear yourself in there.
Yes, my name is Patricia Lillis. I reside at 2119 Conejo Drive. I solemnly declare and affirm that the testimony I have in reference to this item shall be the truth and nothing but the truth, and due under the penalties of perjury. I'm very sleepy, sorry.
I appreciate that.
I hope I can talk fast enough to get my message out. I'm technically not that versed. This is something I don't do normally. I support this appeal. My number one question tonight is why not add these things onto the plat, the needed changes? What is wrong with clarity? Residents don't know if what has been discussed will make it to the plat. Why not add conditions and requirements to the plat so that owners of lots and homes know exactly what the parameters are? What is allowed and not allowed? Also, would that protect all involved, including city? Land use works closely with developers, but why not broaden input to come up with solutions? Tonight demonstrates that need, broaden conversation. Since the assistant attorney brought up the condition of approval slide that discussed the 75-foot setback, I noticed that the Old Pecos Trail Scenic Corridor was misrepresented. The 75-foot setback is a code requirement under the South Central Highway Corridor Protection District and has nothing to do with the Old Pecos Trail Scenic Corridor. Unfortunately, the Old Pecos Trail Scenic Corridor has not yet been allowed by land use to express intent as is directed in the general plan. Also, there is an omission in the staff's report. One of the two significant Old Pecos Trail Scenic Corridor paragraphs directives in the general plan was not included. It says, adopt an Old Pecos Trail Scenic Corridor designation and development standards for the Old Pecos Trail between Cordova Road and I-25. Also not included in support of two Old Pecos Trail directives is the 1999 future land use map that clearly shows the Old Pecos Trail in the legend and the hatch marks. It was removed in 2022 by land use staff as the developer was in the process of a subdivision request. It had been there from 1999 to 2022. There are 3 additional map examples of unauthorized manipulations that I have no time to discuss, but I can provide it to anybody who wants to know. Thank you.
Thank you very much.
My name is Hilario Romero. I live at 1561 La Cieneguita. I state, I solemnly declare and affirm that the testimony I have in reference to this item shall be the truth and nothing but the truth, and do this under the penalties of perjury. I had been before this body for some time in the past, and here I am again. The previous administration allowed me much more speaking time. That has changed now. It has been shortened. The other thing that has happened is land use department is not the same land use department from the previous. There have been a lot of changes. And I find them not to be as cooperative with the community as the one before it. And that is something, because I've been involved in a lot of cases and I've also testified in a lot of cases. And also, since 2019, of course, I have a lot of history with testifying. In fact, at 2:45 a.m. in the morning, in a case where I was cut off on a 2-minute, I had 2 minutes to talk, and I was cut off at 1 minute. That was in 2018. And some of you weren't on the council at that time. That's important. That's important to allow the community to be on the agenda with these kind of very long cases and get the testimony and everything. You got to give us an opportunity to do it at a decent hour, not at 2:45 a.m. Also, because I'm in the Southwest Corridor, and I support, and I think that we need to, I support Bruce and what he's doing, because I'm helping the other side of the coin, because I don't see this project since the beginning as a project that should have ever been created in the first place. I consider that a wildlife corridor. I've considered that for 75 years of my life. And many of you haven't lived that long, or actually lived here in Santa Fe that long. And Phil Beauvais, the Acequia commissioner on one project just across the street from us, they promised Phil and I, when we went out there on the site, after all the plan was taken care of and it was approved, not to destroy the Acequia del Ojito. It's not there anymore, folks. So we need a little more respect from City Hall. Thank you.
Thank you, sir.
I, Monica Montoya, residing at 726 Gregory Lane, solemnly declare and affirm that the testimony I have in reference to this item shall be the truth and nothing but the truth, and do this under the penalties of perjury. Good evening, Mayor and City Councilors. My name is Monica Montoya. I am the planning consultant on this project, and I am here, as Orlin is, just to be a reference for you if you have any questions on the project itself, the project design itself, how we worked on the design of the project to comply with your codes. Also to state to you that the development review process of the city of Santa Fe is a very extensive process, starting with working with the neighbors early on, even before we even came to the city with an application. That's actually a city code requirement, and it's a good one in our opinion. We feel the process made it, the communication with the neighbors made the design much better. It's extensive. So we start with the neighborhoods. We go through all of your staff to ensure compliance with all of your codes. We do it at different phases of the design. And now we're at the finish line, but we do have some notes to place on the plat, some conditions to comply with staff. And we are on board with that, ready to do it. And with that, I'll just stand for any questions if you have any.
Thank you for your testimony. Is there anyone else here in the room who wants to come forward and be sworn and have an opportunity to speak on this matter? Madam Clerk, are there folks on the Zoom who need to be sworn and they would also have an opportunity to speak?
Yes, Mr. Mayor. We'll start with Stephen Farber.
Hello.
Mr. Farber?
Yes, did you
Will
hear?
you please raise your right hand and state your name?
My name is Stephen Farber, Farber.
Do you solemnly declare and affirm that the testimony you have in reference to this item shall be the truth and nothing but the truth, and do this under the penalties of perjury?
Yes, I do.
Thank you.
Mayor and members of the governing body. My name is Stephen Farber. As some of you may know, I am a former city councilor. I also practiced law in Santa Fe, New Mexico for 51 years and retired at the end of 2022. I would like to say that due process of law is a key component of the hearing that you have been conducting this evening and that you conducted last week. One of the aspects of due process of law is to equally apply the laws and apply the ordinances of the city of Santa Fe as they are written and as they have been described. I adopt the comments of former city councilor Peter Ives because he pointed out various statutory references that were not complied with. Also, throughout the proceeding, as Mr. Throne was attempting to ask questions, he was cut off prematurely as he was trying to describe the actual relevance of his questions. The fact that someone may guess what they think the relevance of Mr. Throne's questions were is not something that is definitive. Mr. Throne had the right to be able to state specifically why he needed to ask a particular question and state with specificity, which he was not allowed to do, the relevance of his questions, which were that the city of Santa Fe throughout this process with this particular development that will unfortunately ruin the old Pecos Trail Scenic Corridor, that the city has not complied with its own ordinances and laws, and that becomes a violation of due process of law. One quick example, at your last meeting with the Vista Hermosa assisted living situation, the proprietor was not allowed to go forward with her appeal because she missed a deadline that was set forth in the city code. The council strictly complied with its ordinance and denied that appeal. And if I'm remembering correctly, it was because there wasn't service within a particular period of time. So if you were strictly applying the ordinances at that hearing, you also ought to strictly comply, make the compliance with the ordinances of the city with regard to this extraordinarily strategic piece of property and this development plan. And the other question with regard to the development plan is I do not understand logically how one can appeal a final development plan, which is apparently what this hearing is about, when there is not a final development plan that has been presented to you for you to review. And that is the point I believe that Mr. Throne was attempting to make throughout these proceedings. If one adds up, they said, oh, well, these are minor adjustments and minor adjustments and minor adjustments, and the notes will be put on later. Well, that's not final. So you have to think this through respectfully in your quasi-judicial capacity because you are acting as judges. You are not acting as legislators at this moment. You are not acting as administrators. So I ask that you comply with the city's ordinances. And I don't, is my time up?
Yes, sir. Thank you.
Thank you.
Thanks a lot. Madam Clerk, is there another person in the Zoom area with a hand up?
Yes, Mr. Mayor, Adam Johnson. Mr. Johnson, if you'll please raise your right hand and state your name.
Adam Johnson.
Do you solemnly declare and affirm that the testimony you have in reference to this item shall be the truth and nothing but the truth, and do this under the penalties of perjury?
I do.
Thank you.
If you can be a little bit louder and clearer, I think it will come through better for all of us.
Okay, I'll try to speak more clearly. Thank
That's
you all
better.
for your service, and I pledge to be brief. I'm Adam Johnson. I'm the executive director of the Old Santa Fe Association. One of our major concerns is due process, which was just mentioned by former Councilor Farber. One of the things that I am observing in this public hearing is, or a question that I've had is, how can we make public processes better? And at different stages in this whole saga, we have seen moments where public participation and due process can be improved. And I hope that those are moments of learning for us all as both members of the public and as members of the governing body. Earlier, it had to do with Prime Gov and the digital infrastructure. And then tonight, I think that there is some sort of absurdity around the idea that there's a final plat that is not really final at any stage. So that seems to matter, right? Names matter when we are trying to communicate information to the public and be transparent, which is a stated goal of local government and a very noble one. So I just think that is worth observing. I'm sure you all are sort of processing that information. Given that the pending appeal of the city's decision to rezone this is in the district court and will be heard very soon, specifically, I believe, on March 4th, the proposed approval of the applicant's plat it should not be considered prior to the decision of the district court. It would make sense to not, in this case, put the cart before the horse. So thank you for your consideration.
Thank you very much. Madam Clerk?
Yes, Mayor, we have Stephanie Benenato. Ms. Benenato, will you please raise your right hand and state your name?
Stephanie Benenato.
Do you solemnly declare and affirm that the testimony you have in reference to this item shall be the truth and nothing but the truth, and do this under the penalties of perjury?
Yes.
Thank you.
I just want to say that I am concerned that certain things are on the plat. And I understand some of them are in the covenants and some of them are on the plats. I understand that there is more detail about the open space for the corridor, and that is necessary on the plat. My understanding from Mr. Escobar and some of the other testimony from the staff is that this is going along in the normal course of how things are done. It seems to me that Mr. Throne and his supporters have come forward perhaps too early in the process. And I do agree that there are times where things are vague, like the 5-day rule, something's final when there's no written decision. Even though written decisions are required for appeals, you have to actually attach a written decision. And this whole thing that Mr. Ives just quoted about due process in the appeal ordinance, I haven't seen any of you jumping up and introducing a change to the discussion in which the woman's appeal was dismissed, probably properly, but again, she should have been given the opportunity to be heard on an equal level with the city council. However, I find tonight that the council was incredibly generous in its time. I thought that much of what happened here tonight was so off point. And so I don't even know what word to use, but just beyond relevant. It wasn't relevant at all, and it was repetitive and sort of harassing to some of the witnesses. And I'm not really sure why some of you don't get that your city attorney, Miss Manu Kerman, is referencing facts that she gathered from other sources. These are not her facts. But even more importantly, is she's your attorney. Are you going to vote to waive your client confidentiality and allow her to testify? Do you think that Mr. Summer there should have to think at every question, am I violating my attorney-client privilege here? Because I don't see their client coming in and saying that they can just talk freely about whatever. And we don't know that the facts or the questions were going to be confined to the facts.
Thank
So
you.
anyway, I do thank you and thank you for listening.
Thank you. Appreciate it. Madam Clerk, do we have more folks with their hands up and in the Zoom room?
No, Mayor, there are no other hands raised in the Zoom room.
Very good. I'm going to ask one more time for the people who've been patiently waiting in this room. If you would like to come forward now, this is the time to do it and be sworn and comment on the case. If there are no more members of the public who'd like to be sworn and comment, I think now we're going to go forward with the governing body.
Mayor, one hand just raised.
Okay,
I
good.
apologize. Diane McInnes.
Can you,
Yes, this is Diane McInnes.
we need to swear you in with the clerk. Please take care of that.
If you'll please raise your right hand and state your name.
This is Diane McInnes.
Do you
I'm sorry, if you can speak up a little bit, you weren't coming quite clearly
This is Diane
through.
McInnes. Can you hear me?
Yes, thank you. That's better.
Do you solemnly declare and affirm that the testimony you have in reference to this item shall be the truth and nothing but the truth, and do this under the penalties of perjury?
I do.
Thank you.
Okay, thank you for this evening. I've been going through this process from the very get-go, the beginning, and I support this appeal. I support what Peter Ives said, what Steve Farber says, and from what I've witnessed throughout, it seems that more weight is put on the interpretation by staff of code rather than code itself. And Bruce Throne has pointed out many, many code details that I think you really need to look at. The problem with this development is that we really don't know what it is. We don't know where how the open space is going to work. The notes haven't been put on the final plat, and that must be done. We can't rely on, oh, we promise later, when people are asking for variances, because this is it's not really a development, it's a lot division. People haven't bought these lots and asked for plans for these homes. We don't know what it's going to be about. I don't think it should ever have been approved because we don't know what it is. It's only a division of lots. And to not have the notes on is irresponsible, and it must go back to planning. Thank you.
Thank you. Anyone else, Madam Clerk, that may be putting their hand up now?
No, Mayor, I don't see other hands raised in the Zoom room.
Okay. If there's nobody else here, then the next step in our process is for the governing body to take turns. We've agreed to have a 10-minute individual limit, but no limit to how many times we can go around on the governing body. And the governing body has the opportunity to ask questions of staff, of parties, of witnesses, indeed of the public. And so I will turn to you, Counselor, and the clerk will keep an eye on the clock. We'll try to be true to the 10-minute, but not cut you off in the middle of an idea. But you have the floor to pursue questions of any of the staff, the parties, the witnesses, the public.
I have just a few questions, and I will also try to be brief. Mr. Throne, could you please just quickly address what the major differences are between the initial and the final plat.
There's certainly, I certainly don't disagree with the statement by Ms. Guerrero Ortiz that there were changes to the road designation on the plat because there were problems that the city found with how they were going to provide certain characteristics of the road so that city vehicles could turn around, et cetera. But the notes on the plat did not change. So there were no preliminary plat had certain notes. It didn't address a lot of the areas that we believe the Planning Commission required them, and also was required for actual meaningful enforcement of Chapter 14 of the code that apply to this. And then we would have thought, I mean, you consider that preliminary plat was approved by the Planning Commission in September, at their hearing in August. This is September of 2023. I'm sorry, 2022, that they had all the way until April of 2023 to add the notes to the plat so that we could all see, oh yeah, they're addressing this, they're addressing this. And if there was any disagreement, like, you know, do the open space standards apply? We could have addressed that, but they didn't change them. And then we found out, that's when we found out for the first time, oh, it's our standard practice. We're going to do this after the record closes. So basically we don't disagree that there's still the same number of lots, the road configuration that changes were as required. But we don't think, as we pointed out, we don't think the only issue in this case is whether there's substantial conformance.
Thank you.
Thank you, Counselor. Counselor Garcia, you have the floor, sir.
Thank you, Mr. Mayor. I'm going to try to group my questions up based on folks, then I'll ask for responses from. So I'll ask for former Councilor Ives to come on up. Good evening, sir. So during your testimony earlier, you referenced some parts of the code earlier you felt that were not complied with, or there were some inconsistencies in the way the procedures were carried out. I know 2 minutes is not a sufficient time to go into detail. I tried to scribble in it. Going back to my notes, I wasn't able to coherently put together, I guess, what you're trying to convey. So give you the opportunity in regards to how you, I mean, you referenced 14-3.7B4, and maybe start there in regard, or just let me open it up to how you feel that the process hasn't conformed in regards to the process.
I think, first of all, thank you for that question, Mr. Mayor, councilors, Councilor Garcia. One of the main reasons we're here tonight is simply because this notion of final plat seems to be a somewhat fluid concept. The code provisions that I was referring to call for a complete submission of a final plat, and it talks about that original drawing then being what is recorded of record. But what we've heard tonight is that the city doesn't follow that practice at all, but rather will identify conditions which may or may not be part of the plat that is submitted as a final plat. And we've heard references to the final plat actually being not only the actual plat, as that term is, I think, understood by people who do real estate law, but includes potentially planning documents, memorandum, and many other things that aren't necessarily filed of record when a final plat is recorded. So there's this disconnect between this concept of final plat and what is actually submitted both to the planning commission and to the governing body for consideration as a final plat. And I think it would behoove the council to say, so a final plat needs to be a final plat. That gives anybody who is opposed and seeking to appeal the opportunity to actually comment fully on what is being presented as a final plat, rather than taking shots in the dark as to what's going to be there and significantly how it's going to be phrased, because how things are phrased are certainly significant to understanding what various conditions and limitations are going to be on any development. And that gets to that point of fundamental due process, which is if you aren't dealing with a final document, i.e. one that is not then subject to many tweaks and additional language and other changes after it is approved, then how is a party that might be in opposition to that plat going to appear before you and argue sensibly or fully what their problems are with that document? And then that also creates a problem with the record on appeal of any decision, because you're being asked to decide something that, while it's described as a final plat, in fact is not a final plat. And so the record on appeal is going to be fraught with issues, because what you have to appeal is not necessarily the document that even the city says is ultimately going to be filed of record. So my urging is to consider those procedural issues, change the process. And we heard Ms. Montoya, in fact, say just now, oh, we're ready to put all those conditions on the final plat. Why that wouldn't have been done months ago, when presumably the final plat was going to be submitted, perhaps remains a bit of an open question, other than the fact that that has been the way land use has approached to that issue. So I would hope that we avoid this issue on any land use decision moving forward. And the way to do that would be to not approve this final plat at this moment, but send it back with requirements that a final plat be designated as a final plat with all the necessary conditions and other things stipulated, so that we could argue about a concrete and distinct document as to any opposition, as to any questions on appeal. Thank you for giving me that opportunity to explain a little further where I was.
Thank you for the clarification. I appreciate it. My next questions are for city staff. Anybody, I mean, Mr. Esquivel, I guess. I mean, and to put Mr. Esquivel on the spot, because this is some pretty specific question in regards to setback requirements. So I'll ask it be any city staff that can feel they're comfortable with answering questions about setback requirements. Okay, thank you, Mr. Esquivel. So I'm going to reference this map that was drafted up per your request to help with the designation of the open space requirements. But what I find very helpful on it, it's got the showing the easement on what looks like the north side of the property, the 7.5 foot public utility easement. And so what would the requirement be for any other property in regards to the setbacks?
Mayor, Council, Councilor Garcia, are you talking about within the subdivision or the citywide in general?
Within the citywide in general.
Mayor, Council, depending on which zone district the application or the property falls in, will determine front, side, and rear setbacks. In R1 through R6, the front yard setback is 7 feet, side yard setback is 5 feet, rear yard setback is 15 feet. In your high-density residential districts like R20, R10, 12, 21, 29, the setback requirements are either governed by a development plan or they have a 5-foot setback to the sides and a 7-foot setback to the front.
Okay. So earlier during, I think your questioning from Mr. Throne, there's reference that it should be 12 feet. Is there a reason why it's not?
I'm
12
not
feet?
sure I understand where you're getting 12 feet. Can you be a little bit? more specific?
Maybe, I don't know if Mr. Throne, somebody referenced that this 7.5-foot public utility easement is not typically what it should be. And from my recollection, the response was, well, the corridor doesn't provide any restrictions. And so,
Mayor Councilor Garcia, the 7.5-foot setback along that street is fine because that would also be considered a rear yard setback for a property since their access, or it could be a side yard setback depending where their driveway access is coming from. And I think for lot 1, that driveway is coming up at the top of that lot. So that would be the front yard of that lot. If the lot was accessing off of the street itself, which it couldn't because of the terrain, then that would be a 7.5-foot setback, or 7-foot, 7.5 foot, so I'd have to check, 7-foot setback from the front property line. But since it's not, and it's restricted to access off of its own roadway, then the front of that lot is the 7-foot setback, and the two sides would be 5-foot setbacks, and the rear would be 15-foot setback. They are offering a 7.5-foot setback, which includes a utility.
okay. Thank you, Mr. Esquivel. And I guess my last question is regarding process. So I don't know if it's you or maybe the city attorney's office to answer this question, but I'll ask it and let the appropriate staff respond. Does the council have the ability to send this back to the planning commission and require them to approve a final plat with all the conditions stated on a final plat, approve that, and send it back to us for approval?
Mayor Council, I think I'll defer that question to legal.
I think the city attorney or her designee should answer that question.
Mayor, councilors, I'll let Assistant City Attorney Rebecca Minnick Herman respond to that. I might be able to add on to it, but I'll let her start.
Okay, thank you.
Thank you, Mayor Weber. Councilor Garcia, the governing body has 3 options tonight. Those are the ones set out in the motion. So the, or in the motion options that I listed in the memo. And so you can either accept the appeal, you can deny the appeal, or you can modify the decision below. So you do have the option tonight to add or remove conditions, for example, that the Planning Commission proposed. That doesn't have to be the modification. That's just an example of a type of modification that you could you could propose tonight. However, you do not have an option to remand this case back to Planning Commission.
Okay. Just trying to figure out how we can address the concerns by many stated as well as I have in regards to the final plat that's before us is not in its final form. It's in work. It's a draft. There's still things that need to be added to it. So I definitely understand the concerns, and I do have the same, and I'm wondering how we can move forward with making a determination once the plat, the conditions are on the final plat. Public has the ability to respond to that, as well as the governing body has the ability to respond to it, because right now it's implied that the information is going to be there, but, and from understanding of, and I guess correct me if I'm wrong, my understanding of the response from former Councilor Ives is the process somewhat calls for it, even though our process has not traditionally followed what's outlined in code. It's so I think those are my concerns, and I'm wondering how can we ultimately work towards a solution where all of the information that has been required to be on the plat is there, and that way folks can see it black and white, and we can make a final determination. And if sending it back to the planning commission isn't that, could one of those conditions be that we don't make a decision until all of that information is incorporated into a final plat? Is that a possibility?
Thank you, Mayor Weber. Councilor Garcia. Let me do my best. So there's not an option. The code doesn't provide an option for an additional hearing, an additional public hearing to review the final plat. I think that one thing that may be helpful and was helpful to me in kind of understanding how to think about this process is that the city doesn't own the plat. The city isn't actually making any changes to the plat here tonight. We don't have the physical plat. We're not making physical changes to the plat. The city does have the power to create enforceable conditions. And I understand the public's concern that the conditions don't appear on the plat. So essentially we have two documents. The plat, there's the plat, and then there's the conditions. And so what the Planning Commission did is they conditionally approved the plat. They never approved the final plat. They approved it with the adopted conditions. So the governing body tonight does have the option of imposing any conditions it thinks are appropriate. So what the Planning Commission did was it adopted the conditions in the staff report. The governing body could, for example, adopt the conditions into findings of fact and conclusions of law more clearly, rather than just saying we're adopting the Planning Commission conditions. So that may be an option. Does that answer the question? Is that helpful?
I think Director Klug has his hand up as well, and he may want to speak to your question, Council.
Thank you, Mayor Weber, councilors. So I just wanted to, just a point of information. So first of all, once the applicant prepares the plat for review, for final review, if all the notes and conditions and signatures are accurate, then, Dee and Maggie sign off and record it at the clerk's office and in the city plat room. If there are errors and omissions, we redline it, and then we reprint. We ask them to reprint until it matches the, what was approved by the Planning Commission. But what I wanted to note in the code is that I just wanted to make it really clear that the chair and the secretary of the Planning Commission are required to sign off on the final plat with all the conditions in place. So that process already actually exists. There is that check. So the Planning Commission actually is seeing it again in final form before it goes to recordation.
Thank you, Director. Really appreciate the clarification.
Counselor, I'm going to ask you to put hit pause, and we'll come back to you on another round. Okay. Counselor Lindell.
Thank you, Mayor. I'll be brief. Mr. Throne, question for you. Why didn't you appeal the preliminary plat?
We didn't appeal it for a number of reasons. The first reason is because the preliminary plat wasn't a final plat. And in particular, the record was extremely clear, as we cited in our appeal petition, that on the critical issue of the open space requirements, instead of deciding what applied to the subdivision at that time, the chair of the commission said, after discussing it with Mr. Esquivel, said, well, we're going to put this off until the final plat comes in, and we're going to require that they address that to the satisfaction of the commission then. So we didn't have anything to appeal. If we had appealed that decision then, we would have come up to this body, and you would have heard the staff and the applicants say, they're premature. The chair of the commission said we were going to deal with that in final plat approval stage. So it was one of those situations where why would you appeal something until it's final? We had nothing to appeal. So that was one of the reasons why we didn't do it. And then there were other matters that they decided they were going to be addressed in the final plat approval. And so what we, which by the way, the findings and conclusions for final plat approval relied to a certain extent and were based on the findings and conclusions for preliminary plat approval. And so that gave us an opportunity when they finally said, okay, this is our final action, this is what we're appealing. That's when it made sense for us to come to this body if we didn't think that everything was done that should have been done.
Thank you. Mr. Escobar? You've been around for a while.
Yes.
Have we had other, do you remember other or a number of other appeals on the final plat not reflecting the preliminary plat?
Mayor, Council Lindell, this to me is like the first, I guess, for anything that I've processed. Most appeals usually come in at the preliminary level where the meat and potatoes are discussed for that plat.
Yeah, I haven't, I've been around a while and I haven't seen this either.
Mayor, Councilor, can I clear up something that was
Yeah,
said earlier?
I was gonna just ask you, but go ahead.
So with regard to the process for our subdivision process, even our development plan process, or any process really, Chapter 14 requires the land use developer to come up with procedures, policies, reviews that allow us to implement, review, implement, and enforce all of those ordinances that collectively make up Chapter 14. So I read earlier those sections within the subdivision criteria, the standards by which we use. When a public body conditions or accepts staff's conditions, because they don't have to, even for the open space that Mr. Throne continually brings up, there was no gag order on any of those planning commission members. They could have freely brought it up prior to their deliberation of the preliminary plat and said, you know, I think I would rather see this, send it back, come back. We'll take a look at it when it's here. They accepted the condition. And when a condition is imposed and it's got a timestamp, that means that the applicant has the ability to meet that condition within that timestamp. It doesn't have to be placed on the plat simply because somebody out there says, I want to see it right now. I need to have it right now. And if it's not on this plat, it's not a final plat. Well, it is. It's conditionally approved. And that's the meaning of conditional approvals is that you're approved if you meet these standards. And those standards, if they have timestamps, whether it's to do before final or after final or before recording or during the construction phase, they're still part of the preliminary plat or even the final plat. So to argue that the process was not complied with within Chapter 14 is incorrect. We follow Chapter 14 almost to the letter, to the point, because we use this as a checklist as we go down the line and check off every single item that's been done so that we don't get appealed. And we've done this over and over and over again for the past 17 years that we got it down to a science for everybody that comes into our office so that we can apply the code equally, equitably, and fairly across the board so nobody gets treated differently. We want to keep the same process for everyone so that nobody can say we're treating anybody unfair or nobody can say that we're giving somebody something different than we didn't give somebody else. We treat them fairly across the board.
I note that Director Klug's hand is up. Is this, Director Klug, were you going to try to respond to Councilor Lindell?
Yes, I'd like to add to what Dan was commenting on, if I may.
Yes, go ahead.
So I just want to note that, we approved 270 subdivision lots last year. So to Dan's point, we definitely have this, we understand the process and we use it repeatedly in an unbiased way, and we have for years and years. And I agree with Councilor Ives, actually, that it is a fluid process and it needs to be in order to provide a functional, reasonable process for application to plat approval, and allow a reasonable timeline for the applicant to address conditions prior to recordation and or building permit. And none of that means that we don't have checks and balances, right? We have checks and balances along every step of the way. I just wanted to add that.
Thank you.
Thank you. One final question, Mr. Esquivel. Has the final plat process procedure changed within the last 5 years?
Mayor, council, I think there may have been some ordinance changes back in 2012 when we updated the code back then. I think Greg Smith was here when they did that major overhaul. Some of the some of the standards may have changed, but the process has remained intact in terms of how we treat those types of applications.
Not only not within the last 5 years, not within the last 10 years. I was around when that happened in 2012. So it's actually been about 12 years. Thank you very much.
Thank you. I read the temperature of the governing body. Is there a motion to extend beyond 11:30 so we can continue these questions?
So moved. Second.
There was a second? Okay, thank you. I'm sorry. There's a motion and a second to extend beyond 11:30 so we can hopefully come to a vote tonight and not have to carry it over again. Is there discussion of this motion? Madam Clerk, would you please call the roll?
Certainly, Mr. Mayor. Counselor Cassett,
Yes.
Counselor Castro,
Yes.
Counselor Lee Garcia,
Yes.
Counselor Michael Garcia,
Yes.
Counselor Lindell,
No,
Counselor Romero Worth,
Yes.
Mayor Weber,
Yes,
motion passed.
thank you. Counselor Lee Garcia, sir, the floor is yours for questions of staff, parties, witnesses, the public. And if you don't finish, we'll give you another 10 minutes afterward.
Thank you, Mayor. I've got a lot of scribbles everywhere and there was a lot of content that was brought forth. And so I kind of want to start off first off with Mr. Throne. And just based upon comment that you just made, is that from your all's perspective, there were things on the condition of approval that were not done that should have been done, is what you stated. And so what are those things? I've got some issues here with open space. I've got some issues with lighting issues and height restrictions. Those are the three big ones that I've written down over this time. So kind of want to get your perspective on what those things are that you specify specifically as to what you're requesting to be added additionally to this. If we were to move forward with additional conditions of approval that would go on this final recordation.
Mayor and Councilor Garcia. And these are detailed in our petition. So one of the items was, as I mentioned before, and this is an exhibit to the appeal petition, Monica Montoya wrote a letter on August 2nd, 2022. There was some issue about what the height would be of structures that would be allowed in the subdivision. And her letter, which is in the record, said, oh, we're going to clarify that it's not just 18 feet in height, but that 18 feet includes parapets, because parapets can be actually even higher. And there was some comments made at the hearing about what exactly were. In fact, there was a rendering that was provided by the old Santa Fe Association at that first meeting to show what that would look like, heights.
Okay,
So,
what would you like it to be?
Well, it's not.
What are you requesting?
Well, Monica Montoya's letter said, we will put a note on the plat that and it states right in that exhibit that that the 18 feet height restriction includes parapets and pitched roofs. And she said right in there, the note will be put on the plat to make that clarification. That is not on the plat now. So that's number one.
Okay.
The second thing, there's the prohibition of any fencing within the 75-foot right away from the Old Pecos Trail, 70-foot Old Pecos Trail right away. That actually is a code requirement in Chapter 14 that applies to the South Central Highway Corridor Protection District that actually was adopted as a technical correction by the city in 2012. Actually, the city changed a lot of its Chapter 14 provisions in 2011, and then in 2012, there was a document that the city put into the record in the rezoning appeal that showed that they put that 75-foot setback in there along this section, the south section of Pecos Trail. There was an issue about, because the applicant originally came in and said, we don't think that applies to fences. We thought that was a building setback, and the staff disagreed, and the commission adopted staff's conditions. So that has not yet been put on the plat as it's presented to you now. One of the biggest things, again, as I said, was the open space requirement. And there we have a major factual dispute. We believe that the code makes it very clear that the overlay requirement of 50% open space on each lot of the proposed subdivision is in addition to other requirements in the code. The code says that. We cited that in our appeal petition. And that's an important provision here, because what happens is, if that isn't clearly put on the plat and stated accurately that those private open space standards apply here, it means that you will not be notified. First of all, it means the staff's not going to enforce it, because there won't be a note on the plat for them to enforce. Who knows who's going to be here from staff 2-3 years from now. But more importantly, it doesn't give any notice to anybody who buys the lot what that requirement is. And as I mentioned before, the covenants and restrictions that were submitted by the applicant to the Planning Commission don't state that. So you have a situation where you're creating the circumstances for variance requests. And, you know, I've been here long enough, almost 48 years now, to remember the first interstate building, which everybody was surprised when it went up. People called it the big ugly. They wondered, how could this building have met all the requirements? And the problem was there were requirements, and apparently they weren't enforced. So for enforcement and for the community, especially because this is within not only the South Central Highway Corridor Protection District, but the Old Pecos Trail Scenic Corridor as designated in the 1999 General Plan, this open space thing is critical for the community. It's called a special, right in the code section, it says this is a special asset, the visual openness. So we think that's a very important thing to have in there.
I think I have enough. I think the top 3 that I'm looking at.
I think there was 1 or 2 others, but if that's all you want.
That's all. I'm good. I want to have a few more questions really quick. I want to ask, in regards to the open space, and I think this would go to staff, whether it's Mr. Esquivel or Director Klug. So what I believe you stated earlier, that the overlay supersedes the open space requirements, supersedes the private lot open space requirements. Is that correct for this development?
Mayor, Councilor Garcia, the overlay will force its compliance in favor of its new matrix, is what I said. In some cases.
Sorry, could you repeat that last part of the sentence? In favor of
its new matrix, in favor of its rules. It will force that. And I use the analogy I use was the historic district, where the height requirements are different from the underlying zoning. In that case, the height requirements of the overlay will set the precedent. In this case, the height requirements of the overlay are 25 feet, which are greater than the height requirements for the underlying zoning. The underlying zoning, being the more restrictive of the two, would then restrict it to 24 feet. The applicant is reducing it to 18 feet That is their own condition. It's not something that that we as staff implemented. They offered that at the public hearing. So when it comes to private open space and public open space, the private open space is a function of lot coverage. When you reach 40% lot coverage or greater, we'll say greater than 40%, because that's when it hits. Right at 40%, you're still in line here. But when you get 40 or greater, we calculate the roofed area and compare that to the lot to come up with a lot coverage. And when you're greater than that 40% lot coverage, the code requires that the amount of open space needed is 50% of that dwelling unit. If you have a 2,000 square foot house, then 1,000 square feet of open space is required to be placed for private open space on the plat. Now, that would be in their buildable area. That would not be included in the open space that's already required by the overlay. The applicant has chosen to stay below 40%, so they don't have to deal with that private open space calculation for the people that purchase, and they're going to condition it themselves. So in that sense, open space is open space for the overlay that will be shown on the plat, graphically represented as open space. So
When is that enforced? Mr.
That's enforced on the plat. That's
When
that's
they come for building permit?
when we file that plat. When we file that plat, it's going to show that global open space. And there'll be a note that identifies that no open space, that no buildings will be placed in this global open space. So it truly is an open space. They can't build on it at all. Now, could they put their grading and drainage? Well, the open space section doesn't say they can't. Because it's still open space, right? There's going to be a little indentation for their ponding. There's going to be landscaping in their ponding. It's still going to be open space. It's still not going to be a building in that place. So could they use that? Sure. But private open space says, no, you can't do that. And not only can you do that, it has limitations. The slope can only be 1 in 10. The minimum dimensions are 12 feet in every direction, and it has to have one access into the house.
Thank you. I have a few more questions, but I'll go ahead and
We'll come back around.
come back. You can come back. Thank you.
Counselor Cassidy.
Well, thank you so much. As long as we're on this line of questioning, I just want to make sure that I understand. These open space requirements for private open space, when you go above 40%, they are not going above 40% of lot coverage, so these will not be triggered in this specific scenario. Is that correct?
Mayor, Counselor, that is what they are representing and what they're going to enforce on their buyers. We as staff don't have that trigger. If they want to breach that 40% open space, the code allows them to do so as long as they can meet relevant private open space standards and still achieve their goals. And that's on top of the open space required by the overlay.
So if somebody were to come getting their building permit and they're going to go over 40% of lot coverage, these private open space requirements in the code will be triggered.
That's right. And just to identify how that's done is when the staff is trained for looking at building permits, they are trained to look at and calculate open space. They are trained to look at legal lot of record. They are trained to look at all of the zoning criteria that Chapter 14 requires them to look at. For every building permit across the board within the city of Santa Fe and for all subdivisions that are approved. It's not something that we don't do. It's built into our review and it's built into our training process. So every employee knows how to do it.
Wonderful. And that is covered on those conditions of approval 1 and 2. Property development is required to comply with the applicable provisions of Chapter 14 Land Development Code, SFCC 2001, and subsequent amendments that would cover this, correct?
Yes, and let me qualify that every employee within the current planning division, since we look at zoning.
Got it. Thank you. As well as essentially condition of approval 2, which says that we will follow the entire City of Santa Fe code.
That's correct.
Okay, so I think that that's really those conditions of approval on that plat are very important. It looks like this boilerplate language, I'm assuming. Is that correct? Gravity
Mayor,
on everything?
Counselor Cassidy, that's correct.
Okay. So I think that that's a really crucial point, that there is this conversation about parts of the code not being met. This covers that,
Counselor Cassidy, that's correct.
right? What? Yes, it does require that. Thank you. And then when I am looking at the conditions of approval, so again, when we go back to the setbacks, it talks about 75-foot setback along Old Pecos Trail. That's covered within chapter 14 with South Central Highway Corridor overlay.
Mayor, Counselor Cassidy, the fence condition was a negotiated condition that was accepted. It's not in chapter 14.
Okay.
The applicant did comply with the 75-foot setback per the overlay requirements.
Okay. Now, if somebody were to come, they want to build, and they are presenting a plan that does not meet chapter 14, will they receive a building permit?
Mayor, Council, Counselor Cassidy, we try not to deny building permits because again, chapter 14 is big. You know, I know that Jason hates this, but it's like an onion. It's got a lot of layers, and when you peel it, it's going to make you cry. So what we do is we help those applicants by requiring corrective measures. And we will send those sets of plans back with a laundry list of information they have to do in order to comply with the code. They will then amend their building permits, bring it back in, and then we revisit those areas. If they've complied with chapter 14, they get a building permit. They still missed some items, it goes back again.
Okay, so they don't, but they will not receive said building permit until they are meeting the conditions that they.
Mayor,
must meet.
Counselor Cassidy, that is correct.
Okay, so again, I think another important piece of this concern of we are not sure what this will look like. Chapter 14 really is going to dictate setbacks, open space, height, well, for this one, plat will actually dictate height. And all of that will be, we have another check in the building permit application process.
Mayor, Council, yes, in the simplified version, when we look at a building permit, we look at the legal lot. When we look at the legal lot, we check for notes on the plat. For restrictions, any variances that may have been adopted, we want to know right there so that we can maintain those variances that they got across the board. And then once we've taken a look at the plat, then we look towards chapter 14 and we look at all of those sections relevant to what they're building. And we will either pass them or send it back for corrections.
Okay, thank you. This has actually been very educational, I will say, and, you know, reading plats and understanding the process. So I really do appreciate that. I think that maybe not. Let's talk about lighting really quickly. Ms. Beingesser, this might be for you, or it might be for you, Mr. Esquivel, so don't go away. I know there's been a lot of conversation around no streetlights in Sully Lomas. Is this subdivision part of the Sully Lomas neighborhood, the area that covers Sully Lomas?
Mayor, Council, no.
So they are not required to follow any of the covenants or restrictions of Sully Lomas?
Mayor, Council, not that I'm aware of, but that would be something you might want to ask the applicant, since I am not privy to their what the title company has found in terms of any covenants and conditions associated with this particular piece of property. But to my knowledge, I don't think they are.
Okay, which also would mean that they would not be, I don't know if there's any variances that have been applied to Sully Lomas, but they would not, sounds like it, if we do have streetlights that are required, but Sully Lomas does not need to have them. I mean, that's a whole other history about when this was annexed in and when it was developed, I'm sure. But if there are any variances, they would not be automatically be able to receive those because Sully Lomas has them, correct?
Mayor, Councils, we don't enforce those covenants. So if our engineer required them and they were part of covenants and conditions that the association was saying, no, you can't have them, it would be up to the association to enforce their covenants. We would still require the lights. If they couldn't get it, they would have to seek an appeal or variance from the land use administrator's decision, if D is requiring that, in order to relieve them from that code standard. Because it's our view that the ordinances supersede any private covenants out there.
Okay, good to know. Thank you, Mr. Esquivel. I will stop for now with you. Ms. Montoya, if I could speak with you very briefly, that'd be wonderful. So there's been some conversation around the 18-foot and that including parapets and pitched roofs. Would you agree for us to add that as a condition of approval this evening?
Mayor Weber and Councillor Caslett, yes, we did agree to that from the very beginning.
Okay,
So we do agree to that.
wonderful. Well, thank you so much. I do appreciate that. And Mr. Mayor, we'll pass it on for now. Thank you.
Thank you, Counselor. Counselor, you have the floor.
Thank you, Mayor. Ms. Montoya, sorry. You did agree to that, you say, but when, where is that reflected besides the email that Mr. Throne has?
We accepted that as a.
Is it in the conditions? Okay, so it's just in an email. It's not.
To answer your question, we did agree to, I'm sorry, will you ask?
Okay, so you said you said there, you agreed to the 18-foot height limit and to include pitched roofs and parapets, and you said you agreed to that from the beginning. I'm not sure when the beginning was.
I'll clarify that.
There's a lot of distraction in here. I got people throwing tantrums and papers being crumbled and wow. Okay.
Mayor Weber.
I know the hour's late.
So I think the question is, where does that agreement appear? Either in the record or someplace where we could find it?
Mayor Weber, Councillor Romero Worth, that was a condition that we agreed to early on in the early neighbor notification phase or design phase of the project. We had committed to agree to an 18-foot height at that point. So it's in their early neighbor notification records. We talked about it in the planning commission hearings, and we don't have a problem putting a note on the plat. And the language will be to staff's satisfaction.
If I may,
And I feel like it's in the plat. I read it somewhere.
the letter that was referenced, which is part of your record that Mr. Throne referenced of August 2nd, 2022 to the Planning Commission, that letter on page 3 specifically states height. As part of the ENN process, the applicant agreed to a single-story construction up to 18 feet. For clarification purposes, 18 feet includes any part of the building such as parapets and pitched roofs. And then it showed up on the final plat draft, but it doesn't have the parapets or pitched roof. And I think that's where it showed up.
Okay, so we could add parapets and pitched roofs and that would be okay with you. All right, sorry, that took way more time than I wanted. I'm not sure who this is for. Maybe it's for Mr. Esquivel. I'm curious about what constitutes a final plat. There seems to be great concern that if it's not on these big drawings, it's not there. I mean, we have it's basically a final plat is not only these drawings, but conditions of approval and what else?
Mayor, Councilor Romero Worth. I guess that's a good question.
Thanks.
What is a final plat?
Phew, glad you approve.
Didn't mean it that way. The package that we look at for final plat is a collection of maps and drawings that make up all of the requirements collectively or what a subdivision has to be reviewed and approved by. It is in my, well, I don't think in my 17 years, even in my stint with the county, even when I was consulting and submitting subdivisions, I don't think I've ever seen a perfect application for development, subdivision, or master plan. It's always a series of back and forth, back and forth, back and forth. If we were to require every single application, development plan, subdivision, whatever, to be absolutely perfect before it hit the planning commission, there are still going to be conditions that are going to have to be met outside of that approval, because they can only be met outside of the approval. And every application, instead of what typically takes 3, 6, 8 months now, could take a year and a half to get out of our office, only because of the time requirements for every application to be processed. As I remember talking to you when you were early on, Mayor, our development process has 2 components. The city is developer driven. We don't build anything. But the codes, our chapter 14, all of our updates, those are neighborhood driven. And the council usually adopts conditions, ordinance changes based on those meetings with neighborhoods and when they come here. So for anybody to say it's not a final plat because it doesn't have all of these elements, that's why we use conditions of approval, so that we can get past the bureaucracy part of it and get to the finalization of conditions in order to record, so that the ultimate goal is to get them to the building permit. So if you think of the application as a rough ashlar and the city staff as the masons, we force that ashlar into a form of a brick for the builder's use. And we work with them as best as we can. Sometimes we disagree, and the city manager, I'm sure, will be able to attest that I get a lot of complaints. But we do our best to get it to that point so that we can get it to a final state for recordation. But the final approval is the plat as it stood, and any additions to it. Like in this case, they made changes to the road. They widened the main road and put parking there because the fire department at the last minute said, I need a 20-foot. So
Need to be turn the trucks around. I'm gonna stop you because I don't have a whole bunch of time. But Councilor Cassett pointed out these conditions of approval. Property development is required to comply with applicable provisions of Chapter 14, and it's required to comply with all the ordinances of the city, those conditions 1 and 2. I mean, you couldn't possibly put all of that on this diagram, could you?
Mayor, council.
That's part of the reason why it's not just this, it's this, and then the conditions of approval, the technical changes, other documents that fly with this.
That's right. So they do comply when you add the conditions. They would not comply if the conditions weren't present.
Okay. I think there are a couple of things that are very important to this neighborhood, which is in my district. One is height, one is open space, as we've heard, and one is lighting. And I think, so in the time I have left, the lighting issue, so the lighting was added by our engineer, wasn't on the preliminary plat. It was added sometime before the final plat. We could tonight take it off of the plat, but that doesn't change the fact that and I guess the question is, and it may be for Dee, what requires that lighting in this neighborhood? And then Councilor Cassett's questions about Soli Lomas and there being covenants, and that's why there's no lighting there, and that's a very old neighborhood. And if this can't come under those covenants and that neighborhood, I'm curious, what creates the requirement for the lighting? And even if we take it off the plat, I think there's still the requirement, but is there another process where the neighbors could seek a variance not to have the lighting if that's what this neighborhood does not like lighting. So what are their options?
Mayor, Council, I think that's a better question for our subdivision engineer than me.
Okay, Dee, are you still on?
Yes, I am.
Can you tell, what requires the lighting that you've recommended in the final plat?
So the city code states that in 14-9.1 that basically all developments must construct, and then it lists streets, curbs, whatever, all those, and street lighting, consistent with the standards in this article in chapter 25, which is the street, sidewalks, and public places. So streetlights are required to be a part of developments.
And is it possible, given the nature of this neighborhood that doesn't have them, to seek a variance or to change that requirement in any way? Or is that a question for the city attorney's office?
Yeah, that might be a question for, I mean, as an engineer, I would say for safety reasons, they should be there.
Right, and you're saying for safety and because our code requires them, you put them in.
Right.
And I'm saying because they weren't in the preliminary plat and now they're in the final plat, I think, have the power to take them off the final plat, but I don't think it doesn't mean that there won't be streetlights, but I guess I'm curious, I don't know, does the city attorney's office have a thought about, is there another way the neighborhood could seek a variance, given that this area doesn't like lighting, doesn't want lighting, doesn't seem to need lighting like other parts of the city?
Thank you, Mr. Mayor, Councilor Mara Worth. And please correct me if I'm wrong, but I believe you would have to be an applicant would have to be a property owner or have some kind of agency to apply for a variance. So another person, you wouldn't have the same appeal rights as, as you do to file an appeal, where you might, there might be different standards. So
could the applicant apply and say they don't want streetlights, or could a lot owner apply and say they don't want a streetlight on their block?
They would have to look at the individual circumstances, but yes, an applicant could apply, or yes, a property owner would usually be an applicant. Like they could usually apply for a variance.
And I would think it might be easier to get that variance if the final plat didn't say there are streetlights, even though I don't think it really matters in terms of what the code says. I mean, the code, whether the streetlights are on the final plat or not, doesn't have any bearing on whether streetlights are required. They're required outside of the final plat.
Right. So the streetlights are required by the code, as
Right.
determined by the city engineer. So it would be, I mean, it would be an application for a variance from the code requirement. So I guess it would depend on the individual application, but that an application for a deviation from the code would usually be an application for a variance. So yes, that would probably fit the bill.
Okay, and I'm sure my 10 minutes is up, so thank you.
We'll come back around.
I'll wait.
Yep. I'm going to take fewer than 10 minutes, but I'm going to come back to Mr. Escabel because I think at the risk of violating my own redundancy rule, I'm going to ask a similar question, but in a slightly different way. Why aren't all the notes on the plat if it's a final plat?
Mayor, Council, there are two reasons. One, the conditions of approval provide a timestamp as to when they can be complied with. And two, when the appeal was filed, I stopped reviewing and completing that process.
So ordinarily at this point, if there were no appeal, according to the process you've used, the notes would be on the plat, and depending on the outcome of this hearing, they will presumably, if the appeal is denied, the notes will appear on the plat by date certain?
Mayor, Council, it's not a date certain. a lot depends on the applicant. They have to draft everything on all of the sheets relevant to all of the DRT comments that are required. So if any DRT says you have to make these changes because this is what this condition alludes to, then they have to modify all those sheets in order to address that particular condition. So it's a long process to get to that final recording, because any condition can modify the plat itself, and that's going to take time for whoever that draft person is to modify all of those sheets
So the date certain is prior to
recording.
recordation. I think we've also had the suggestion that something about this process is not the way that standard business is done. I'm curious to know, is this somehow a different way of doing business when it comes to preliminary and final plats, when it comes to the city's land use department and the other members of the review team?
Mayor, council, that has been a very long going debate. Mayor Delgado put me on the Building Permit and Development Review Task Force years ago. And now we're going through a code update, and we're revisiting how do we streamline the code? How do we make it easier on the applicant? How do we make it more complete for the neighborhoods? Everybody's coming together to try and meet that same end. I don't know how the end result's going to be. There are so many rules and regulations that apply to any one given application that the process dictates its own requirement. And then Jason will then implement policy or review process so that we can effectively enforce all of those ordinances for any given application. And unfortunately, that can lead to a very, very long review process, not by just me, but when I have to send it out to every other department because we don't have in-house staff to do it ourselves. It can take a very long time because not only do they have to look at my projects, but they'll have to look at other senior planner projects, and they still have their work on top of that they still have to do. So it does take a long time.
Again, I'm going to ask you almost a planning philosophy question. What is a complete submittal when it comes to the plat debate?
Mayor, council, that's actually a good question. A complete submittal is one that when I look at that application, I have enough information to send to all of the departments for them to review something. If there's nothing for them to review and I require them to review it as part of my initial analysis of the project, then for me, that's an incomplete application. From there, once they build the application to meet all of the DRT areas of review, that is complete enough for me to ship out for them to continue that review process, which will ultimately build on top of that.
Thank you. I want to raise a question that was brought up by one of the folks who addressed the governing body. How do residents know what will or won't be on the plat, given what we have in front of us tonight?
How will residents know what will and won't be on the plat? Mayor, council, if those residents get a copy of the report, get a copy of the application, looking at them as we do together will identify what that final plat may look like. I mean, notes are going to be placed all over the place depending on which sheet they're going on, but all of those conditions of approval have to be built into that. And if they go to the public hearing, if any conditions are added at that public hearing, they'll know that as well. That would be the only way, because until it gets to the post-development process, it still kind of is a jumbled mess.
I'm going to stop there and see if my colleagues have another round they want to take. And we'll each have, again, the limit of 10 minutes if we can adhere to that, please.
Most definitely. And I just had another quick question in terms of what we could do in terms of conditions. Would it please the appellant for there to be a clear carve out for driveways and retention ponds aside from that 50% open space?
Mr. Throne, the counselor was asking, is that question clear to you?
I think it is. And I think the answer to that is the reason why we brought out, we understand that until someone comes in for a building permit, okay, and they submit the plans and they look at, well, let's see, what's the lot coverage? What's it going to do? How much open space? You're not trying to tie somebody into where their driveway is going to be. The point I was trying to make was that at the level of what they submitted, that document with the green in it, which is the building open space, that was relied on by the staff to say, okay, this shows that they can comply with the open space. That was the point. But we're not here to say, you have to have you have to have an enforceable location for a driveway. I mean, that would be absurd. What we're just saying is, no, but you got to show that you can meet these requirements if you're going to go exceed the 40% lot coverage. Does that answer your question?
So it was a little bit more just trying to find common ground and thinking of what we could do under conditions. So if you look at the site plan, it says lot buildable area, a minimum of 50% of the lot shall be open space. If we include it, excluding driveways and retention ponds, would that suffice?
We're not trying to change the code. So I think in our view, the proper way to state this would be to make it clear that the requirements for open space include the open space standards in section 14-7 in the code, which says what can be included and what can't. Because at the end of the day, I mean, let's say this development gets built out in 2 years. Sell the lots. Somebody buys a lot, they come in, okay. First of all, when they buy the lot, they want to know, okay, I want to build X square feet, their plans are going to be their plans. And I want to have this, maybe they want to have a storage shed, whatever they want to do. You want to tell those, first of all, those people need to know before they buy the property that they'll be able to do what they want to do. Otherwise, they're going to be coming in for a variance, and you're going to have variances all over the place. But on the flip side, on the enforcement side, is you have this. They come in, and as Mr. Escobel testified, they come in with their plans, and they go, "This is what we want to do." Now, none of us are going to be there. We're not going to get notice of when that happens. We're going to be relying on staff to enforce the code. That needs to be clear, and the best way to make that clear, we're not suggesting that every single provision in Chapter 14 has to be on the plat. We're just saying refer to those sections in the code that apply here.
So you would prefer, I apologize, that we refer to the Section 14 code in particular on the plat under that 50% requirement.
Right. And what we said in our appeal petition was that it should refer to not only the 50% requirement on each lot that's in the South Central Highway Corridor Protection District overlay section of the code, but also the private residential open space standards. And that's where we have a difference of opinion about the interpretation, because we believe the code says that the overlay standards are in addition to, and we cited the code provisions in detail in our. But again, we're not we're not trying to negotiate some provisions that aren't in the code. We're just trying to make sure that the code is applied.
I understand that. Thank you so much. I appreciate that. And just to clarify, I'm suggesting that we just clarify that part of the notes.
Thank you, Counselor. Counselor Garcia.
I guess just more of a process question. Just to clarify why we're here tonight is because there's an appeal. Am I understanding that correct? This, otherwise the planning commission would approve it and we'd be done with the process. I guess, Mr. Esquivel.
Mayor, Councilor Garcia, can you repeat your question, please?
So typically, in a process such as this, and for the final plat approval, it's approved by the planning commission and then it gets recorded. But because it's coming before the governing body because there's an appeal to the final approval.
In a simplified way, yes, that's true.
Okay, so, and the reason I'm asking is because I'm reading the next steps through what the code says. You know, if the final plat is approved by the planning commission, the approval shall be recorded on the face of the original drawing of the final plat. Can you explain more to me what that process is? That the approval shall be recorded on the face of the original drawing of the final plat.
Mayor, Councilor Garcia, if you look at the examples that he gave you and you go to, I believe it's sheet 2, which is the cover page of the survey, you'll notice that there are a signature block for the planner manager. There's a signature block for the subdivision engineer, and there should be a signature block for the chair and secretary of the planning commission. There's also a line that identifies the case for that particular project or that subdivision. So that is the approval of that subdivision that identifies not just the subdivision the city approved, but where to go for what happened throughout that process.
Okay, thank you for clarifying that. And Councilor Castro, because my copy is there, and I don't recall the planning commission chair's signature being on this page. So in my opinion, it's not a final plat based off of the way it's read here in the code, that it began to get recorded with signatures. And so I guess my question is why hasn't the planning commission chair signed off on this yet?
Mayor, Councilor Garcia, because there was an appeal filed and we stopped the processing of the application to move it forward.
Okay, so I guess this gets me back to my question in regards to our process, because I'm a bit perplexed that we only have 3 options in front of us. You know, why couldn't one of the options be send it back to the planning, one of the options be send it back to the planning commission chair for the appropriate signatures? That, in my opinion, would show that they've done their due diligence, that all of these conditions are going to be implemented on the final plat. And I think that maybe would alleviate some concerns. So I guess maybe city attorney's office can help me understand, why is it that we only have these 3 options? Why isn't it sending it back to the planning commission, in this instance, the planning commission chair, or their signatures on the final, what would be considered a final plat based off of the way that the code reads?
Mayor Weber, Councilor Garcia, I think that goes back to this being a de novo hearing. The code does require that it be a de novo hearing, and that's both under the appeal procedures and under the description of the role of the governing body. And so tonight the governing body is taking new evidence. And so rather than sending this back to the planning commission for more steps, basically the governing body is taking that authority back from the planning commission. The governing body is standing in the planning commission's shoes at this point.
But I would think that we also have the authority to hand the authority back to them to, am I humble opinion, it would help to clarify and clean up the process versus we grant the appeal or we deny the appeal or we add more conditions. I'm trying to find a constructive solution towards a middle ground in regards to sending it back to the planning commission, make some appropriate changes that I think folks would like to see. And should somebody else want to appeal it, I mean, and I, from my understanding of the way the code reads as well, is that Mr. Throne and the other applicants couldn't appeal, but somebody else could appeal and say, we don't agree with that, the way it's moved forward, and we can address it again in that manner. So am I understand, I'm just, I guess I'm at a loss in regards to the system and the structure doesn't allow us to send it back to the planning commission in general. I mean, it's the way I'm interpreting what you said is we have to deal with it. And I think there's alternative routes besides us making one of these three decisions. And, you know, as I've mentioned, send it back to the planning commission for reconsideration, send it back to the planning commission for the signatures on the page as outlined in the code. I mean, I think there's other options. So I guess the overarching question is why only three options are presented to us when, I think there could be many more.
Thank you, Mayor Weber, Councilor Garcia. Respectfully, I think the only way I could answer that question would be to speculate about the way that the code is, the way that it is. And I do not have the answer to that question. Madam City Attorney, I don't know if you might have
Mayor Weber, Councilor Garcia, and Assistant City Attorney Rebecca Herman. I agree. So I think it goes to why are your rules the way they are? If you want to change them and not make it a de novo appeal, where the governing body is now in control, then you could look at revising your rules. So we can't speculate as to why this resolution was adopted in 2011. There's nothing saying you couldn't have a different procedure, but this is the procedure you have.
Okay.
Can I ask a clarifying question that I
Sure.
think might help, just so I understand? If I understand the process correctly, if we were to deny the appeal, it would move forward with the process, and in moving forward with that process, the planning commission chair and secretary would sign because it would continue to move forward with the normal process. So so at this point, nobody signs anymore? Okay.
Wait. I think what we're all trying to get clear on is, if I understand Councilor Garcia's question, it goes to the earlier question about what is a final plat. And what you said to us previously, Mr. Escabel, was there's more work to be done. Once that work is done, then the signatures would be affixed to the final document, but that you suspended that work that would have gone forward if there had been no appeal. So we're in this area where the appeal led you to stop working on completing the final completion. If this appeal were not to succeed, you would complete the work, and at that point, the signatures would go on to the document as required.
Mayor Council, that is correct.
So it goes, Councilor Garcia, I think I understand your point, but I think it goes back to the signature once the actual rest of the process has been completed, to get all of the notes applied, to get all of the timestamps in order, then the signatures would go on.
And if I can add, I think if we make changes tonight, those are also things that would go on and be reflected.
Correct.
And that the planning commission chair and the secretary would sign. Well, I don't know.
I think that's correct, but
Okay.
we're veering off into discussion before we get done with questions. So I think our hearts are in the right place. We're trying to clarify it, but I'd like to try to march through the process if we could.
Sure. And I got one more question, and I guess this is, I don't know how to figure out who to respond it to, because it's definitely an open-ended question in regards to anybody that's testified, and maybe I'll put it to Mr. Throne. Sorry to interrupt you, but we heard the city attorney's response in regards to, we've got three options in front of us. From your perspective, given you've been working on this case for quite some time now, do you see anything outside of the three options provided to us?
Yes, Mayor and Councilor Garcia. First of all, the basis for my response now is my understanding of what a de novo hearing is, as the city attorney's staff report has said, and also what's in the city code. A de novo, and this is in the staff report where they describe what a de novo hearing. What a de novo hearing refers to the standard of review. And as stated in that January 26th report, as Ms. Mnuck provided to you, it means you don't necessarily have to defer to the decision of the Planning Commission. And you're entitled to look at not only the evidence that came before the Planning Commission, but any evidence that has properly come in since then. Which, by the way, includes, it wasn't an email regarding that August thing. That was actually a letter to the commission that was sent in. That's in the record, Exhibit H to our petition. But so I would respectfully disagree with, and I know they put, this was in the report, the decision tree. These are your options. There's nothing in the code that we've ever seen that limits the governing body's options on this. And you know, one of the requirements in the staff report that's listed is there's supposed to be a recitation of what is the relief requested by the appellants. That's on page 45. It's the last appeal petition we set out. Here's what we were requesting for relief. And we requested that it be sent back to correct all the problems. And so, again, I respectfully disagree, but I'm not disagreeing just because I don't like her interpretation. I'm disagreeing because there's nothing in the city code that limits your power to do that. That's a remedy. And you have oversight through the appeal process to correct anything that you want, because ultimately, if you look in the code, you'll see what it says in terms, and this is the appeal section, is you as a governing body has delegated your authority to approve subdivision plats to the Planning Commission, subject to the right of appeal. In other words, it's giving you the right, your oversight right. And so anything that's brought to you, you can say can be corrected. And now, it appears to us that the way it gets corrected, I mean, you can make changes yourself, but you can also send it back to the Planning Commission, because then they're the ones that you've delegated your authority for final plat approval. And that's the final decision. I mean, at the end of the day, if anybody wants to appeal the city's approval of a final subdivision plat, okay, it has to be a final action of the city, and it doesn't become final until it goes through your processes. I hope that's clear and answers your question.
It does. I mean, it definitely helps me to understand my role as a governing body member. And as we started out this process, I did have some concerns around the three, but we'll get to debate later. No other questions, Mr. Mayor.
Thank you, Counselor. We're up against it on the 10 minutes. Counselor Lindell? Good. Counselor Lee Garcia?
Thank you, Mayor. I do want to touch back again on in regards to the timestamp or the time frame of trying to get these final records, final plat completed and sent off to the county for for recordation. And so typically, how long does that take once is approved by the planning commission? Granted, there's no appeals, granted, everything goes proper, and everything is recorded, whether it's in the notes, the conditions of approval, everything is on there and it's complete. How long typically does that take?
It's hard to say. There are some applicants who work really fast and they can get me changes within weeks. And there are some that take months. It just depends on when they can meet those conditions of approval. When we do try and redline those plats so that we can tell them ahead of time what we want, where we want them, and how we want them, so that it becomes recordable. And then it's up to them to make those changes, and however many changes they have will take as long as it takes.
So what I'm hearing is that during this process, staff, and it goes through the review process again from all the departments, that all the conditions are being approved, they're recorded on the plat. And then that's sent off to the county for recordation, is that correct?
Say that again.
So once all of the conditions that were requested or that were approved by the planning commission are gone through by staff and all the notes are put on the plat, then it goes off to the county for recordation, being recorded. Signatures are
Pretty
there,
close.
I mean. the
All
planning
all signatures are, yeah, we set it up for recordation.
And is there any times that the, and I think you answered this earlier in your testimony, but are there times when the county may send it back to the city for issues that they have seen?
No, we've pretty much worked out our deals with, I wouldn't say deals, our differences with the county clerk, so that we know what they're looking for, why they're looking for it, so that we can arrange the plat so it's recordable. So we make the plat ready so that the county clerk can just simply record it. There have been times where mistakes are made and we put something on the plat and they say, well, where's all this information? And we have to make changes, but we've ironed it out to the point now it is sort of routine, so that once we get the plat ready through all our red line changes, it is recordable.
Okay, and I guess,
I should add that some developments, because at the county clerk, the treasurer's office has to sign on that plat because it's a subdivision. And that typically means that the developer, unless they have arrangements with the county treasurer's office, they have to pay all of the taxes for the current year before they'll sign it and before the county clerk will record it.
I think that's the rest of the questions I had. Thank you very much.
Thank you, Counselor. Counselor Cassidy?
I think I just have deliberation. No more questions. Thank you.
Counselor Merriworth?
Thank you for the reference on Exhibit H, found that. So I want to go back to process. So this is a de novo appeal, which does tell us that we can, well, rather than me, why don't I defer to you? Tell me what a de novo appeal is.
So a de novo appeal, the code doesn't provide a definition of de novo appeal, but de novo means a new hearing. So it's, you're hearing evidence again, you're looking at the record again, you're looking at it with fresh eyes, you're standing in the position that the planning commission essentially was in when it made this decision and making a new decision.
Right. And so we are now in a position to, we delegated our authority down to the planning commission. Now we're basically, because of this appeal, taking our authority back, and we can now make changes based on this new hearing and what we're learning, and maybe some mistakes or issues that have come up, which caused this to be appealed to us.
That's correct, Mayor Weber, Councilor Merriworth, that is correct.
Okay. And I guess, all right. So I don't know that we need to send it back to the planning commission because we have the authority right here to fix what we need to fix. And I think we started, and I think Counselor Lee Garcia started us down by asking what kinds of things could we put in here? And I asked some of those questions too. So, I mean, we could take the lighting requirement out. We could clarify the height. And I don't know, maybe I need to go back to Mr. Throne. Open
space?
open space, I don't know, did we talk about that? I guess what would you do about open space? Well, it's, the problem is there's a difference about whether both the overlay applies and the private piece applies. And so, I mean, we could address that as well, I guess.
Thank you, Mayor Weber, Councilor Merriworth. Yes, so I think that the governing body tonight could make the decision that the provisions of section 14-7.5 apply as well. You can make a decision about how to apply the law to the facts. And so if the governing body were to decide that that section was also appropriate, one modification could potentially be adding a condition saying to comply with that section of the code. The applicant would have to comply with the code anyway, regardless. The code applies regardless of whether the note is on the plat, but that is something that the governing body would be empowered to add to the plat if that was the governing body's legal determination tonight.
Yeah, so there are things we want to add and there's things we want to take off, which is kind of ironic. Mr. Summer, I mean, applying that extra open space provision, what does that mean to you all?
Mr. Mayor, Counselor, thank you for asking. There's no disagreement really between the parties or staff about what it means. Everybody agrees that the corridor open space applies, and that means that 50% of the lot has to be that kind of open space. Everybody agrees that if you're 40% lot coverage or less, you don't have to have private open space. If you trigger that by going over the 40%, you must comply. And we also agree that if you must comply with that private open space, you can't stick your drainage pond in that private open space. So the thing that Councilor Castro was concerned about is in the code. And the fix that you just talked about works perfectly because there is no disagreement. You could reference that Chapter 14 shall be complied with, including without limitation, both of those open space requirements. And if they trigger them, they trigger them. If they don't, they don't. There's no disagreement. There is no disagreement about that. There's also no disagreement about the fix with respect to placing a note about not putting fences in. It's practically stated right there. I mean, it's going to get on the plat anyway, but you could say that note, as that stated, could be on the plat. With respect to the height requirements, adding the language that's in that letter, not a problem. Those are all fixes you could do right here and find, as a matter of fact, that there is substantial conformance with these more specific conditions. They're not different. There's no disagreement about that. So that's what we believe is fundamentally correct and can be accomplished. And it covers the point that Councilor Castro said, would this work? And the answer should have been, yeah, that would work. If you would reference the statute, that would be great because then they could fly. Sorry.
Well, and also in that Exhibit H in the letter from Ms. Montoya, you all address the walls and fences piece and agree to it. So
Exactly.
yeah,
There was a disagreement with staff, but we said, we're not going to fight about it. We'll put that note on the plat. Just
right. And right now it's in the conditions, which it still means you have to comply with it. But if it makes everybody feel better, we could put it on the plat.
And the note is supposed to go on the plat as part of the conditions. So yes, we're saying we agree with it. It's in the conditions and it must be on the plat.
So we could emphasize that, I guess,
Yes.
by
You could put an exclamation.
we could underscore, bold, an exclamation mark. All right. Let's see. Too much paper around here. Now I've lost track. Okay, and then just going back to the code that Mr. Ives cited for us, it does talk about this original drawing or original, I can't remember what the words are. I could look it up, but that'll take time. You all know what exactly, and I think somebody sort of alluded to this.
Yeah, the term original
Yeah.
drawing doesn't mean the document that got put in the application.
Okay,
It means the document that is the Mylar, on the Mylar that gets recorded. That original Mylar must have that information on it. This idea that original refers to something that's not the final
Okay.
thing that gets signed.
so like when I go and I record an original will,
You know, you've got the original will.
the original is the one that's signed and that's the original,
That is it precisely. And
Okay.
that's the term has been used.
not the first one that got drawn and then has been crumbled up and marked all over.
Right, and the original drawing, if that was the case, that it referred to the document that was in the packet at that planning commission hearing, staff could not send back red lines. And part of their big job is to make sure that that final plat complies with the requirements of the code, and they're redlined. I mean, Dan will tell you that almost every department sends back red lines that show up on that plat. We would never get done because you'd never have an original. That's just an absurd reading of the code.
Okay. Oh, my time's up. Thank you.
Thank you. I'm going to point out that it's 12:20 and we all agreed last week that it's disrespectful to the public to make these decisions at 2 a.m. And I think it's still disrespectful to the public to make these decisions at 2 a.m. And we haven't finished our process. So if there are any concluding questions by anybody, now would be the time to do it before we go to the last part of the process, after which we close the public hearing. I'm going to ask any other questions. All right, thank you. In that case, our process now offers an opportunity to the city attorney or the planning staff to respond to appellants or applicants' evidence and testimony if you wish to do so. And I would suggest fewer minutes is better, but
Thank you, Mayor Weber, members of City Council. I think that a lot of the things that I had on my list to address, we've already covered, so I'm going to be very brief. One of the issues that had been raised earlier was about whether actions of staff could be under review at this hearing, actions of staff or city employees. And I guess I did want to clarify that, of course, statements, actions, anything by staff is completely appropriate review for the governing body. And also, you're hearing live testimony tonight, so of course you may weigh the credibility of that testimony and decide how much weight you want to give any testimony that you heard tonight. And so that is appropriate for your review. However, the only decision under review, as I think we've already established, is the Planning Commission's decision. Only the Planning Commission in this instance has the authority to render a final decision. That was the only final decision. So that is the only decision that is under review tonight. One other note I wanted to bring up was there was a question raised at the last meeting about why the planning case was so late, or why the land use case was so late. And I did want to note that we do have a governing body procedural rule that was adopted on January 12th of 2022 that provides the order of business. I'm just noting that for the record that public hearings are held almost very, very last according to that procedure. So that was not necessarily something that was specific to this case. That was something that was a part of our procedures. Let's see. And I also wanted to note that There is some case law on the issue of whether a preliminary plat is a final decision. Our New Mexico Supreme Court of Appeals considered that issue in Zuni Indian Tribe versus McKinley County Board of County Commissioners. In that case, they did determine that a preliminary plat is a final decision, even if there may be some issues of law that are outstanding after that preliminary plat is issued. So the preliminary plat that was approved with all of those conditions, including the timeline. And so that preliminary plat that decision by the Planning Commission to approve the final plat would be a final decision under that analysis. So I think that's enough for me, so I'll turn it over to the next speaker.
Thank you. According to our process, we now go to closing arguments. And we begin with the appellants and an opportunity to make a closing argument. I would suggest 10 minutes would be an appropriate time for both you and the applicant to make a closing statement.
Thank you, Mayor. I think just from what I've heard, we've come a long way after hearing Mr. Summers' acknowledgements of what he thinks been agreed to. I'm pleased to hear that. I do want to point out one more timing thing, just so you'll be aware of it, and that is that under the city's appellate procedures, it refers to also appeals of final actions to the district court, and you have 30 days to do it from a final decision. The final decision in this case would be by this body. And I just want to point out that if you have 30 days to appeal a final decision, but you don't have final plat to address, and that issue is going to go up to the district court, and you can just see the problem it causes. So I just want you to be mindful of that, that's why we think things have to be corrected at the city level before, so there's a final action that one can decide whether or not, it needs to be appealed within that time frame. As we pointed out in our appeal petition, and I personally participated in 2000 when the Worst family, before they passed away and the property passed into a trust, they went to the Planning Commission. They tried to get a higher density development. And they actually, they came in with an R3 planned unit development proposal, but they had to get a variance on the open space requirement. And for that reason, the Planning Commission recommended against approval. And that's addressed in our exhibits in the petition. And before that matter could go up to the city council, the Worst withdrew the application. The notes from one of the staff public participation meetings, Mr. Worst confirmed that. There are factual reasons why this property has not been developed since then, since 2000. They have nothing to do with the appellants. It all has to do with the physical characteristics of this property. One is the fact that it's located directly adjacent to the Old Pecos Trail within the South Central Highway Corridor Protection District. And also it's located within the Old Pecos Trail Scenic Corridor as designated in the general plan. So that was a problem. And the plan was adopted in 1999. Then you have the problem with the topography. You've got the fact that the lot split by the Arroyo, which is not only a flood zone, but it's a wildlife corridor, which prevents building a roadway across that would have destroyed that. And then on top of it, you have a terrain that is such, because of drainage, it requires these stormwater ponds. So there were all sorts of problems with it. You had to also, to do a higher density development, they had to get a sewer extension that came across the Arroyo, and you heard some evidence about that. You know, as I said before, in answer to Councilor Garcia's question, I really do think you have more options, and we don't take any pleasure in not only being here in such a late hour, but challenging the city on these issues. We're just here because we feel that it's necessary to get this done right, so that if the court's determine that the city's zoning decision last January 21st is valid, then all the things that are required by the city code are complied with. That's what we want to see. And we're particularly concerned with these open space requirements, not because it's in our backyard, it's because it's a community asset. And the visual openness is something that's specifically recognized as a special asset for the community to be protected in that overlay district. You know, once the record closes in this case, there's no procedure in the city code that allows the appellants, or for that matter, any other affected members of the community, an opportunity to review the applicant's final plat before the city records it. And all this is going to be done according to the land use department, outside the record and beyond anybody's ability to review. And so unless it's determined by this body to get it done right now, there's just no way to deal with the problem. It gets recorded. Once it's recorded, it's not like anybody can come in and challenge a recorded plat. So, you know, we do think this is the time to get all these things corrected. You know, I think the record is undisputed that there are certain things that the applicant committed to. There are certain things that are required for compliance with the code. I was happy to hear Mr. Summer agree that the applicant doesn't have any problem with making sure that the section, the open space, the private residential open space standards in the code are specifically put on the plat. I think that's appropriate, in addition to the 50% requirement in the overlay district. And so, you know, we think make it clear so that if it turns out that the applicant does, or anybody does try to do any of the subsequent lot owners come in and they want lot coverage that's more than 40%, it's real clear what happens. And so there's no, down the line, people in the community won't look at this and go, what the heck happened here? How did this happen? And we've kind of seen that in some other projects, I think. And so this is the time, we think, to clear that up. Again, on this issue of the preliminary plat, was that a final action of the commission? The city code says that can be appealed. No question, we know that can be appealed. Problem here is, as I mentioned earlier, is because the open space requirements on the record were clearly kicked into the final plat approval process, which we thought was inappropriate, but we weren't allowed to even address that. That was after our public comment period was over. That was just a decision that was made. There was nothing, we could not appeal that because there wasn't anything to appeal. You can't appeal an action that hasn't yet been taken. All that matter, the record is clear. All that matter, including that document, the buildable area, open space document that we talked about, that wasn't even presented until April of last year as part of the application to support final plat approval. And so that's why we've addressed, it was the first time we had an opportunity to address it. That's why we did it then. So we don't think there is any kind of waiver argument about that. And we do think you have the ability to clear up all of these issues. I'm glad, I was gratified to hear the Assistant City Attorney reversed her position in paragraph 1 of their January 26th report and point out that, yes, because this is a otherwise valid appeal, the opinions, actions, and decisions by city employees who provided advice and recommendations to the commission are in fact subject to review by you in this body. And we point that out because we had a lot of procedural problems here, and, you know, it can be corrected. I mean, that's the good news. Good news is you can correct them. And we hope you will. We realize the hour is late, but we really hope that you will take a close look at the basis for our appeal and these matters. And by the way, you know, there was a matter, there was some, one of the things that the staff report was supposed to identify as the basis for our appeal, that really wasn't done in the staff report. I mean, we tried to be very clear about what the different issues were, and all I can say is that there were some misrepresentations. I think in the slideshow, there was a slide number 5 about access to sidewalks. That was never a basis for our appeal. We don't know how that even got in there. I think, you know, just sum up, I think in the final analysis, you know, we think that the issue is this. We understand that this body depends on advice from its land use division staff and its city attorney. And, you know, it's not that easy to question that. And so we've had to do a lot of work digging into the code and explaining to you why we believe a lot of that wasn't correct. I think the issue now is, you know, does the city, I mean, circle the wagons and defend its staff and just kind of roll the dice and you know, prove this, or, you know, do you take a serious look at this and go, yeah, we can correct this, we should correct it, and we really should have a process in place, not just in this case, because we think this case is even, you know, will have ramifications in the future. An opportunity to not only be more transparent in the process earlier in the game, but also to make sure that the Planning Commission really does its job. And that is to look at these plats, insist on these notes so they can look at them and say, wait a second, this is not clear. This should be corrected, and do that at that stage. If they do it at that stage, it doesn't come up to you. You don't have to spend all the time you've had to spend. And that's the good news is, you know, if it's done right at that, and we also think, you know, I know people, you know, the city attorney has said, well, we have no right to cross-examine, you know, at the Planning Commission stage, only at the appeal stage. But think about that. The city is represented like in the district court proceeding now on this rezoning, that the Planning Commission is the principal fact-finding time. I mean, that's the purpose of cross-examination, to ask the challenging questions and to bring out information for you, because with everything you have on your plates, we know it's very hard for you to read everything that's in the record and to form those questions. So we've done our best. I know I took a lot of time asking those, but I hope you found it at least helpful to in your deliberations, and we appreciate the time you've taken, and respectfully ask that you grant our appeal and correct all of the deficiencies that we've identified in our verified appeal. Thank you very much.
Thank you. Mr. Summer, you have the same opportunity and the same time limit if possible.
Mr. Mayor, members of the council, I will be very, very brief. What should be a normally exhaustive review of things has become an exhausting review of things. We start out with one simple question here. Does the final plat substantially? And Mr. Escobar, who's been doing this for quite some time, checked off all the things. Well, you all get to determine what substantial conformance is. Number of lot, I mean, what we're talking about here is that the Planning Commission was accused of getting everything wrong. Staff was accused of getting everything wrong. The applicant got it all wrong. That's not what happened here. What happened was neither the staff nor the planning commission nor the applicant would arrange the world to make them happy. That's what the problem is. You have been discussing now very small tweaks that will solve the problems that have been identified. I submit to you that that by its own definition says this plat substantially conforms to the preliminary. When I first got up here, I said there are 3 documents. We could just compare them and say, is that right? And Dan basically acknowledged that. So I would submit to you that this appeal is not about the merits of what's going on. Most of the 45 pages deals with, I didn't get my emails responded to. I didn't have enough time to respond to before the hearing, but it's the same time everybody else has. 45 pages of grievance have nothing to do with the issue in front of you. I submit to you the Planning Commission got it right, and they should not be required to rearrange their process, their staff, their code, their everything to make that interpretation the law. That's what you're being asked to do. I submit to you the Planning Commission got it right, staff got it right, and the applicant got it right with its proposal. We submit that you should uphold the Planning Commission approval and tweak it the way that we've talked about here with the height, adding those 2 words, the fencing, putting that on, making sure that's on the plat, the open space reference to the 2 provisions of the code. Is there anything else? Really not. So we submit to you, we've done we've upheld, we've provided enough information for you to uphold the Planning Commission. And I would just like to end with one thing. And it's hard to watch staff who devoted in this particular case, I mean, countless hours in a review process to address every complaint, respond to everything, to be told that they were in a petition, that they had some bias. I can tell you, Dan is not an easy man to work with. He is not an easy man to work with. And he doesn't make it easy on us, and he doesn't make it easy on anybody. That's not his job. But he does a good job. Maggie, Jason, all of them, they work their rear ends off for you. To be accused of things that they've been accused of in this case is unwarranted, unkind, not necessary. Has nothing to do with the case. We submit to you, you should uphold and tweak the Planning Commission.
Very good. Thank you, sir. At this time, I will close the public hearing. I remind my colleagues that should anyone wish to reopen the hearing in order to, the public hearing part, in order to ask further questions, that is permitted under our rules, but closing it now means that we'd have to make a motion to reopen it if we wanted to ask more questions. And now is the time set aside for discussion and deliberations before we move to a motion of any kind and then a vote. So I will follow the same process we've done in the past, which is just to offer 10 minutes of, up to 10 minutes of time. Looking at the clock, it's now 1:45. So Councilor Lee Garcia, you have the floor, sir.
Thank you, Mr. Mayor. Just want to thank everybody for, the testimony, for being here, for allowing us to really go through this again and giving us the opportunity to hear you out. And I think that is in itself what we should be providing as elected officials, as city administration. And so I kind of understanding what the 3 options that we have in regards to upholding, approving the appeal, denying the appeal, or making our own determination in regards to what we feel we heard here tonight and previous testimony in regards to maybe tweaking it a little bit. And I think that from my perspective and what I've heard is that satisfying the appellant's requests in regards to certain conditions of approval that they would like to see on there recorded. And I think that that's the direction that I'm headed towards. And the reason that I'm headed that way is because I want to have faith in the process of how this all came through. Countless hours have been spent on this, from the ENN meetings to coming to the planning commission for their initial, they have to hear the zoning changes, and even though on the record, I voted against this at the beginning, but I'm hearing another whole set of, we're at a different stage now. And I think that the information that has been presented warrants the fact that a lot of work has been done on this, and there's been very many compromises that have gone through this whole process. I think that I'm gonna leave it at that, because I think I want to let other counselors chime in on what their feelings are. And would be happy to support some of the amendments going forward under the conditions of approval. Thank you.
Thank you, Counselor. Counselor Cassett?
Thank you so much, Mr. Mayor. I also do want to thank everybody for being here for this process. I think this has been a really wonderful kind of, especially with the code update. I've really just appreciated all these challenges that have come to the forefront, because we really are at an opportunity to discuss process. This is not where we change process, but we are in a place where we are changing process. So all of these different experiences are extremely helpful, as well as this has been a great learning experience for me. So I do appreciate that. I agree with Counselor Garcia that in terms of looking at making some of the changes to the conditions of approval, I think is a good compromise. I do want to talk a little bit about this process of the final plat. And first of all, I think that is important, the component that the Planning Commission Chair and Secretary do sign. So there is that final check of, were the, conditions of approval, were the things that the Planning Commission stated actually incorporated. When we are looking at city processes, there is always this really important balance. And one of the things that I've heard so much about land use is that we do have a lot of process. And so finding the different ways that we can make sure that we are both balancing the importance of community involvement as well as efficiency, to me, is extremely important. I think the idea that every time there is a small change on the plat, that it would have to go back to Planning Commission would be horrendous. The amount of time that I have seen staff spend, the fact that land use is completely understaffed to begin with, the amount of time that planning commissioners would have to spend, the number of cases that they have, as was mentioned by the appellant, the frustration that this took so long. It would take longer if every time there was a change. It does go back to that question of what is considered a substantial change versus not. We do not have that defined. Again, we do have an opportunity right now in the code update. So has really raised some really good points of conversation. And I think that it also does come down to one very important question, which is, do we trust our staff to do their job? And I do. Because if they don't do their job, they shouldn't be our staff. And I do need to, I do want to take some time to defend our staff. They will make mistakes. They will miss emails. They will misspeak. We all do it. We are human. It does not mean that they are incompetent. It does not mean that they are hiding something. It does not mean that they are trying to manipulate the situation. They have a lot coming at them. They work extremely hard
These are not easy jobs. These are not easy issues. No issue at the city is simple, and land use especially is wonderfully complicated. That does not mean that our process is perfect. We know in many instances that it is not. We do have opportunities to change it, but I did want to make sure to acknowledge our staff and how hard they work. And that they truly are, you know, really dedicated professionals. So every one of you that's sitting back, as well as who is on our Zoom, it does not mean they're perfect. But that's I think a really crucial piece. And so when we get back to this process and we get back to this idea of, will the things that have been stated in our hearings wind up on the plat? That's our staff's job. That is their job to do so. We do have some checks and balances put in there with the signature block. That's a very important job, Planning Commission Chair and Planning Commission Secretary. They do have a lot of responsibility on them. So, you know, that is very important for us to consider as we are doing appointments. So I will stop there with just the acknowledgement that opportunities to continue to improve the process are important. We are really at a really crucial turning point with that. And I definitely acknowledge that in this scenario and in others that there have been frustrations. And I think that hearing those are extremely important. But I do think that there are some part of these processes that we did get right, considering the various aspects that we do have to consider when we are looking at that. So I will stop there. Thank you, Mayor.
Thank you, Counselor. Counselor Merrill.
Thank you, Mayor. And like the two before me, thank you all for sitting with us tonight. Thank you for all of those of you who participated. Thank you to our staff for hanging in there. I would agree with Counselor Cassett. I know how hard you all work, and I know you are all professionals in each of your own roles and really value the work that you do for the city. And I just want to thank you for that. I would agree that there isn't a process in the city that couldn't be made better, and we can work to do that. I do think tonight we can cure some of the things that are objectionable in this plat with a motion to modify. And again, the way I would look at that is, you know, let's put the walls and fences prohibition on the plat. Let's be clear that there are two provisions in the code regarding open space that would apply to this subdivision. Let's be clear that the parapets and the pitched roofs are included in the 18-foot height limitation. And I also think that we should take off the lighting requirements. I know that lighting in this neighborhood is not welcomed, not needed. And you know, I don't think that's the end of the conversation for the neighborhood, but I do think it's an acknowledgement by this body that that's a value that is important to this neighborhood, and I would like to see it affirmed. So with that, Mayor, it's the hour's late. I'll pass it on down the line.
Very good. Thank you. Counselor Castro, do you want to take the opportunity to make some remarks?
Sure. Again, thank you everyone for being here. I really appreciate all of the comments and all of the thought and the many years of work that you've put into this. Mr. Esquivel, thank you for your comments and keeping the process open and accessible. I think that idea is something that we want to make very clear, that we are looking at processes and that we are interested in having community input. I do have a little bit of disagreement just because I am somebody that wants to be able to use the city at all times, that we need a little bit more light. And there's been times that I don't feel particularly safe in the dark, but that's just a personal opinion. And again, thank you so very much.
Thank you, Counselor. Counselor Garcia.
Thank you, Mr. Mayor. Good morning, everybody. I guess first person to tell you all that. As well, just thank you, everybody, for participating in this long and grueling process. These things, I think, we learn through each one of these processes, and we'll learn not only how we can be better, but make things more efficient for everybody, not only the governing body, not only for staff, but I think more importantly for the public. I think I agree that there definitely needs to be some changes made in regards to the proposal in front of us. But I disagree that we are the body to address it. That's what the Planning Commission is for. They're the body to take these recommendations and ensure that they are fully implemented to the T. Because we can spend all morning here figuring out what how we want to modify and change this. And I think providing the proper body, which is the Planning Commission, the ability to make sure that we get it right, and that way there's no further appeals, is the best process and course of action, in my opinion. These issues that come to us, I think that, there are many instances where there were breakdowns in the process. I think over tonight's hearing and the previous hearing, we were able to establish where that happened and where we can make things better. Now, I think that's where we give the baton back to the Planning Commission with our recommendations and ensure that they carry out the work. Because if we set the precedent that the governing body is just going to sit there and clean up the messes, we can be here on a constant basis. And I'm not saying that the Planning Commission is going to do that, but I think that's ultimately what that body is formed for, because they have the expertise to ensure that our processes, laws, ordinances, codes, etc., are fully followed. And especially with a complicated case such as this one, it is going to require the due diligence and expertise of our Planning Commission team and the land use staff that works to support them. So it's my opinion that we deliberate what changes we want to see, and we send it back to the Planning Commission to ensure that those changes are incorporated, implemented, and a final plat is meets the needs of everybody. Thank you, Mr. Mayor.
Counselor, thank you. And Counselor Lindell, you have the floor.
Thank you, Mayor. Thanks everyone for being here. It's almost 1 o'clock in the morning. Staff, you've put in a 16-hour day and you haven't started your cars yet. You aren't on your way home. Yeah, there's 12, 15 people from staff that had a long day with this. And I appreciate the work, appreciate the testimony. I think that the staff does their job in a really fair and equitable manner. Everyone in the room that works for the city, I have deep respect for the work you do. And I'd like to get through this and get it moved on and put this, hopefully the neighborhood can be accepting of it and also move on. So that's what I have, Mayor.
Thank you, Counselor. I don't have a lot to add. I think the tone and the time speak for themselves. People are tired, and also I think in deep agreement with Mr. Throne that none of this is designed to be all that much fun. We do what we do the best we can with the best spirit that we can muster, and we try to arrive at a decision that serves the public's interest to the best of our ability. And I do think that the time it takes also does boil down some of the emotions in a way that I think is constructive. I think there's a general consensus that you alluded to, Mr. Throne, that Mr. Summer had said some things that were good news for you, that there was more accommodation or recognition, and the parties were in many ways not as far apart as maybe we thought at the beginning of this process. I think we have to try to be the decision-making body that we are charged by ordinance to be. I don't think we can try to find a way to evade that responsibility, and certainly not after all the time and the work and the effort that has gone on, not only in the room here, but in private time, going through all the material and studying this documentation and listening to and watching the video. I think this governing body is the right group to make the decision, because that's our job. Doesn't mean it's easy. Doesn't mean that we're not going to make some people unhappy or make some people feel that they were not well served. I can tell you that we've given a lot of credit to our staff. I want to give a lot of credit to our governing body members. This is really hard work, folks. We are asked to be in a quasi-judicial role rather than a legislative role. That's true, but it doesn't change the fact that for most of us, we are deeply embedded in the community, and we want to be part of the community, and we want to serve the community. And we're confronted with cases where there are disagreements, and we have to try to do our best not to please everybody or even to make compromises that we believe will stand, but that we believe fit the code, fit the facts, and serve the public. And I think that is the ultimate job that we're tasked with. I think the hearing has been really productive, constructive, and I think I also believe that if we could arrive at a solution that would lead to a resolution that everybody would feel meets the community's needs, that would be a terrific outcome. We already have one case around this piece of property in the courts. I don't know whether this decision will end up there or not. I would hope we would not continue to litigate, but the process provides for that as well. And what will be in that regard is what will be. But I do want to salute the effort, the work, and the seriousness of purpose with which this case has been considered, not only with this matter, but with previous parts of it. This governing body has served a lot of public interest simply by the efforts put into trying to resolve differences and fit the facts to the code, and that's ultimately our job. So with that, I would entertain a motion.
Mayor?
Councilor Merriworth.
I move to modify the commission's approval of final subdivision plat by asking that the walls and fences section that's prohibited, I believe those are in the conditions of approval, be moved to the final plat itself, be reflected on the final plat itself. That also on the final plat itself, that the open space requirements be listed, that the subdivision has to comply with both provisions. The 50% that the overlay requires, and then I'm gonna get the second one. How do we characterize the second one?
The private open spaces.
Right, open space provision is also listed on the plat as being a requirement. In addition, there's already on the plat, the restriction on height for 18 feet, but that we add that parapets and pitched roofs are included in that height restriction. And then the provision that requires lighting that is listed on the plat, I would like to take off. And then my motion continues by approving the final subdivision plat as modified and directing staff to prepare findings of fact and conclusions of law consistent with this motion.
Second.
There's a motion and there's a second. We have the opportunity for discussion as well.
Do have a
Yes,
point of
Counselor Cox.
information. So although we aren't putting the lighting on there, it is still in the code. And so folks would still need to get approval to not have lighting, correct?
Yeah, I don't think it gets rid of that requirement. It just isn't on the plat. But I don't know what I think that's kind of going to be the next question is if you really don't want lighting, I don't know what the avenues are, but
Is that the,
It does.
you have further questions? Because you have the floor.
No, thank
good.
you. I see the floor. Thank you.
Other comments on the motion before us? Seeing no hands, we have a motion and we have a second. Would the clerk please call the roll?
Certainly, Mr. Mayor. Counselor Castro. Counselor Lee Garcia.
Yes.
Counselor Michael Garcia.
No.
Counselor Lindell. Counselor Romero Worth.
yes.
Counselor Cassett.
Yes.
Mayor Weber.
Yes,
Motion pass.
thank you.
Mr. Mayor, may I ask for one clarification on the record? I understand the motion. The second provision about open space has if it applies, if you trigger it by your development application. I just wanted to make that clear that that's the way I understood it. And I don't want there to be a fight about, hey, every permit has to have private open space. If you don't trigger it, you don't have to comply. Is that?
Counselor Mayorworth, do you want to respond? It's a little unusual to have this dialogue right now.
I'm sorry about that.
Right. So my understanding is that the applicant doesn't think they're going to trigger the 40%, but if anybody did, they would be required to meet it. That's the way I understood it.
Thank you, everybody, again. Appreciate your time and your effort and your patience, and this meeting is adjourned.